Thank you, everyone, for joining us today. I am Sarah Hammer, Executive Director at the Wharton School and Professor at the University of Pennsylvania Law School. And I'm very pleased to see everyone today, colleagues, old and new. Look forward to some fantastic discussions. I have the honor and pleasure of co-chairing the International Expert Consortium on Artificial Intelligence with my friend and colleague, Professor Philip Hacker, who will also be with us today to co-convene our discussions. The International Expert Consortium on Artificial Intelligence, which is the organizer of today's workshop, is a global consortium of leading experts, both academic and from industry, focused on the regulation, the economics, and the computer science or engineering of artificial intelligence. We provide a platform to facilitate cross-disciplinary inquiries on key questions and challenges related to artificial intelligence. Our experts from around the world come from leading universities, leading AI institutes or nonprofit organizations, and we have a number of esteemed observers from industry as well. I'm very pleased that many of the members of our consortium will join us today and look forward to continued discussions. In fact, this is the second year in a row that our group has convened here at AI for Good. Last year, we convened as well formally as the Expert Consortium RECSAI did not exist yet. I'd like to thank the Dieter Schwarz Foundation for its generous support of the International Expert Consortium on AI. And I'd also like to thank the International Telecommunications Union for hosting us and for generously collaborating with us here at AI for Good and beyond. I've had the pleasure and honor of sitting on the IMAC, or the Oversight Committee for the ITU, for 5 years. And it's been a great honor to be able to work with the many colleagues of this organization to support AI for Good. I'm pleased to introduce our first speaker today.
Oh, okay. All right. That's okay. So this has two aspects. The first one is to be able to gain a better understanding and better transparency as to how the model operates. And the other aspect is to be able to do more clear attribution, for example, for copyright issues and copyright attribution and so forth. So that's one example. Here is another example that I find interesting that we look at is something called representation engineering. And the idea here is to view this idea of explainability and transparency more as the idea of trying to characterize and describe the representation that was learned by the model. This is inspired by what is done typically and very commonly in neuroscience. And the idea is to probe the system by giving it input, specifically constructed input, to record the activations in the system, so activations at different layers of a transformer, and to then analyze the distribution of those activations and trying to draw conclusions as to how the representation is built internally. So this is a simple example here where one tries to understand how the system reacts to the concept of honesty or dishonesty. And the idea is to input prompts that are constructed around those concepts, collect the activation data from the system transformer, for example, and analyze the distribution of those outputs. Those are actual output. This is an example here trying to understand the behavior of the system as it relates to different sentiment concepts: sadness, anger, fear, etc. And what you see at the bottom here, each color corresponds to a different sentiment. And the clusters that you see here are actual activation vectors in the system that are being clustered according to those different sentiments. So this is just a very quick example to show how one can, by probing the system, one can gain an understanding as to the representation that has been modeled by the system. So this is just a glimpse into some of the work that can be done to try to have a better understanding of systems and better understanding of their construction. Okay, so those are a few examples that I wanted to talk about in terms of technical aspects of understanding AI system. I'd like to thank my colleague at CMU, in particular in the responsible AI area, and in particular my colleague Oda Edari, who contributed to those slides. Thank you.
Thank you so much, Dean Hebert.
Yes.
Okay, we can take a few minutes for questions. I also want to let everyone know that we're pleased to have a hybrid audience today. So there are folks watching our live stream as well. Are there any questions from the room? In that case, Dean Hebert, thank you so much for such an informative presentation. I look forward to speaking with you more about it. I'm pleased to welcome our next speaker, Professor Jeremias Adams-Prassel. Thank you so much for joining us, Jeremias. Professor Adams-Prassel is also a member of our consortium RECSAI on artificial intelligence. His research focuses on technology, innovation policy, and the future of work in the European Union and beyond. He is a fellow of Magdalen College and read law at Oxford, Paris, and Harvard Law School. He's held visiting, teaching, and/or research positions at many esteemed universities, including Hong Kong University, the Max Planck Institute Hamburg, Renmin Law School Beijing, University College London, University of Vienna, and Yale Law School. He has published several books and articles in the area of AI and the future of work, including his book, Humans as a Service, published by Oxford University Press in 2018. Professor Prassel, thank you so much for joining us today. We look forward to your presentation.
Thank you very much indeed. And thank you, Sarah, and also thank you to Philip for having me. It's really good to be back. I'm afraid from all the exciting technical stuff, I'm now going to take you to the very boring world of law. But the boring world of law is something we have to think about, because increasingly what we've been seeing is this response by various regulators, particularly in the European Union, to try and catch up with the technological developments. Now, one of the issues with legal regulation is this huge path dependency. So as we're moving very fast, one of the real challenges is getting it right from the get-go. So the stakes are quite high. And that's why I think we need to think quite carefully about the broader approaches we're taking to regulating emerging technologies. Now, as with so much that's going on here, this is not necessarily a novel challenge the law faces. The lawyers in the room will be familiar with debates about what we call regulating the law of the horse. This goes back to a famous conference in the 1990s where a bunch of cyber lawyers met in Chicago. And about a day into the conference, a fairly famous judge, law and economics guy, Professor Easterbrook, turns up and tells the assembled colleagues that they're wasting their time. He says, you're studying cyber law, well, you might as well study the law of the horse. Horses injure people. Horses get sold through contract. Why don't we just use existing norms when it comes to regulating cyber law? There's a big counter movement to that. Lawrence Lessig in 1999 writes a famous piece saying, actually, the law of the horse is different from cyber law. Says, actually, cyber law can teach us new things about how we think about regulation, how we think about responding to quickly emerging technologies. And that's really the core of what we're grappling with here, right? And that is to recognize the limits of the law in regulating, in responding to very fast-moving technologies, but at the same time, also to think about how we can escape those limits, or how we can reshape and rethink that kind of response. So against that background, the real question I want to think about today is different competing ways of responding from a regulatory perspective to the kind of challenges we've already seen in the previous presentation and we're hearing much more about in the course of today. Before I go into new regulation, just a very small, very short asterisk that I think is important to make. And that is to say, it doesn't really matter which kind of area of law we're looking at here. I'm going to use one particular case study, which is my area of interest, and that's the impact of AI on work. And when I think about the impact of AI on work, I'm not necessarily thinking about workers losing their jobs to robots. I'm actually interested in what happens when bosses lose their jobs. In different words, when traditional management functions, from hiring workers to managing them, all the way through to firing them, are increasingly being automated or augmented by increasingly sophisticated technologies. Think of it as algorithmic management as the broad kind of label we're working on. This is something that started very much in the gig economy. Platforms like Uber, Foodora, etc. were pioneers in this field. But today, it's really coming to workplaces across the socioeconomic spectrum. No longer matters whether you work in an Amazon warehouse or in a professional services firm, even in a university as old-fashioned and crusty as Oxford. These kind of technologies are increasingly deployed right across the socioeconomic spectrum. Now, one thing to say before we get into regulatory debates is that just because the technology is new, we don't necessarily need to throw out all of our existing established rules. There's a temptation to think that we need to completely reinvent the wheel when it comes to tackling AI, generative AI in particular. And I think that's a trap we have to avoid. There are existing sets of norms, whether it's, for example, in discrimination law, whether it's, for example, in data protection law, that can actually be successfully deployed in this context. But that's not what I want to talk about today. What I really want to talk about today is the new kind of norms we start to see emerge, particularly at the European level. And here then is the core conundrum we're facing at this level. How are we going to regulate AI, whether generative AI or various other AI systems more generally? And we're seeing a big fork in the road. And that fork is a choice between omnibus regulatory regimes and between sectoral regulatory regimes. What I mean by that specifically is omnibus regimes where we try to regulate the technology as such. We're trying to regulate AI. We're trying to regulate foundation models. That's the approach we see in the AI Act. I'll go into a bit. By sectoral regulation, I mean thinking about what particular impacts will emerging technology have in the field of healthcare, in the field of work, in the field of consumer finance, etc. And I want to give you two brief case studies of very recently enacted European legislation of both omnibus and sectoral regulation, and then try and draw some first conclusions. And again, it'd be really interesting to hear your takes as well afterwards to see what you think might be the way forward. Let's look at some examples specifically. Again, this tension that we've always had is as old as European law itself. Very brief, again, quite dry and technical EU constitutional law point. The EU, when it wants to act and make new laws, actually needs to show that it's got the competence to do so. The EU treaties are essentially a long list where the member states have given powers to the union to regulate certain things. And again, there's always been a tension between specific competences, such as Article 16, which says you can regulate anything to do with personal data. And broader articles, like 114 of the treaty, which says you can regulate anything that has to do with creating the internal market. And so again, that tension between an omnibus approach, anything to do with the internal market, and a sectoral approach, you can regulate data specifically, has been baked into the treaties right from the beginning. In practice, we've seen this debate already in the very genesis of data protection rules in the EU. The GDPR, as its name suggests, the general data protection regulation is an omnibus instrument. It regulates the processing of data in any kind of context that falls in its scope. Today, that sounds uncontroversial, but actually, when you look back to the legislative history, there was about a decade of fighting and debates in the Council, in the Commission, trying to work out whether we should have general data protection rules or whether we should go down the route of saying, let's have general rules perhaps as a framework, but then specific implementation in work, in finance, in consumer protection, etc. And so what we see then is that even though the general data protection regulation claims to be an omnibus instrument, you have snuck in right in the back, the sort of really tedious bits that barely anyone reads. You have all these little opening spaces for more specific regulation. So for example, going back to my work context, Article 88 suddenly says within the omnibus frameworks, member states can actually create rules specifically for data protection at work. Now, from the legislative perspective, that might sound like a lovely compromise. In practice, it creates a huge mess. In practice, what ends up happening is within the general framework, you end up having different member states going down different regulatory routes. And suddenly this idea of having the internal market, where I've got one set of standards to which I can build products, is completely fragmented by different countries doing different things. One of my postdocs, Halle from Abra, has done really interesting work on this, going through what's happening in different member states. And ultimately, what Halle from concludes is that, sure, it's a pragmatic compromise to say, we'll have this general regime, and then we'll put in these little opening clauses. But in practice, actually, that compromise comes at a very high cost when it comes to the practical implementation and the encouraging of innovation and technology in the Union. The problem with that is that it didn't stop the legislator going down the route of omnibus regulation. And the clearest illustration of that we see in the Artificial Intelligence Act, which has very recently finally passed through the various legislative stages. Now, again, employment is specifically recognized as one of the so-called high-risk contexts to which the AI Act applies. So we again see already, yes, there is an overarching regime. We're going to try define AI very broadly. We're going to try and regulate AI as a technology. Then already you start seeing that tension sneaking back in by having this Annex 3, this list of different high-risk contexts: employment, public services, health, consumer finance, etc., the kind of areas you would expect. Then, whilst the AI Act is sort of working its way through the legislative process, suddenly people start hearing about generative AI. And so on top of this entire risk-based system, which you might sort of think of as a pyramid, for example, comes, to make everything completely messy, a separate set or an additional set of rules for general AI and even more specifically for foundation models. I think of it as a sort of weird donut hovering over the pyramid. If somebody can come up with a better image, please let me know. But it really just does not make sense. Sorry, I should be more polite than that. But really what's going on here is that we have text-specific identification saying, okay, here's our definition of generative AI, here's our definition of foundation models, and then you have layers of obligations specifically attached to those foundation models. Now, again, the goals of this are laudable. The goals are exactly what we've been talking about, right? Fairness, accuracy, transparency. I have absolutely no problem with that. The issue is that by trying to do it in an omnibus way, we're potentially trying to chase technology rather than think about what the actual underlying regulatory goals are and how we can go achieving them. And so that's why, at best, I think the assessment, the most positive assessment of what's come out of the AI Act is that it's going to create a lot of regulatory sort of paperwork and red tape, but its impact in terms of protecting individuals, protecting citizens, and also its impact in terms of creating an internal market and creating an innovation environment in Europe is going to be fairly limited. That's both because of the inherent design choices in the AI Act, because what the AI Act essentially does is use product liability, the sort of regimes that have been developed for chainsaws and lifts and medical implants, and tries to use that sort of reified approach to regulating AI, which has all sorts of problems in and of itself. But also fundamentally, it's never been designed to protect individuals, to protect rights, particularly fundamental rights within the Union. So those are the real challenges we see with this omnibus approach, and a real difficulty, I think, with the AI Act as an example of AI regulation going forward. The second example I promised I'd give you would be about sectoral regulation. And here I want to go back again to the work context, because another instrument that was very recently passed was the so-called Platform Work Directive. And the Platform Work Directive is the first specific instrument that actually regulates the deployment of AI systems specifically in the context of work. It's more limited than that in its scope. It's very specifically limited essentially to gig economy. It's limited to the Ubers and Fedoras of this world. But it's nonetheless, I think, a really interesting blueprint for the kind of context-specific regulation of AI we are starting to see emerge. So what the Platform Work Directive does in Chapter 3, there are other bits that are not relevant for our purposes today, but essentially it sets down a clear set of rules for various forms of algorithmic management, the kind of tools, the kind of devices platforms use in their interaction with workers. And what we see here is for the first time a very specific approach to identifying particular problems and challenges in the work context and then trying to tackle them. So Article 7 of the Platform Work Directive, for example, sets out a series of red lines, a series of clear bans, things you're simply not allowed to do. So, for example, one, shall we say, at least questionable deployment of AI technologies has been to try to identify workers who might want to join a trade union or workers who might be about to become pregnant in order then to terminate them before they cause, quotation mark, trouble. That is software that actually exists, that's actually being advertised, and that's out there already. This is not some dystopian vision. That software exists. That software is being deployed widely. Now, under the Platform Work Directive, there's a specific ban on using AI systems to predict the exercise of fundamental rights. So we've got a specific work context problem, and then we've got a very clear response to that saying you're simply not allowed to do that anymore. We also have more broader mechanisms for consultation, for example, thinking specifically about how in the workplace we can do things like we talked about co-design earlier, and we can think about how we can use worker representatives, for example, to be involved in those kind of co-design procedures. And so what you see is whether it comes to information and consultation rights, whether it comes to the involvement of worker representatives, essentially a legal regime that says we've identified a series of specific dangers, a series of specific regulatory gaps, and here is a context-specific response to that. Okay, final bit. Let's think about the promise and the perils of those different ways of doing AI regulation. You might have got a sense already which way I'm leaning, but I'll try to keep an open mind and give you the bonus and the malus on both ways. Let's start with the promises of omnibus regulation. Well, there is definitely some advantage to thinking about regulating AI overall, having one clear set of rules independent of context. First of all, it's about consistency. It's about having a level playing field and saying it doesn't really matter in which context you want to deploy your system, whether you want to build a cool new app for consumer finance or for work, there's going to be a level playing field. There is going to be consistency. And again, when you think about the fact that foundation models are increasingly being used, similar or same models are being used in lots of different contexts, that consistency definitely has some value. There's definitely something positive to think about there. It's also really important in what union legislators try to call market making, right? Which in non-EU constitutional terms essentially means let's try to create one internal market that is attractive for investors, that is attractive for innovators. But again, having one clear set of rules you can play to makes it much easier. And it makes it much easier, particularly for the smaller kind of startups that Europe wants to encourage. Because you can throw whatever regulatory regimes you want at very large tech firms. They'll be able to comply with whatever you come up with. The real challenge are the much smaller startups where the more complicated compliance get, the more there'll be strong disincentives to actually try and work, sell into, or innovate within the European Union. So again, in terms of market making, in terms of encouraging innovation, having clarity, having one set of rules, and then saying, fine, once you've complied with those, you don't need to worry about anything else. Definitely clear advantages there. Finally, though, there's also questions as to the limits at which we want to harmonize. Once more, I'll spare you the sort of technical EU law constitutional geekery, but essentially there's a question when it comes to having 27 different countries, to what extent we want to harmonize the rules. And one of the challenges that we've always seen within the EU, and that's really sort of intellectually, I think, quite unresolved, is do we harmonize as a floor? Do we say here's a set of minimum standards, and then individual countries can have higher standards of protection if they want? Or do we harmonize as a ceiling, where we say that actually whatever rules the union lays down, once you've complied with those, individual countries can no longer get involved in any further regulation. And again, that's a tension we see that's inherent in the AI Act in various forms. So those are the advantages of omnibus regulation, but there's also the drawbacks I've already mentioned. When it comes to sectoral regulation, on the other hand, I think we see more significant advantages. First of all, it's this context specificity, right? And when we start thinking, and again, one piece of work I've done with my team of both computer scientists and lawyers over the last couple of years is trying to map what the regulatory gaps are, right? This goes back to this point that just because the technology is new, we need lots of new rules. Instead, we need to think about what are the specific gaps that are triggered by the emerging technology. And those specific gaps, those specific concerns, actually might be very different in terms of different contexts. Even when you think about basic issues like questions of, do we want to encourage, in a worst case scenario, type 1 or type 2 errors? In a hiring context, you might have a very different that question than you might have in a medical treatment context. So recognizing that context and therefore saying, actually, we might have different rules. We might want models to evolve in different ways, in different contexts, I think is really important. So whether it's waiting for errors, whether it's thinking about differential impacts that errors in systems can have, I think context specificity is something we mustn't overlook. The second thing is that we need new regulation to integrate with existing regulatory regimes. Again, put yourself in the position of somebody who's trying to set up a new startup, tries to comply with various rules. If you've got lots of new sort of general rules that clash with existing rules in a particular sector, you're going to find yourself in a really difficult position. Again, if you're a large corporate, no problem. You'll have a legal team. They'll work it out. You can litigate. If you're a small startup, you're going to really struggle meeting different regulatory obligations. And so when we look at specific sectors, actually, they have, of course, evolved various ways of dealing with the kind of challenges we think about. In consumer law, lots of different countries have various ombudsman systems, for example. In employment law, different countries have regimes, whether it's unions, whether it's works councils, whether it's other ways of representing worker voice. And so I think context specificity would allow us to, as it were, graft new rules, existing procedures, again, whether it's in finance, whether it's in healthcare, or whether it's in the world of work. And the new rules could then slot in much more neatly into and also learn from the existing regulatory structures we've seen. Finally, and again, this is a point that'd be really interesting to hear take off, I think one of the advantages of sectoral regulation is that it potentially opens the door to tech neutrality. To say, well, actually, at the end of the day, it doesn't really matter specifically how a harm has instantiated. What we care about in regulation is avoiding the harm. We don't want discrimination in recruitment, whether that is a traditionally racist HR manager or a biased machine learning system, ultimately doesn't necessarily matter as much as the harm that we see instantiated to a candidate who, because of a protected characteristic, suddenly has a much lower chance of getting a particular job. So this focus on harms, I think, allows us to sidestep this question of, is this a foundation model? Is this generative AI? What kind of machine learning system is this? Is it just an old-fashioned algorithm, like a lot of benefit system, where somebody has sat down and programmed in that women over a certain age shouldn't be given more job training? That's what happened in Austria in their social security system, right? It wouldn't matter anymore precisely what kind of technology underpins the system. We'd be thinking much more about the harms. I think the advantage is that would let us sidestep questions like explainability, like transparency. But I think we also have to think about what the cost of that might be. And again, I think an interesting question where I'd be interested to hear your responses is, what would be the issues if we focus on the harms rather than the mechanisms that are behind that? Now, we will hear later from various colleagues from the European Union, and when you put this challenge to the European legislator, they say, well, Jeremiah, you're trying to draw the stark distinction here between these regulatory modes. Why don't we just do both? Why don't we just integrate them, right? We'll have this nice set of horizontal norms, and then in addition to that, we'll have sectoral things slotting neatly into that. Well, that's very attractive in principle. And if we sit there in the abstract, I'd say, great idea. Let's have a set of basic norms that apply, and then we'll find a way of working out how it actually works. We'll particularize them, whether in union legislation or whether actually leaving it to the member states to then implement the norm in different contexts. However, sadly, and this is where the legal geekery comes back into, whilst this is a lovely idea in practice, it's fiendishly difficult to achieve in reality. The problem you end up very quickly is that you end up with conflicting norms, you end up with conflicting standards, and you have operators in industry who are suddenly faced with different rules that could potentially even contradict each other. Even with recent instruments like the AI Act, you can already potentially point to problems where what's in the AI Act contradicts obligations that are in the GDPR. Very basic illustration, GDPR, key principle, data minimization, right? Thou shalt not have lots of data around. Key principle of the AI Act, thou shalt have lots of data around. Thou shalt document everything and keep it all around for at least a decade. Again, faced with this challenge, do I minimize data or do I collect everything and keep everything? You can see that this idea of having an overall regime and then particularizing it very quickly leads to very complicated challenges. That's a practical challenge, of course, for those who want to do it, but it's also actually a really interesting constitutional challenge. Because whilst most legal systems evolve rules constitutionally for what we do when we have clashing rules, EU law never has actually gone to that extent. There are some basic rules saying, yes, of course, the treaties are more important than secondary legislation. But when you've got two norms at the same level, AI Act, a regulation, clashing with the GDPR, a regulation, actually there is very little law in practice that tells us what I should do when I'm forced with those competing obligations. That's a practical problem from our market-making innovation problem. But when you think about it, it's also quite a deep constitutional rule of law problem. I want to comply with the law. I want to conduct my life in line with the law. Yet there's two rules at the same level that tell me completely contradictory things. How do I go about it? And so that's why I think that this idea that, yes, in principle, it's very nice to have this integration between the horizontal and the vertical, but in practice, there's a lot of difficulties to watch out for. So to summarize, I think we are at a real fork in the road. Going forward, when we think about regulation, when we think about how legislators at the European, at the international level can respond to the challenges of quickly emerging technologies, how are we going to do it in an omnibus way, in a law of the horse kind of way, where we regulate AI or foundation models or whatever else it is? Or do we go down a world in which we say, well, here are the challenges we can identify in the world of work. Here are the challenges we can identify in the world of healthcare, consumer finance, whatever it might be. And we're going to identify gaps and regulate specifically in line with that. That's the challenge. I think we should go down the sectoral approach, but I'd be really interested to hear from you what you make of that. Thank you very much indeed.
Thank you so much, Jeremias, for that very excellent presentation. I'd like to welcome questions from the audience. Reggie.
Question for you. The sectoral approach and the omnibus approach both have their downsides. And so what I hear you advocating for is we just take sectoral. It sounds like what you're effectively advocating for is sectoral, and let's just accept all the downsides associated with that. It's my view that, as you pointed out, both approaches have their merits. And I think who you center matters. I think from an omnibus perspective, generally that's the provenance of governments focused on society, right? We're wanting to center things like human rights. And I think there's certainly merit in maintaining some standardization there, particularly for folks who have been marginalized. And then the sectoral approach, certainly from a contextual perspective, absolutely matters. As a person in industry, I care about that a terrible amount. I honestly don't see a way that you do one without the other in a satisfactory manner. And so I'm just curious to get some evolution of thought around how leaning into one approach versus the other absolutely satisfies all the positive of the choice that you don't choose, if that makes sense.
Thank you so much. And it's really interesting because that's a regulatory question that goes right back really to the inception of human rights, right? So when you look back to here in Geneva 70 years ago, one of the core questions was about this universality of human rights. And what are the kind of rights which we want to be universal? And where do we want to say, actually, no, we need much more specific regulation in particular context? And that's why actually historically you see this really interesting split between the sort of legal and political rights, which are universal, and the more sort of applied socioeconomic rights, which then don't have the same kind of universality given to them through historical choices. So I think the one way of squaring the circle would be to say, let's actually think about having, as it were, a baseline of standards that does apply. And this goes back then to, again, saying this doesn't need to be text-specific regulation, right? Human rights law applies, right? Tort law applies. Whether you get run over by a drunk driver or a self-driving car, tort law ultimately applies. And so I think, again, sort of not forgetting the fact that there's a general regulatory background, and then also having the context-specific way might be a way of going about this. But I think your point about saying who we center matters is really important. And I think that's the difference we see between the Omnibus regime and the AI Act, where what's centered is very much the technology and the developers and producers of the technology, as opposed to the Platform Work Directive, where what we center is, you know, the workers, the data subjects.
So where you land there, it's universal. So you're not arguing against the notion of an omnibus, but just that the omnibus probably should sit at the level of tort as it goes to the technical specification.
Exactly. I think that might be a way of doing that at the moment. And again, it then might help us with that sort of tech neutrality as well, right? Rather than trying to chase what's in the news today.
Thank you so much. Additional questions? Professor Fink?
Thank you for your great talk. So I'm quite interested in how the AI Act affects member state competences. And I think the probably most significant effect of the AI Act is one that we don't talk about so much. So the fact that it precludes member states from adopting further legislation on artificial intelligence. So I'd be curious about your take on this in the employment context, right? Because if you're saying, oh, well, essentially we're already using AI in, you know, hiring, workers management, but also firing, then potentially all of labor legislation is ultimately also AI legislation, meaning that member states potentially can't adopt further norms. So yeah, I'd be curious to just generally hear your thoughts, and maybe also whether you think that the council was actually aware of the fact that this is what they were voting for in the legislative process.
Thank you. And you're putting your finger right on a really, really important point there. So in some work I've done jointly with Michael Veal at UCL, we actually argue that the AI Act is a really good illustration on how not to regulate technology. And one of the case studies we use there is competence. So this goes back to this point that the union, unlike countries, can't actually just do what it wants. It needs to point to a particular article to have that competence. Now, two things about competence. First of all, the regulation of employment law using the AI Act is actually illegal, because Article 114, which is the legal basis that's being used for the AI Act, if you read as far as paragraph 2 of Article 114, explicitly says, thou shalt not use Article 114 to regulate the rights and interests of working persons. So the very fact that it's being deployed in the employment context actually is just constitutionally completely illegal. And I think the Court of Justice, if somebody were to challenge it, would strike it down. The more interesting question is that as to member state regulatory capacity. And again, for those who aren't EU constitutional law geeks, one of the sort of long-standing challenges has been, what powers does the union have and what space does that leave for individual countries? This goes back to this minimum harmonization versus maximum harmonization point. Now, one of the real problems in the AI Act is the use of this product regime that goes back to what's called the new legislative framework from the 1970s. And the new legislative framework is a maximum harmonization framework. So essentially, you'll all know the little CE mark, right, that you see on various products, face masks, your phones, etc. Once somebody complies with the standards to get the CE mark, it's maximum harmonization. Member states are not allowed to put any further rules on that product. However, and that's a big catch here, that maximum harmonization is limited to the product itself. So when you think about the face mask, for example, a member state can't say, oh, the loops need to be longer or shorter, right? It can't change the product standard. It does not maximize what we call use rules. So member states can still say, we'll have a law about wearing face mask in this particular context or in that particular context. The problem with the AI Act is that it goes beyond just the product standard maximum harmonization, and it strays dangerously into the territory of maximum harmonization of use. And what that will mean, exactly as you pointed out, Michelle, that certain domestic rules, for example, on labor law, for example, on environmental law, could be seen as an obstacle and therefore illegal under EU law. So that would be the real problem with maximum harmonization, that any kind of rules on sustainability surrounding training of models, rules surrounding, workers having a voice in the introduction of new technology could be in the crosshairs of EU law. We have raised that point during the legislative process. There have been some amendments to try and tackle that maximum harmonization problem when it comes to use, but I'm still quite weary because you look at some of the recitals of the Act, that might actually still be a real challenge. And certainly you could see operators trying to use that, exploit that. I mean, if the AI Act were used to get rid of German co-determination, I think you'd have the ladies and gentlemen in Karlsruhe, the German Constitutional Court. I think they'd have some strong feelings about that particular issue, to say, put it mildly. But it is definitely a technical challenge. That is a real problem with the AI Act.
I'd like to welcome a question from Professor Philip Hacker.
Maybe let's take the others first.
Okay. A question in the back. Okay.
Thank you. Yeah, thank you. Very interesting presentation. I share your analysis regarding sectoral versus omnibus, like the dilemma between the two, but I'm looking at it more from a policy process perspective. So now I'm curious, where do you see political decision points to still act on this dilemma? Because the AI Act is there. So no wonder your colleagues in Europe tell you, well, we can do both because they will have to do both to a certain extent, right? So yeah, maybe specifically with the AI Act, where do you think regulators or the people that are going to have to implement this at the AI office are going to be able to do something to maybe minimize the tension between these two? Thank you.
Thank you. I think that will be one of the biggest troubles in the in-tray for the incoming commission, right? And sort of thinking forward to the new legislative period, that'll be the real issue. And, you hear the sort of mooted talks about, a moratorium on further tech regulation, etc. I think that's why we will see a lot of the kind of sectoral approaches. I think the important thing is not to think that the AI Act has solved all the problems. Right? I think there is sometimes what I think of as a sort of regulatory iceberg kind of challenge where you say, okay, we've identified the problem and we have responded to the problem with this piece of legislation, but actually you're only talking about the tip of the iceberg. That's the sort of easy wins and very visible. And you've got the huge thing floating underneath with all the real problems still going on. So I think the real challenge for the Commission going forward will be to think about in each DG, what are the kind of challenges that we're now facing and how can we regulate in that particular context? I think tackling the GDPR will be a real challenge there, being in compliance, being in line with the GDPR, but also more fundamentally thinking about how you do that kind of regulating by saying the AI Act, as it were, deals with the upstream kind of challenges. What we're now going to do is deal with the downstream challenges. And I think that is constitutionally possible. Because the Court of Justice has said in the past very clearly that, again, product regulation regimes, what the sort of AI Act does, are not about the rights of individual citizens. They do leave space, right? There's the TÜV Rheinland case, for example, where the Court of Justice very clearly says this is not about the downstream issues. This is just about upstream. So I think there is constitutional space for the new commission to do that. Lots of really exciting conversations going on right now. While the politicians are all off campaigning, actually, there's all sorts of interesting stuff going on in terms of preparing new work programs. And I'm certainly aware of various DGs starting to think very specifically about what's going to happen in their worlds going forward. But I think the key message is to say, don't rest on the laurels of the AI Act. if there are laurels in the AI Act. But don't sit there and think, great, we've solved AI. We can now move on to other challenges.
Thank you so much for that question. We have one more question in the back. I'll just mention to our viewers, our remote viewers, that we're running about 20 minutes early. And I plan to keep us running early so that our upcoming speakers will have a bit more time. Please.
Okay.
Yes, so we'll go to both questions.
You are right. Okay, cool. Thank you very much for the talk. I'm actually like pretty keen to hear, because I might have missed this. It seems like the distinction between like what is technology and therefore omnibus versus what is product and therefore like sectoral is a bit, it sounds to me a bit artificial, right? Like even when you mentioned foundation models, like foundation models are products that are being like integrated, or components that are being integrated into other products, which are themselves being integrated into broader systems, which are themselves being like used into a broader service provision or something like that. So like I'd be curious to hear if there is like something clear in the law that makes the distinction, because like when we think about the political aspect of this, it is obviously like upstream like providers of base models versus the downstream deployers, right? So if you take sectoral, the sectoral operators become like the ones that have the most responsibilities, while as soon as you talk about the foundation models providers, we like they have more by default, in a way, they are presumed to have more responsibility, and they do in reality, right? In terms of like the design decisions, the data, and that kind of thing that they know they use. So like there's this interplay where like going to the sectoral would have served very well the AI industry, in the sense that like they wouldn't have had to care at all anymore about compliance. And yet I think there are concerns beyond the politics. There are concerns, for example, with greenhouse gas emission, right? Like we are concerned about greenhouse gas emissions. So like, should we regulate like the tens of thousands of like engines and products that are actually generating greenhouse gas at the end point of the value chain, or should we actually regulate the oil refining that is like providing us with cheap and dirty fuel for such a long time? Or beyond the oil, if you go one step further, like just energy production, right? And that would have probably be technology neutral, enabled renewable energies to come in, and we would not be in the situation that we are in right now. So like, do you see what I mean? Like there seems to be, we can telescope like every technology into another broader system or technology. So is there anything in the law that unable to escape that dichotomy?
Okay, thank you. We'll go to our next question right away, and then Professor Adams-Prassel, after you reply, we'll have a comment from Professor Hacker, and we'll try to go to break around 11:05 or 11:08.
Well, you talked a lot about deregulation in the EU, but you work in the UK, and UK hasn't really regulated AI so much so far, but it seems that the Labour would be interested in regulating AI more. So how do you see this evolving after the general elections this July?
Thank you. I was hoping I could avoid the Brexit question, but we'll get to that in due course. I think it's a really, really important point about, as it were, shifting responsibilities and shifting liabilities. And again, that's something we've already seen in the GDPR, right? Already in the GDPR, you see various attempts contractually to sort of shift the responsibilities between who's the processor, who's the controller. Now, when it comes to that, the Court of Justice has been very clear that you can sign whatever paperwork you want. You can't just artificially shift those responsibilities, right? So you can sign as much that you adjust the processor, not the controller. If you de facto you act as a controller, you're going to be held responsible for that. That, though, doesn't address the underlying point, I think, that you say that if we only focus on downstream, it's going to essentially give a free pass to those who really make a lot of the core key choices. And I think there are various ways of thinking about that. One way I'm thinking about a lot at the moment is, for example, to include a more specific sort of right to repair equivalent, right? So one thing the EU has done recently is to say you can no longer glue your products together. You actually have to use little screws so that if somebody wants to repair their product, even at the sort of downstream level, they can do so. Again, you could think of various ways in which you say that actually when it comes to deploying software in a particular context, you need to have more flexibility in terms of tuning, in terms of the kind of parameters you choose. So something along those lines could be an answer to that. I'm not sure that tech regulation and product regulation maps onto the omnibus versus specific, because the interesting idea about the product regulation regime is that it was designed as an omnibus regime. And again, I should make it very clear that in principle, the new legislative framework, that kind of EU product regulation approach, is genius. Because the idea was in the 1970s, you didn't want politicians to waste their time squabbling, because in France, the handle on the chainsaw is on the left side, and in Germany, the handle on the chainsaw is on the right-hand side, right? That's not a question that has any democratic relevance. We don't need politicians to do that. So we can happily outsource it to tech experts, and then they'll be able to decide which side of the chainsaw the handle goes, and that's the end of the question. The other thing with the product liability and safety regime, of course, is that the incentives are very clearly aligned. Apple is as much interested in my iPhone battery not blowing up as I am. The harms we're talking about are binary, right? They tend to be physical harms. It's very clear when your coffee machine goes wrong or when a medical implant goes wrong. You can tell when the harm is instantiated. You can then respond to it. The problem is all these great features of the product liability regime, once applied to AI, don't make any sense. The harms we're talking about will not be material harms, they'll mostly be immaterial harms. Person of color having a 12% lower chance of getting a job is much harder to detect than your iPhone battery catching on fire. And it's this reification of the technology that I think is a real problem. This is still sort of thinking that AI is a widget in the way that a chainsaw or a medical implant is. I think that's the fundamental problem, rather than a sort of distinction between the technology and the product. Again, super technically, yes, the Court of Justice has said that software can be a product, but not in that context. And I think the real category error of the AI Act is using a regime that was designed for physical problems and then applying it to, as it were, a much different world. Brexit, what's going to happen under Labour? Well, there's certainly going to be a change of tack, and I am aware of various efforts to start having rules specifically, and actually the way of thinking about it is context specific. So what we're seeing, for example, recently, a draft bill was published by the TUC to think about regulating AI at work. Different other sectors are also starting to think about it. The GDPR is very likely to stay. So, if you know, the grand visions of ripping up the GDPR, that's been sort of quietly shelved. And certainly, well, there's no more parliamentary time left to do it now anyways. So I think what we are going to see, the sort of sense of direction of travel I've got, is that there will be a lot of interest in regulating AI, but the way it's going to happen is more down that kind of sectoral route rather than the overarching route. And certainly what we saw from the sort of AI summit and just a general sort of, we'll just happily endorse industry self-regulation. Well, I don't think that will be continued.
Thank you so much. We have a question and comment from my co-chair for RECSAI and Professor Philip Hacker.
Hi, everyone, and I'm terribly sorry for my late arrival. My flight was canceled, and even though I'm probably one of those with a fairly close or short flight from Berlin, but I was able to listen to some of your talks on Zoom. And so I just had three quick observations. So the first one, tying in with what Michelle said, I'm also deeply concerned about the fact that the AI might actually preempt sensible national legislation. So I'm wondering if one way around this could be the fact that you could say that obviously EU law only preempts legislation in areas that it covers within its scope. And you could argue that some risks are consciously or non-consciously not addressed, at least not in a significant and adequate way in the AI Act. And hence that could potentially lead to, particularly in the non-high risk areas where, frankly speaking, we only have transparency and cannot be the case that all other laws concerning non-high risk AI systems are just now can be thrown out of the window, you know, including tort law or whatever. So if we only have transparency, that's clearly not a complete and comprehensive regulatory endeavor. And hence I would argue that in these cases with high risk AI, it's much more difficult. With non-high risk AI, I would say that it's clearly not maximizing. And so we have leeway in the member states. I was wondering what you make out of that argument. Second point would be to Reggie's claim about, or question concerning the interplay between omnibus and specific sectoral regimes. I was curious to hear, maybe he'll talk about it just after the break, whether the US system, where we have a much more sectoral approach for lack of comprehensive legislation coming out of Congress, whether that is something that from an industry perspective in the US makes more or less sense than the AI Act. So you have specific rules, of course, on autonomous vehicles. There have been state legislations, not only on data processing, but also on hiring in New York, for example, or in Colorado. So how does that square with basically the quest for a cohesive framework also for industry to know what is coming and what they can, base their planning on? And then third and finally, to Marshall's talk, I was wondering if, and maybe because I missed some at the beginning of it because I was on the plane, but I was wondering if one particular challenge that we're all facing here is the new developments in the Gen AI and general AI world, where post-training enhancements seem to play a great role. Chain of thought reasoning was only discovered after GPT-4 was launched. We have a lot of fine-tuning studies that show that actually with very little compute, you can change the behavior of the model significantly, and you can actually enhance it in ways that are radical. You can even make it much more dangerous. You can, of course, remove safety layers. And that is, I think, something that gives quite a pain to regulators, because the AI Act focuses on providers. There are some rules for deployers as well, and there is a good rule about when deployers become providers, but those post-training enhancements will be difficult to catch, I think, under at least a specific framework such as the AI Act. I have some specific thoughts about how this could be done, but I'll stop here just to point out this challenge where I think we see new developments in the technical sphere that again pose a conundrum to regulators.
Jeremiah, can I pile on with one additional
of course.
comment before, and then have your response? I'll be interested to hear your thoughts on the application of the theories that you presented to the United States, and where I think we are in a much different stage in terms of regulating AI. But as many in the audience know, we have an executive order, and there's an additional report that has come out of the United States Senate over the past couple of weeks. But for the financial sector in particular, which is one of my areas of interest, we have a structural system in the United States, obviously, with federal regulation and then state-based regulation. And then in addition to that, we have 6 federal financial regulatory agencies. So one might describe it as a very fragmented system. And in some ways, we may see some of the agencies, such as the Commodity Futures Trading Commission, moving forward quickly to regulate. So again, a different industry, and feel free to discuss later if that makes sense. But I think it is very relevant to consider what you have said in regards to regulating as we understand the technology, as opposed to moving forward quickly.
Thank you. Do you want to kick off with?
Yeah, I'll answer your last point first. Yes, that is absolutely an area of concern. In fact, in the talk at the beginning, I showed one example that is somewhat related to this, basically vulnerabilities, etc., that come after the training in fine tuning and related aspects. So yes, that is a major concern, and in particular the concern of how do we capture those products that are created downstream. With those additional fine tuning, additional outside training of the system, so that is definitely a concern, and one that is not addressed correctly at the moment.
Thank you. Thank you, Philip and Sarah, for these great challenges. Now, when it comes to preemption and the scope of EU law, I think that's a sort of, again, tension that's nearly as old as EU constitutional law itself, right? So historically, one of the first big cases we see in EU law is a tiny little regulation that regulates the wholesale of charcoal in the European Union, right? Sort of very weird market kind of bit. And then a German trader says, well, hang on a second, this rule on how much I can sell as a wholesaler contradicts my rights in the German basic law, in the Grundgesetz, the sort of, foundational constitutional document that's at the very highest level of norms. So you've got this tiny little bit of economic market regulation against this enormous Grundgesetz, hallowed foundations of the German constitution. And the Court of Justice of the Union is very clear who wins. Who wins? The little economic market regulation over the German constitution, right? And the court has been consistent in this principle of what we call the primacy or the supremacy of EU law. Now, Philip, you're right to point out that one way out is to say, well, actually, this falls beyond the scope of EU law, and therefore it's simply not covered by those rules of direct effect of exactly. The challenge, however, is that the Court of Justice has, when it comes to interpreting the scope of EU law, been generous, to put it at its mildest, right? Kuhn Lennertz, the president of the Court of Justice, likes to talk about the penumbra of EU law, which is his way of saying essentially anything that we decide falls within our scope, So again, in principle, I think there is a real argument to say that, yes, particularly for systems that aren't high risk, there is space left for member states. But I think there is then still the space nonetheless for operators to use it to challenge those rules, right? Would the Court of Justice ever find itself in a situation of striking down, a Swedish law on the energy consumption of training models? Well, I think you would be in that kind of extreme constitutional challenge. I mean, again, if German co-determination were struck down as a violation of the AI Act, definitely Karlsruhe would say this is ultra vires and you're not going there, right? So I think, but again, we would find ourselves in really hot constitutional waters, triggered by regulation that probably was never designed to bring out these challenges. So I think, again, there's a sort of difference between what we can think about neatly in a sort of senior common room discussion and what would happen in practice. And of course, the people who are then in between are the small startups who have to challenge that, right, and have to tackle those ideas.
To link up with our friends from the strategic litigation units. I was just looking yesterday. So.
There's a lot of strategic litigation being planned from all sorts. Your second point actually, I think, ties in very nicely with Sarah's points, and that's about the sort of difference between what's going on in the US and what's going on in Europe. Now, for me, the most interesting distinction I'm observing is that perhaps because of the legislative gridlock we are seeing at the US level, you see really interesting enforcement activity from various agencies, right? You've mentioned some of the financial agencies, including the SEC, but also you look at the work the FTC is doing, for example, under Lisa Khan, right? They've really interpreted their powers in, again, shall we say, quite interesting and exotic and novel ways, trying to use existing rules on consumer protection to go against what's happening in various AI systems. Similarly, again, we see this in the employment context. So the EEOC, the Equal Employment Opportunities Commission, under Charlotte Burrows, the commissioner, I've done quite a bit of work with her, and they have taken their powers to essentially combat discrimination in the workplace and interpret them in very interesting ways to make algorithmic discrimination one of their enforcement priorities. Now, again, you've got this interesting divide then in EU law, really there is no enforcement power for the Commission. Apart from certain very narrow areas of what we call exclusive competence, like competition or antitrust, really the idea is that the norms are set at the union level, but the enforcement is then left to the member states. So, for example, with GDPR, you then get, certain member states where, let's imagine, lots of big tech companies have their headquarters there, and their tax revenue contributes significantly to your national budget, and suddenly you've got a data protection regulator in this hypothetical country in the northwest of the European Union, where suddenly no GDPR norms are enforced at all, or enforcement is done very lightly. So that's always been the challenge with EU law, and I think that's one really big sort of difference between the US approach and the EU approach, that we see a lot more enforcement action in the US. Though, again, what will happen after the autumn elections is a different question altogether. But certainly at the moment, we're seeing a lot of enforcement action, whereas in the union, we see more sort of standard setting action.
Yeah, thank you very much, Jeremiah. That's a characteristic of our system. I'll just note that enforcement action and litigation is a much different route for regulation and can be very expensive, particularly for startups that may have less resources than the larger companies. So thank you very much for an incredible presentation, and thank you to everyone else in the room for your excellent questions and discussion. We will go to break, and can we resume at 11:35? And that way our upcoming speakers will have a few more minutes. So again, 11:35 for everyone in the room, please come back. And then for our hybrid audience as well, please join us at 11:35. Thank you.
Thank you.
So I'm very pleased and honored to introduce our next speaker, Reggie Townsend, who will be providing a much needed industry perspective on artificial intelligence. And Reggie's credentials are so expansive that I can't possibly give them credit in this short introduction. Reggie is Vice President of Data Ethics at SAS. He's leading a global effort to build a better and more equitable future through fair, sustainable application of data, AI, and associated technologies. He's had the privilege over many years of leading multiple teams that deliver proven data-driven results across many sectors and advising marketing and sales alignment strategies, leading customer success through machine learning and AI in health and life sciences, amongst others. And Reggie is also a member of the National AI Advisory Committee, formed by the United States, both through legislation and appointed by the President of the United States. Reggie, we're very honored to have you with us today. Thank you.
All right, test. All right, perfect. Now I can hear myself in stereo. That's good. All right, so like I said, I'm going to take a pragmatic approach here this morning as it relates to the conversation around AI. There's a ton, and I think we've covered, quite an expanse already this morning, from kind of headlong into some of the technology itself, all the way to some of the regulatory aspects and what all of that means. And so I'm going to sit somewhere in the middle and talk about this notion of profit and purpose. Clearly, from an industry perspective, the ability to earn a profit from all of this technology matters. But for those who are conscientious, the profit matters because it helps to drive purpose. And I think it's important that we balance those two. I think it's also important that we give, until proven unnecessary, adequate benefits of doubt, and as best we can, reduce some of the cynicism around the conversation. I think there is a broad concern socially, literally around the globe, and I think it all boils down to trust. We've got a trust gap. It shows up in the conversation about AI, but it also shows up in the fraying of democracies, right? But in industry, where this trust gap shows up is in the willingness or unwillingness of folks to embrace our products and our services. Edelman did a survey. They do this trust barometer every year, and in their 2024 version that came out earlier this year, what they show is that there are more people who are willing to reject AI than to embrace it. They do this global study. We're talking about, when I get in the car and I talk to my Uber drivers all the time, and they find out that I do AI stuff, and usually within the first 60 seconds, there's some sort of fear-based response. Concern of some sort, and I talk to family and friends, the same is true. And I'm sure you all have similar conversations. And that fear-based response is rooted in something real. And where it shows up in industry is here, more willingness to reject than embrace. Why is that? Well, there's a number of reasons. One has to do with this out of balance equation here, and I want to speak to you about this. So this quadrant, also from Edelman, speaks to the notion of major institutions throughout the world, NGOs, non-governmental organizations, business, media, etc. And basically what it says on the lower left-hand quadrant is that most people think that government and media are some combination of incompetent and unethical. All right. And on the flip side of this is saying that business and NGOs right now are having some measure of success in terms of competence and ethics. Now, we can quibble about whether or not these institutions are in the right part of the quadrant, but I think if you look at their studies over the course of time, what this bears out is a relative amount of consistency. And again, when you start to think about notions of trust and why we get those fear-based responses when we talk to our families and friends and Uber drivers, what they're telling us is that, you know, I kind of trust business because there's some expertise there, but where I lose trust is when you show up with your expertise and you deliver products that end up hurting people, or when you say you're going to do something and then you do something different, right? And so over time, you start to see the business trend in the other direction. And by the way, government has been doing that for a long time, so they're on the wrong side of the quadrant and have been there for quite some time. But this shows up in our society, right? And so what I would argue is that it's the responsibility of business right now, considering that we have some measure of trust, to try to uphold this thing and bring the folks who are on the incompetent and unethical side up into the right side of the quadrant. I consider that an opportunity to compete on our values. You can see some of this play out. I give this example, I'm sure the Waymo folks probably don't like me about it, but for those who aren't familiar, in the US, we have this self-driving company called Waymo. So they've got cars, you know, around a number of US cities that are unmanned. They don't have drivers, they just have computer vision, like the good Dean pointed out earlier, and they are navigating streets. And so while this is novel from a technology perspective, we have to think about the socio-technical impacts here. Now, there are those who say this is a really good thing because what the technology allows us to do is have fewer driver accidents, because the computer vision, as the Dean told us earlier, has matured to such a point that we're able to navigate people and navigate obstacles of all sorts, and that's good. But what about the people who actually drive for a living? What are they to do? What about the people who are just kind of freaked out about the idea of cars driving? I don't know if anybody walked downstairs and saw all of the robot dogs and robot people. Like at some point, some of that gets to be a bit unnerving. Why? Right? Because it starts to go against what we know as a human experience right now. Over time, maybe we get acclimated to it, right? But we have to accept that these technologies are showing up in a society that currently exists, very much like we were talking about the laws earlier. Some laws already exist, and so how do we graph on the new laws onto the old laws, or do we create new laws and all these sorts of things, right? So these are socio-technical problems that we're dealing with. And they impact every one of us. Kind of pick your column, and I'm sure there are a number of other columns. This is illustrative, not exhaustive. But from a business perspective, certainly we have our concerns. Can we make sense of any of the data? We talked about the GDPR versus AI Act conflicts there. From a policy-making perspective, like, do we have omnibus versus sectoral, as Jeremiah's pointed out earlier, and can we be adequately transparent? And oh, by the way, and one of the things that weren't mentioned today, maybe we can get into it in a little bit, is the recognition that a lot of the laws today were established to keep those in power, right? And so over time, maybe you have to go back and revisit some of those laws. And maybe these new laws gives you an opportunity to do that, either through amendment or other legislative processes, right? And then finally, we all can be consumers or citizens or what have you, and we have our own individual concerns as it relates to our privacy. And what is privacy anymore? What really does that mean, right? And so we all have our concerns with respect to that. So I tend to argue that while we might have technical solutions and legal solutions and economic solutions, all of them really only address societal level issues, right? And that's what they're designed to do, to try to create norms and standards. But we really have to get a hold of the individual level approach. And I think the ethical inquiry approach allows us to do that. And so I'll kind of unravel that a bit for you. Laws have limitations, as were pointed out. Technologies have limitations, as we heard earlier. They all have their vulnerabilities and so on. But I'd like to ask the question, 3 of them actually, whenever we are at this point of dilemma, whenever we have these notions of ambiguity, for what purpose, to what end, and for whom might it fail? So if we can ask ourselves the questions before we show up with the next robotic dog, right? For what purpose? What are we hoping to get out of this thing? Is it just a toy? Or do we want to actually play fetch with it? To what end? We're building large language models in pursuit of artificial general intelligence. Should we? I know we can, but should we? Right? These are ethical dilemmas that won't be solved by law, right? But they have to be solved by us. For whom might it fail? If I create an AGI that has the ability to destroy humanity, as we saw earlier in the example, is that a good thing? Right? And so why are we in these pursuits? Is it just because it's scientifically possible? Is it because I have enough money that I can do it and screw the rest of you? Like, we really have to ask ourselves these questions. And so we're going to end up with laws. We have to, right? We're going to end up with technology that shows up in society, but I believe starting off with these 3 notions of ethical inquiry are the kind of the initial steps in any of these design approaches. So here are we stuck? There we go. All right, so here, I'm gonna do this. I'm just build it out. So when we talk about AI from an industry perspective, we start to think about our technology from the vantage point of trustworthy AI. Having been informed by some of those questions with respect to ethical inquiry. So fundamentally, we want to make sure that we are developing tech in an ethical manner, that it doesn't harm people. People ask me what I do for a living. I'd say my job is to make sure that wherever our software shows up, it doesn't hurt people at the end of the day. So we want to make sure that we do no harm. The could we versus should we, which I mentioned earlier. And then finally, can we build AI that reflects our values as a society? I think, and maybe Jeremiah might argue with me, but I think fundamentally where the Commission was headed with the AI Act, because they were trying to accomplish that one, whether or not it satisfies all of the legal parameters and all of that, I'll leave it up to the attorneys to talk about that. But I think at the end of the day, you've got to do something that says, here is what our value system is. And so I think that was the attempt there. So why does any of that stuff matter from an industry perspective? Well, we don't want to break laws. As I said, remember that whole profit piece up front, right? Breaking laws cuts into that, right? So we want to make sure that we stay on the right side of the law. So compliance becomes very important for us. Now, having consistency, not only within a nation, but literally around the world helps us. But we recognize that the ethics of it all get applied differently. So what's ethical in the US may not be as ethical, say, in Dubai, just making it up. No shade to my Dubai people. Interoperability then is right on the heels of that, right? Because I want to be able to write once and run many places when it comes to my software. That is an attribute that helps me be efficient, that helps me predict what kind of talent I need in the marketplace, that helps me understand how much penetration I might be able to get into a particular market, et cetera, et cetera. So interoperability becomes important. When there is a lack of interoperability, that means now I've got an inconsistent set of standards that I have to deal with. That happens, right? It's part of the way of the world, but it is easier for me and more profitable for me if we've got interoperability. Now, trustworthy AI matters because if I don't show up in a trustworthy manner, then I risk my reputation in addition to the finances, my ability to profit, as I mentioned earlier. But I want to really hone in on the last piece because I don't think that industry gets enough attention as it relates to moral imperative. At least certain companies. Look, let's face it, there are some companies out here that have just been bad actors for a long time and continue to be. However, I would argue, I get a chance to talk to a lot of people in boardrooms and C-suites and you name it. I have yet to walk into a boardroom and see a diabolical plan on a whiteboard, right? I have yet to walk into a conversation where people are saying, you know what, here's the best plan to destroy humanity, right? Yet to happen. I've been doing this for a little while. Most people are attempting to do what they believe is in their best interest financially, and it's an important conjunction, and to not hurt other people. Now, we do have to wrestle with the reality. There is a tension that exists in any society, right? If you pull on this lever, right, it lifts the other side. Like that happens. But I think it's important that we give the right level of benefit of doubt when it comes to the moral imperative piece, right? I don't think that most companies are out here trying to expressly do harm. Now, that said, when harms occur, they need to be held to account. And when harms can be predicted, we need to mitigate as best we possibly can with the data and abilities that we've got available to us at the time, right? So from an internal perspective, what I see a lot of companies doing right now is attempting to govern their own AI endeavors, okay? Clearly, there's a lot of motivation from what's happening here in the EU. As was stated, I do some work with the US government. There is some movement there as well. And so industry leaders are responding in kind. And this is not just limited to the West, right? We've got a lot of activity in China and Singapore and Australia. And business leaders are responding in kind. They're not solely motivated by the legal regimes, however. I will have to say that again, right? There are a lot of people who have woken up and said, hey, we could actually hurt people. Let's not do that. It's not a good idea. It's bad for business. And so let's figure out a way to govern ourselves, even in the midst of environments where there is no, hard, quote unquote, AI law. All right. But as was pointed out earlier, we do have laws, right? And AI applies to many of them. So what are organizations doing? They're largely organizing around 4 constructs. And here they are. They're focused on oversight. So see a lot of organizations now putting oversight committees in place. Generally some combination of executives cross-functionally, focused on all matters associated with AI, trying to get their arms around what AI actually is within their enterprises. They are also focused on compliance. You see a lot of these oversight committees that are comprised of or driven by a lot of times their legal teams. So a lot of focus on compliance and regulatory activities. You've got operational aspects associated with this. So this is everything from what people buy to what they sell from an AI perspective. There are a lot of organizations that are using AI from an HR perspective, from a worker safety perspective, you name it, and trying to kind of put their arms around what that really means and how they can ensure that they're doing the right things there. And then one area that I don't think is getting enough attention, and I put it here, I know we focus on a lot at SAS, is the culture component. What you have to recognize is that every single organization out here, whether you're young or old, has a set of normative behaviors that AI now gets grafted onto. Just think about your basics, right? A year ago, if you use Outlook or Gmail, you name just regular email application, it worked in a certain way. Well, today they're all Copilot and autofills and all these sorts of things. Now, you might say no big deal, and that's good, but think about it as a CIO when features just show up in the product that you subscribe to, and those features may grab data and repurpose that data in ways that last month didn't do it, right? So all of a sudden you've got to retrain people on how to use email, right? You've got to put policies in place on whether or not to use a large language model and which models to use and those sorts of things, right? So this is an ever-evolving topic. And oh, by the way, you have employees who are suffering from and this is a real term, AI anxiety right now with concern about their jobs. So think about this as a leader of an organization attempting to bring AI into the workplace to help improve worker productivity, but in the back of the workers' minds, they're thinking, oh, this is my replacement, right? So figuring out ways to message become really important, right? Putting all the training and skills enhancement in place becomes really important. Right? All right, so I'm gonna speed us up a little bit. So there's a whole construct that we've built around how to pull some of this together for organizations. So we go out and talk to boards all the time about doing some of this kind of work and what it means. So I won't spend a lot of time there because I know we probably want to get to the Q&A. I do want to talk a little bit about the tech of it to some degree. From a trustworthy AI perspective, we tend to think that this is a marketplace. So the conversation came up earlier about market making. I think this is a perfect example of that, where trustworthy AI, we believe it really itself is a market and it has its own components, many of which I've shown here. You can think about these 6 kind of core capabilities on the technology as the key attributes needed in a trustworthy AI environment. If data is the new oil, you need to be able to manage that data, right? You need to be able to clean it and refine it and distribute it just like you would oil. You've got to have sufficient levels of explainability, which was talked about earlier. You've got to make sure that you can keep data private and secure. You've got to be able to detect and mitigate against biases, which, by the way, there's a lot of conversation in our space around bias with a negative connotation. There's also an upside to bias, right? And so if you just accept that bias is the way that humans are basically use our bias mechanisms to be more efficient in our cognitive processing, bias isn't always about discrimination for bad, as an example. You can bias and discriminate for good if, let's say, you want to make sure that women are getting access to capital to build businesses, or you want to make sure that people of color are getting adequate access to healthcare, right? That is also a bias, right? But for good purpose. And so I think we have to be able to identify biases that will do harm and then mitigate against those harms. So I just want to kind of shed some light on that. And then finally, and again, kind of another burgeoning subsector of that market is this notion of model operations, where you see audit regimes and such start to come up, which we were just talking about a few minutes ago during the break. To that end, one of the things that we've been focused on a lot and we're starting to see more of is this notion of model cards. And so it is a reality that every single model from an AI perspective has a shelf life, right? It is accurate until it's not. So that just basically highlights this notion of model drift. As data continues to feed a model, what that model was tuned for initially gets out of tune over course of time. So we need to be able to identify when those shifts occur. We need to be able to evaluate models ongoing for things like accuracy and fairness. We need to understand what the underlying data is. We need to know what the major characteristics are that are driving a model and those sorts of things. And so model cards help us with that. Think about them as a nutrition label. All right, so you have a nutrition label on the side of your food, right? It tells you how much sodium and sugar you're going to consume. Well, same needs to be true for AI models. And so there's a burgeoning movement around this right now coming out of our AI Safety Institute in the US. Of course, we've got one at SAS. And so I predict we'll start to see a lot more of those in industry. And so I'll leave you with this. This notion of AI is still an evolving term. I don't think yet that society writ large has really weighed in on what AI is and will be, right? Because society ultimately does have a say, right? This AI conversation has largely been in the domain of the technologists and the governments. But society will have its say. We saw an example of that with the Waymo. Now, I don't think that everything will be a violent revolution against AI or anything like that. But I do think we have to understand that language evolves over time. And so a lot of the things that used to be just single technology silos, like, I don't know, computer vision and forecasting and analytics, are now referred to as AI, in addition to large language models and generative and you name it. And so we'll see how expansive that term becomes or if it contracts over time. And then we'll see how society weighs in. And I'll leave you with this last point. I am a net positive on AI, largely because I do believe that it democratizes access to knowledge. And when you democratize access to knowledge, you create an opportunity for creativity among society, right, writ large. And there are far too many people who have been pushed to the margins of our global society over the years. And if we can imagine for a second, I'm old enough to remember, and I'm going to date myself a bit. I'm old enough to remember that, there was a ton of knowledge in these things called encyclopedias. Right. And when I grew up on the south side of Chicago in the US, my mom couldn't afford the whole collection of encyclopedias. But what she could do was get a couple of the dictionaries, right? And I spent time flipping through the dictionaries. But if I needed to get into the full set of encyclopedias, I had to get on a bus and go to a library and spend time looking at encyclopedias. Then over time, these computer things started to show up, and we could get encyclopedias on these things called CD-ROMs. Yeah, I told y'all I'm old, right? Right, and then you could put this, CD-ROM in, and then all of a sudden the world opened up, right? But then there were limitations, and then all of a sudden this internet thing showed up. It's like, oh my God, right? There are actually people on the other side of the world. Can you believe that? Right? And so now we have this thing called AI. And it's going, and it is, not going, it is giving us an opportunity to tell it things, have it tell us things back, right? And so imagine if you are, a kid, when I was that age, 7, 8 years old, imagine if you're 7, 8-year-old, but you're living in a nation that is far less prosperous than the US or far less prosperous than Switzerland, right? That doesn't have the infrastructure to support a major data center, doesn't have a whole collection of scientists and whatnot. Imagine this thing showing up and you being able to see and talk and experience. Imagine what that releases in you. So I'm a net positive, and I think AI overall will allow us to do just that. And so I'm looking forward to what it produces in the next 7, 8-year-olds that our society produces. So I thank you, and I'll open myself up for some questions.
Thank you so much, Reggie, for that really insightful presentation on ethics and trustworthy AI, and ending on a positive note. Do we have questions from the audience? We'll start right here, please.
I can be the mic runner too if you need it.
Thank you very much. I'm just
Yeah.
mindful of having the mic for the people online so that everyone can
Yes.
hear everything as clearly as possible.
Sure.
Thanks so much for a really fascinating talk. The question I had for you when you were talking about different trustworthy principles and the foundation was you had a focus on oversight. And what I'd really like to hear your views on is that within the context of cultural compliance. So it's so difficult to be that person within an organization, a data protection officer, for instance, under the GDPR, who says to developers and engineers, no, you can't do that, or you shouldn't do that. But that internal oversight is absolutely essential if any external oversight is going to work. So with the AI Act, I know there's going to be quite a few criticisms of the AI Act today, so I'm bringing some more positive notes when I can. We have a reference to practices like red teaming, which is making sure there's an adversarial voice in that conversation when you're talking about cultural compliance and oversight. So Reggie, you sound like you have a lot of experience in this, going back to CD-ROMs and, dare I say, floppy disks.
Yeah.
Having panic attacks right now, thinking of how unreliable those were. But in your opinion, what do you think is the best way? And at what stage do you think is the best stage where that adversarial voice should be? And how do you support those people who are having to have those more difficult pushback questions with developers and with engineers and even with senior management?
Yeah. So look, nobody likes the police until you need them, right? I'll give you a personal anecdote. One of the things that we dealt with at our company, and I see this show up in a couple of different places as well, which is you've got kind of the notion of kind of leader-driven impetus versus, let's call it just self-governed, self-regulation, if you will. We started, before we kind of instituted our practice, we started down the path of what I might call just kind of traditional responsible AI governance, basically wanting to show up and make sure that we weren't hurting people, but it very much came across as thou shalt not. In our environment, and I think this is context specific to kind of cut to the chase, but in our environment, that would not work. We've got a bunch of innovators, bunch of, I think we've cornered the market on data science PhDs and all, like really smart people who know what the heck they're doing on a day-to-day basis. But they still need guardrails. They still need to be held accountable. But how do you do that in a way that accomplishes the goal, but respects the culture? And so what we had to do was start down the path of what I'll refer to as soft governance, the soft hand approach, where we just define a set of principles and put some policies in place. And that is, if you will, the thou shalt nots. But even in the way we messaged it, it was thou can do everything except these couple. See the difference, right? You can do a whole lot, but these few things will just suggest ought not be done, right? And if you do those things, then you need to have a conversation with us about why you're deciding to go down that path, right? It's sort of a call your manager before you do these things was I think the actual language. And so that worked for us. And what it did, coupled with training and a ton of it, and very targeted strategic communications from senior execs in certain areas who are influential. A lot of that work we still have going on now. What that does is that creates a permissive culture around this topic, right? Such that now we have a ton of people who want to be a part of this activity of quote unquote governing for all the right reasons. That worked for us. I've seen it work in other areas as well. Because I think at the end of the day, when people show up in a corporate context, like the police, right? I think it cuts against, particularly technologists, kind of cuts against this notion of agency for those individuals. And so I think we've got to figure out a better way to have those conversations, to get them on the right side of kind of self-governance. So just personal anecdote.
Yeah, thank you very much.
Yeah.
So thank you very much, Reggie, for an incredible presentation and for speaking to us today. Oh, Professor Hacker has a question.
Please.
Thanks. We just still have 2 minutes. Thanks for a really insightful talk. So I just want to pick up two things. One, tying in a little bit with what Nora said about cultures. So you showed that impressive graph where government and media are widely distrusted. And I was wondering, does that survey come from the US or is it a global survey? And I'm pretty sure that there is significant cultural variation if you look at different countries and regions. So that's one thing. And also with respect to industry. And the second question, more to the end of your talk, you showed these nice, basically like dashboards or so with fairness and accuracy and so on. So I'm wondering, in your team and in your work, how do you approach possible trade-offs between these goals? So I've teamed up with mathematician, computer scientists, machine learners to, look at the fairness accuracy trade-off, which is fairly famous and doesn't always hold, but, you have that in the field. You might also talk about performance sustainability trade-offs, where at the moment, the most potent models are the large ones, which have an insane CO2 footprint. So how do you navigate these trade-offs that become actually fairly intensive and difficult if a company, for example, has several goals? I'll say they want to be, carbon neutral or sustainable or whatever. At the same time, they want to be fair and they want to be accurate and performative.
Yep. So let me address the first question, Philip. So the quadrant, that's a global view, and that what you saw was an aggregation of that global view. You can do a double click and see the actual country responses on that. So the Edelman report is pretty robust. And what you'll see is that, basically it bubbles up. There are certainly nations where there's more trust in government, but writ large, it shifts to the lower left there. So happy to share that with you if that's of use for you. And then on the second question, the trade-off question. So yes, trade-offs matter, but context matters more. It is obviously important to be very accurate in a, let's say, a medical setting, perhaps less so in, I'm making this up now, so I don't want to offend anyone, but maybe less so in an insurance setting, right? Or more, right? So not to suggest that you don't want to be accurate, but, you know, I'd much rather somebody be more accurate on my heart than, you know, on my interest rate. Now, our job as the creators of the technology is to put people in the position to make those decisions for themselves, right? That's the position that we take. We want to ensure that the you know, most senior leaders all the way to the analysts who are, you know, working on the data are in a position to understand what the impacts are of the choices that they're going to make on things like fairness and accuracy and what have you. Is that perfect? No, it's not. None of this is a perfect science. But from our vantage point, we recognize that we have limitations as technologists of creators of the platforms to do this stuff. And then we've got, if you can kind of think about a track metaphor, you know, a relay race, at some point you have to hand over the baton, right? So we're going to hand over the baton to the people who are actually working in their particular industry on their particular set of problems and give them the tools to measure their impact, right? So that's the way we think about it.
Thank you very much, Professor Hacker, for that question. And thank you, Reggie, for your presentation. Very insightful, and we look forward to discussing with you further. I'm pleased to welcome our next speaker, Professor Michelle Fink, who's going to present to us today about a very important concept, policy explainability.
Johannes, come to help.
Or is it all?
Yes.
Yes. Okay. Okay. I hate to hear myself.
So I'm pleased to introduce Professor Michelle Fink. Michelle, thank you so much for joining us today. Professor Fink is a professor of law and artificial intelligence at the University of Tübingen and director of the CZS Institute for Artificial Intelligence and the Law. She has also worked at the University of Oxford, the London School of Economics, and the Max Planck Institute for Innovation and Competition. She has also been a visiting professor at LUISS University and an affiliated fellow at University College London. Michelle has worked on a number of esteemed and highly regarded projects regarding AI, data governance, data controllers, and in addition, the handbook on the law of the sharing economy. Professor Fink, thank you so much for joining us today.
Thank you so much, Sarah. So thank you so much for having me and for putting together this great event. So what I'll try to do in my talk is offer a legal perspective on explainability. And in particular, I'll be looking at various areas of European Union law and try to determine to what extent they do or do not create legal obligations to make AI systems explainable. Now, it is likely that this talk will leave you with just as many questions as answers, but I think that's just due to the fact that at this stage, there are more questions than answers in relation to those various legal provisions. So I can't look at all of European Union law in 20 minutes. So what I've done is chosen 3 areas of EU law to look at. The first one is EU administrative law, also as it is governed by the EU Charter of Fundamental Rights. Then secondly, data protection law. And then third, you could not include it, the AI Act. And I've chosen these 3 areas because I think they're first, the ones that apply to most AI systems. And second, also because they're generally the ones that are most talked about in this respect. So let us start with EU administrative law, right? So as most legal systems, the legal system of the European Union creates various legal obligations that apply to administrations. And in particular, EU administrative law contains various legal obligations that require authorities to explain the reasons behind the decisions to those that affect it, right? So I think this is a feature that we generally find in administrative laws across the world. The idea is that when an administration takes a decision, then it must explain these decisions to the citizens that are subject to it. So for instance, if you apply for a buildings permit in your municipality, then typically the municipality will have an obligation to explain why it doesn't grant such a permit if that is the decision that it takes. Now, what is the scope of the application to this in relation to AI systems? Well, EU administrative law would apply to decisions that are taken by administrations, right? So we're talking about sort of potentially any kind of AI system, but it needs to be employed by an administration in order for these legal provisions to kick in. Now, EU law contains three different obligations that are particularly relevant in this respect. The first one is Article 269 of the Treaty on the Functioning of the European Union, which creates an obligation that legal acts shall state the reasons on which they are based. Then we also have Article 51, paragraph 2c of the EU Charter of Fundamental Rights. So the EU Charter of Fundamental Rights is essentially a constitutional document that enshrines various rights that must be respected across the European Union. And Article 41 enshrines the right to good administration, which includes an obligation for administrative decisions to give, for administrations to give reasons for their decisions. And then thirdly, the duty to state reasons also forms part of the procedural standards and guarantees that are recognized as general principles of EU law. So in EU law, we also have this tradition of general principles that are sort of more implicitly considered to be part of the constitutional law of the European Union. So for instance, there's a few fundamental rights that were first recognized as forming part of the general principles of EU law before they were then given a sort of statutory grounding in the Charter of Fundamental Rights, for instance. Now, these principles that we find in EU administrative law, they have been part of EU law for a long time. They predate any discussions around AI. They predate any sort of larger scale use of artificial intelligence, and they apply to administrations irrespective of how they come to a decision, right? So it's a general obligations that administrations must explain the reasons why they take certain decisions. As AI has started to be used more widely, questions emerge as to whether these various legal duties for administrations to explain decisions that they take, whether they also apply in the context of artificial intelligence, and if so, what they mean concretely from a technical perspective, right? What do these explanation obligations imply for AI? Well, the second question hasn't really been answered yet by the European Court of Justice. So at this stage, we can't say, well, legally, the fact that administrative law obliges you to explain your decisions implies that you must, for instance, provide a counterfactual explanation as to why you've denied the building permit. This question hasn't been answered yet. But in 2022, the European Court of Justice's Grand Chamber issued a judgment that made clear that in principles, these explanation duties that we have in EU law apply also in the context where artificial intelligence is being used to make a decision, right? So in this this judgment in Ligue des droits humains, the European Court of Justice essentially said, well, if you're using an AI system, and if by virtue of using this AI system, you can't explain why a particular decision was taken, then you cannot use the system. So we know that these various long-standing obligations also apply in the context of artificial intelligence. But the question that remains open is, well, what does explainability actually mean in this context, right? How do we need to be able to explain an output of an AI system for it to meet these legal obligations? So that's an open question in this context. So when we look at these provisions, we see that the addressee is the state, right? Administrations. We see that there's at this stage not yet any legal certainty as to what technical mechanisms need to be put into place in order for this an explanation to sort of meet the explanation standards that we have in EU law. We can also say that EU administrative law does not prescribe any specific kind of explanations, right? So there's nothing in the law at this stage that would make us think that, oh, you would certainly need to have a global explanation or maybe a local explanation of enough. There's no prescription of a particular explainability standard. And then I think it's also interesting to think about the rationale of explanation duties in administrative law, and then also compare them to the two other areas of law that I'm looking at later on. So I think here it's quite clear that the rationale for explainability is firstly citizen control of state power, right? So this is quite clear in relation to these legal obligations that we saw. This is the idea that, you know, the citizen is subject to the state monopoly, and because of this power imbalance that we have between these two actors, it's really important that citizens be able to understand why a given decision was taken. Also, so that they can potentially challenge it, right? So explanation here also has this enabling dimension to the extent that it's also designed to empower the citizen to detect, for instance, whether a decision was taken on discriminatory grounds, which would make it breach anti-discrimination provisions, of course, and the citizen would then be able to sort of challenge this in court. Another rationale that is less explicit in the legislative history of these provisions, but I think we can also read it into this, is the human dignity element, right? So I at least would argue that there's also this idea that that explainability also safeguards human dignity to the extent that we think that this is something that's potentially threatened if we're subjected to decisions that we can't understand. Now, let me look at the second area of EU law that I want to talk about today. And this is the data protection law, right? So data protection law in European Union law is protected as a fundamental right in the EU Charter of Fundamental Rights, but it also has a very specific legislative or various specific legislative regimes that implement this fundamental right. And one of them is, of course, the General Data Protection Regulation. And in the GDPR, we have this article, which I think is in many ways a bit of an odd addition to the GDPR when we look at its predecessor and also compare it to the other legal obligations that we find in the GDPR. And this is Article 22. And Article 22 creates a right not to be subject to a decision based solely on automated processing, right? What's the scope of application of this provision? Well, it applies only where an AI system processes personal data, right? So it wouldn't apply to AI systems that work with climate data, for instance, or data that's clearly not non-personal in nature. And Article 22 specifically creates these rights for data subjects. So these are the persons that are whose personal data is being processed. And the right not to be subject to decision based solely on automated processing also only applies in relation to automated processing that either creates legal effects for the data subject or similarly significant effects. There's some limitations to this right. So you can still do solely automated data processing where it is necessary to enter into a contract or for the performance of a contract, where it is authorized by national law, EU law, or where it is based on the explicit consent of the data subject. And if your solely automated processing falls within these categories, then there's an obligation for the data controller. The data controller is the natural or legal person that determines the means and purposes of the personal data processing that's taking place, needs to implement suitable measures to safeguard the data subject's rights and freedoms and legitimate interests, at least the right to obtain human intervention on the part of the controller to express his or her point of view and to contest the decision. Now, the big question is, does this provision, the third paragraph of Article 22, can a right to an explanation be read into these provisions? And this question has not been authoritatively answered by the European Court of Justice at this stage. A few years ago, there was a very heated academic debate that took place in relation to that. So essentially, you had a student paper at Oxford that tried to provide a computational implementation of a right to an explanation in the GDPR. Then you had a few professors from Oxford writing this paper saying, no, 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 you know, you've got this wrong. There's actually no right to an explanation that can be read into this provision. And then you had, I don't know, between 5 and a dozen additional academic papers that were contesting these findings and that were saying, well, actually, we can read a right to an explanation into Article 22, paragraph 3. And the main arguments put forward by those that argue that a right to be an explanation can be found in the 3rd paragraph of Article 22, paragraph 3, argue that this is something that can be read into a recital 71 of the GDPR. So essentially, your recital is the text that precedes the article of EU secondary legislation. From a formal perspective, it is not legally binding, but from a practical perspective, the European Court of Justice very frequently relies on recitals to interpret the legislative text, and in some cases have actually treated recitals almost like the legislative text, right? And recital 71 tells us that there is a right to obtain an explanation of the decision reached after such assessment, and then also to challenge the decision. There's another provision of the GDPR which has led some to speculate that we can read a right to an explanation into Article 22, and this is Article 15, paragraph 1H, which tells us that the data subject has the right to obtain meaningful information about the logic involved, right? And some people have argued that, you know, this really means sort of the logic in a mathematical sense. And then by extension, this means that you have a right to sort of learn more about this. So does this mean that there is right to an explanation in the GDPR or not? We don't know at this stage, right? So there's various interpretations that have been put forward, but the European Court of Justice hasn't specifically answered this question yet. There is a case from last year, the Schufa case, which doesn't go into this question specifically, but some people have argued that the way in which the question that was before the court in that case indicates that if the question were to be put before the court, whether there is a right to an explanation, Article 22 GDPR, there's a high likelihood that it would say yes. What would this mean from a technical perspective? I think that's a question that would still need to be determined. So in summary, we can say that potentially data protection law also creates a right to an explanation under EU law. In that case, it would only apply to AI systems that process personal data, because that is just the scope that data protection law has. The addressee of these obligations would be data controllers, so the natural or legal persons that determine the means and purposes of processing personal data. The GDPR definitely doesn't tell us what an explanation would require from a technical perspective, right? But it also definitely doesn't prescribe that an explanation would, for instance, need to be a global explanation or a counterfactual explanation or whatever, right? What is the rationale of Article 22? Well, again, I think we can read this human dignity dimension into it. Generally, data protection law pursues the objective of protecting the data subject when their personal data is being processed. And additionally, in the Schufa case, which was the first case in which the European Court of Justice engaged with Article 22 last year, the court stated explicitly that in addition to this general objective pursued by data protection law, Article 22 additionally pursues this objective of protecting individuals against the automated processing of their personal data, right? So it's specifically a protection of the individual when AI systems or other forms of solely automated data processing are being used. Now, let me look at the last area of EU law that I wanted to talk about today. And this is, of course, the Artificial Intelligence Act, right? So there's no specific explanation duties that arise for general purpose AI models. There's a transparency obligation in Article 50 that doesn't go beyond transparency. So this essentially just requires you to disclose generative AI in some circumstances. And then there's Article 13 of the AI Act. There's again discussions as to whether Article 13 can be interpreted to create an explanation duty. Some people have argued that yes, and some people are arguing that this is not the case, right? So again, it's an open question to what extent this could actually or would actually require an explanation duty. So let us look at the text of this. So the first paragraph of Article 13 states high-risk AI systems. So this, of course, sorry, I should have said this before, right? This only applies to high-risk AI systems. This is part of the high-risk regime. So it tells us that high-risk AI systems shall be designed and developed in such a way to ensure that their operation is sufficiently transparent to enable deployers to interpret a system's output and use it appropriately, right? So the big question is, what does interpretation mean, right? And it's, I think, a question that's particularly difficult to answer because we have this mixing of transparency here, but then also interpretation, which is typically taken as a synonym of explanation duties, right? And at least traditionally, for instance, if you look at the NIST framework or other standards and generally the way in which people have thought about different ethical and legal obligation in relation to AI, generally there's been a distinction between transparency and explainability, right? Whereas if at some point the European Court of Justice argues that Article 13 also creates some sort of explanation duty, then we have sort of this overlap of both obligations in this article, right? So some people have argued that, well, yes, maybe this means that you need to explain the output of an AI system. The same case has been made in relation to the second paragraph of Article 13, which tells us that high-risk AI systems need to be accompanied by instructions for use that have to include various things, inter alia, where applicable, the technical capabilities and characteristics of the high-risk AI systems to provide information that is relevant to explain its output, right? So there you have the word explain. Clearly invites some interpretation that this might amount to an explanation obligation, and then also where applicable, information to enable deployers to interpret the output of the high-risk AI system and use it appropriately, right? So the big question is, how will this be interpreted going forward? I think the first thing to look towards are the standards. Standards, as most of you will know, will be the flesh on the bones of the AI Act. They're being worked on now. The expectation or the hope is that they will be ready by the time that the AI Act enters into force. And those working on the standards right now, they need to determine, you know, what does sufficiently transparent mean from a technical perspective? To what extent is there some kind of explainability obligation that might derive from any of these things? So it might be that the standards actually give us a pretty clear and workable interpretation of these terms and a pretty clear and workable indication as to whether an explanation is required in relation to an AI output. I think the more likely outcome is that standard makers don't want to read any of these things into the AI Act, and that we end up with various kinds of processes that need to be followed in relation to Article 13 and other provisions of the AI Act that don't really touch on this ultimately normative question as to whether there's a need to explain how an output is being reached. So again, putting the AI Act into perspective and thinking about it along the same lines as I did in relation to EU administrative law and data protection law, the RECSAI here are providers of systems. We can again say that there's no legal certainty as to whether there is an explainability requirement or not. Maybe we'll know more 2 years from now when the standards are there, maybe not. In any event, the AI Act also does not, the Act itself, right, does not prescribe that any particular kind of explanations that would be needed. It does not state you need to be able to globally explain a model, right? And what is the rationale of explainability under the AI Act? I think it's a bit different than in relation to the first two. So first of all, it's a means of legal compliance, right? So Article 13 is also a means that is designed to sort of make it easier for providers to comply with other provisions of the AI Act to the extent that it forces them to make the process transparent and sort of explicit and understandable what's going on. And similarly, I think that Article 13 can also be seen as a vehicle that allows market surveillance authorities within the member states to carry out their enforcement powers. Right. Then briefly concluding, as I realized that's just me standing between you and lunch at this stage. So ultimately, I think the only global conclusion that we can reach when we try to determine to what extent EU law creates an explanation duties for AI systems is that we can't say at this stage, right? I mean, these are areas where we don't really have legal certainties. It's areas where pieces of the puzzle are still missing, like the standards in relation to the AI Act. Even if these legal questions will be answered, right? So even if we have a judgment, say 2 years from now by the European Court of Justice that says Article 22 GDPR actually does require you to explain how an input is translated into an output by an AI system, then we still won't know what this actually means from a technical perspective, right? So it's certainly an area that will continue to be characterized by just lacking certainty. But similarly, in any event, I think we also have to conclude that EU law does not prescribe any specific kinds of explanations at this stage. So at least at this stage, sort of corporate actors that want to make their decisions, their AI outputs explainable, have sort of a lot of freedom as to how they would want to do so from the perspective of these areas of the law. Right, I'll stop here. Thank you so much.
Thank you so much, Professor Fink. We'll take a few questions. Start right here. Yeah. Oh, we can start right here.
Should I give the mic to someone? Or? That's it. Whom do you want to?
Start right. Yes, we'll take. Could you raise your hand again, please, if you have a question? So we'll take 2 at a time. So I'll go here next.
Thank you. I wanted to go to your last point about corporate actors, and I'm not super familiar with the EU AI Act. I noticed that different from administrative law or the GDPR, in this case, it seems that the obligation on Article 13 would apply to developers. And then I'm just thinking ahead, if it's not so clear and we're waiting on, for example, court decisions, how do you see this dynamic where maybe from this article you would have one corporate actor demanding from other? You would have a deployer demanding from a developer that before they deploy, if they want to buy an off-the-shelf system, that they can do that. They can be safe by knowing that it's explainable. How do you see that dynamic versus with natural persons, such as like in the case of GDPR? Thank you.
We'll take the second question here in the back.
Yeah, thanks for the presentation first. And so I'm more a technical person. So my question is also a bit more technical because I'm grappling with like how to create like this transparency and explainability from like the technical perspective, like you said. And I was thinking, do you think it would be a good thing to say, if you want to release a model or like an AI product, you have to also release like a significant amount of the training data to make it transparent, you know, and look for biases in the training data, accompanying with enough documentation. That would be my question.
Yeah. Right. So do you want me to answer these two?
Oh,
Right.
please.
Okay. So I'll start with the first question. So there's a distinction between the sort of personal scope of application of the AI Act and the GDPR, right? So the GDPR, it creates this right again, solely automated processing to data subjects, which by definitions would be natural persons, right? So if a right to an explanation can be read into Article 22 GDPR, then this would be exclusively a right for individuals, right? Article 13 of the AI Act is very different because it requires this transparency and arguably explainability, right? This is the point we don't know about yet for deployers. And if you look at how deployers are defined by Article 3 of the AI Act, then it specifically excludes, for instance, consumers. So it explicitly consumes private actors or natural persons sort of acting in a personal sphere. So the objective there is very different, which I think why the rationale of Article 13 is also not the protection of the end user or of the person subject to any decision that might need to be explained, but it's really more, it fulfills really a more systemic role in the AI Act, right? So it's designed to create transparency and arguably explainability for deployers and for providers as a means for them to be in a better position to comply with their other obligations under the AI Act, but also as a means for market surveillance authorities to check whether the AI Act has been implemented with. Now, regarding your question, so I think we can't read these requirements into at least Article 13, right? I mean, there's other documentation obligations that apply on the AI Act that you would need to comply with. Regarding the release of the training data, I mean, there's this like really difficult trade-off between this being amendable to transparency and arguably explainability, but also potentially personal data, for instance, forming part of your training set, in which case you shouldn't or you must not sort of publicly release it. So I think this is a really context-specific question, and it largely depends on what data you've used to train the model.
So we're running out of time, so I'm going to do a lightning round. If you could please state your question very briefly, and we'll do them all together, and then Professor Fink will respond, and then my co-chair, Professor Hacker, will have a comment before we go to lunch. I'll start with you, Jeremiah.
Thank you, and I can shout so somebody has to pass my. Thank you, Michelle. Super interesting presentation. Got me thinking about the institutional dimension as well, of course, because ultimately a lot of the sort of grey areas you find out will have to be sorted out by the Court of Justice.
Yes.
And or through the preliminary procedure. And I think it'll be super interesting to see how these cases end up before the court, whether the court ends up as well just dealing with the legal requirements directly under the reference, or whether the court ends up having to do it by itself, de novo, as it were. I was just wondering what your thoughts were on the institutional perspective and capacity in tackling that.
You mean in terms of predicting what will?
Just whether the court is actually up to that task, or whether, you know, the different routes in which, whether it's 234 or 267, the routes with which it'll get to the court might actually make a huge difference to the outcome of litigation.
Yeah, I mean, I think most likely we'll see these questions as part of preliminary reference procedures. I would think. I don't know. Maybe you have a different take on this, but I think this is what's most likely to happen. If I had to predict, I think we'll first see it in relation to Article 22 GDPR, and I'm not sure. I mean, I think that you can't really predict how the court will decide this, to the extent that in Schufa you have this really interesting phenomenon where the court says, oh, this is Article 22 GDPR, and then we also have recital 71, which sort of creates these safeguards, but it's just mum on on recital 72, probably because it didn't want to state sort of specifically what it says in relation to this. So I think in Schufa the court sort of made this decision to not preempt any future decision that would take on Article 22, probably because it was deemed too controversial. But yeah.
So unfortunately, we are very much out of time. I'm going to ask those with additional questions to reach out to Professor Fink bilaterally, if that makes sense for you. And if
yeah, sure,
Professor
happy
Fink
to.
has time, My co-chair, Professor Hacker, will have a comment about the next session before we go to break.
Yeah, thank you. So this was really an inspiring session from an industry perspective to, all the way to the intricacies of explainability. And we know that explainability is getting even tougher as we enter the age of generative AI, where there's multiple dimensions of explainability you could think of. And in fact, just to add on to the complexity that Michelle just mapped out, there is a recent ruling by an appeals court in Amsterdam in the Uber and Ola cases that Michelle also knows very well about. And the court actually says something along the lines of the explanations need to be given for a complex scoring algorithm that Uber uses to score its drivers, performance of its drivers, including the weights in an aggregate manner such that the individual drivers can challenge the decisions, which is quite perplexing because if you think about it in machine learning terms, an aggregate score, that would be a global explanation, whilst you would think that you actually need a local explanation pertaining to the specific case at hand to actually challenge the decision. So it seems like the court, consciously or not consciously, is arguing for both a local and a global explanation. If you look at support vector machines or, of course, deep neural networks, that will get increasingly difficult, not even to speak of, multi-layered transformer models. So we're entering really into an era where we're in the explainability front, these technical provisions and the EU law are about to clash just a little bit, I think. And we will explore this a little further from a global dimension after the break. So I'm just gonna make this one announcement. We have an absolutely exciting panel coming up. Rachel Adams just entered the room, I think. So she will be up first with a perspective from the African Observatory for Responsible AI. I hope I got this right. That was just founded and basically represents a fabulous majority world perspective on AI globally, responsible AI more concretely. And then we will have two experts from the EU. And you might have heard that yesterday there was an announcement about the AI office, basically the institution that will be in charge of supervising and enforcing the AI Act. Now we're, I guess, the first panel to actually host a specific person from the AI office. Sabrina Cuthbert is going to join us. She's part of the AI office. She will be here to answer your questions and to speak about AI implementation jointly with Kite Senna from the European Parliament. And those who know him will know that he's actually the architect behind many of the provisions of the AI Act. It's not exactly, the final outcome is not exactly what he had in mind. He'll tell you about it, but he's one of the most knowledgeable persons on AI regulation in the EU. So we're looking forward to those panels, and then a fantastic industry panel also with Dieter Chen from EY and Isaiah from SAS also. And so please stay tuned. And now we adjourn for the lunch break and we shall return.
Before we adjourn, I just want to mention that Professor Hacker himself also recently published recommendations for the EU AI office, and they're very aligned with things that we will discuss here today.
Oh yeah, everybody's publishing something these days, I guess. So, so thanks so much for being here in the morning. We'll see you again at 2 o'clock. Hello, hello, and welcome back. Thanks for being here after the lunch break and for not taking a nap right now, but rather listening to our exciting speakers who are about to tell us more about AI, ethics, regulations, and the interplay from a more global perspective. So as our first speaker, it is really a great honor to have with us Dr. Rachel Adams. And if you know anything about AI regulation from a global perspective, I don't need to introduce her. But in case you didn't know, she's now the founder and CEO of the Global Center on AI Governance, which is, I think, the first global center on AI something that's located in Africa. And that's great. And we hope to see many more of those. And she's also leading numerous efforts with the Global Index on Responsible AI, with the African Observatory on Responsible AI, and many other institutions. I'll stop here to make room for her talk, which we are anticipating and which will tell us a little bit about the global index on responsible AI that she has been constructing for the last couple of years. And we're really absolutely thrilled to get a sneak preview of this. This is not something that will be shown on the main stage, not like this. And she's been to a number of talks here already. She will have more. But thanks so much for sharing with us some intimate insights and details from this index. Rachel, many thanks for coming all the way. The floor is yours.
Thank you so much, Philip, and thank you, Sarah. It is very, very exciting to be here. I'm going to be talking about a project that I've been leading for the past 3 years. It was a really daunting project to begin with. It's funded by the UK, Canadian, and US governments, their development ministries, although disclaimer, they are not involved at all in designing or the results of this work. But it's been a hugely daunting project. So 3 years ago, I was asked to design a conceptual framework, a measurement framework for responsible AI, and then measure it in as many countries around the world as we could. And as you all know, responsible AI has become more and more and more of a thing over the last 3 years. I think what's really exciting about this study is it allows us to say, okay, this thing we've been talking about, this really big idea, this is the empirical data that underlies it. This is where the world is at in terms of responsible AI. This is how far it is just a talk shop, it is just an idea, and this is how far it really is happening. And yeah, I think some of the exciting kind of insights that we're getting from this report is what are countries outside of the European Union. We hear a lot about the excellent regulation that is happening in the EU, and that it is, but it's not the only gold standard. And it shouldn't be in places where there are different kind of cultural contexts, different kinds of legal regimes, and different kinds of issues and risks and challenges. So part of what we wanted to do was create a kind of massive database and repository of examples and instances of what responsible AI looks like outside of Europe and outside of the US and North America. So I'm going to talk you through this exciting project. It really is exciting because we're only launching officially next month on the 13th of June at the Global Digital Development Forum in Washington. It was considered too divisive to launch the results sooner or at forums like this. So I'm not going to be talking about the rankings, and that will come out on the 13th, but the other insights I will talk to you about. And this is kind of the first public time that we're talking about some of these insights. If I can move the slides, I'm really struggling to move forward. So maybe Philip, I don't know whether.
Now, try again.
Okay. Well, we don't need to go over that overview. So I think I've spoken a little bit about why we've done this study. We want to support the implementation of responsible AI. We want to ensure that it becomes a real thing and not just a really cool idea. And we want to understand what difficulties governments are facing in trying to implement it and what implementation looks like in different parts of the world. We really want to support better international cooperation around AI for good. It is a really, really big idea to ensure AI serves equitable outcomes and helps to address the Sustainable Development Goals. But unless we're centering the expertise and insights of the places that we truly want to serve, we're not going to be able to do that in a just and meaningful way. So we need to fill these data gaps. We want to measure progress over time. So this is the first edition of the Global Index on Responsible AI. The second one will come out in 2025. We've already begun the process of refining our conceptual framework, and we'll begin data collection quite soon. And then the idea is that by 2030, we have 6 editions that gradually gets better and better as we refine our measurement approach and framework, so that we can really look at what is the relationship between responsible AI and meeting the Sustainable Development Goals. So this is really the kind of baseline of establishing a measurement framework to do that. It doesn't go all the way, but it gives us a start. And then we want to see, is responsible AI possible? And is it possible everywhere? So we designed a conceptual framework that split this idea of responsible AI into 3 dimensions across 19 thematic areas with 57 indicators. I'm going to go through that conceptual framework in another slide. We collected data through designing a very long survey, and then recruited country experts in every single country that we worked in. It was more than 138. We dropped a couple of countries because data quality was not strong enough in a couple of countries, who then spent months and months and months completing this rather tedious but very important questionnaire. The data is only up until November 2023. We had to do a cutoff date because there was a very rigorous process of data quality assurance and checking what was over 500,000 data points in the end. So I know there's been a lot of progress since November 2023, but don't worry, it's captured in the 2nd edition, and the 2nd edition will come out next year. We have 138 countries included in the final index, with 41 from Africa. So this is really major. We are gathering and filling data gaps that we knew very little about what was happening in very different parts of the world. And part of the work I've been doing recently is supporting the African Union to develop their regional continental AI strategy, and having data about what's really happening in their countries has become very valuable. And yes, over 500,000 data points. So this is the largest global study on responsible AI to date. So this is quite hard to read, I'm sorry, but this is our conceptual framework. This is before some of the nice data visualizations and design work that's all happening at the moment. Our web developers are very busy trying to make this look far prettier and far more readable. But we split up the concept of responsible AI into 3 dimensions: responsible AI governance, that covered national AI policies or strategies, AI impact assessments, and then some of the kind of key AI principles, AI ethics principles: transparency and explainability, accountability and responsibility, proportionality and do no harm, human oversight and determination, safety, reliability and accuracy, public procurement, and access to redress and remedy. So that was the first kind of big solid dimension. And then the second one was on human rights and AI. This is really an index that's interested in, are human rights being promoted, protected, and respected everywhere as AI becomes used and deployed and monitored in different places around the world. So what we're really at the topmost interested in and care about is the promotion and protection of all human rights. So not just civil and political rights like data protection, freedom of expression, access to information. We're also interested in the rights of future generations, the rights of workers, environmental rights, socioeconomic rights. You will see a list of human rights here that is not as expansive as what I've just spoken about. This is because we did collect data on AI in health, AI in education, AI environmental protection. There were a couple of others. But actually, I mean, I think this is partly because our measurement framework, what we asked researchers to look for, was not precise enough, but we generated a whole load of data about all these different policies and frameworks and actions that governments around the world were doing to promote AI in health or promote AI in education. And it was not conclusive that it was being done responsibly or advancing human rights. So we have this data, and we're going to make sure that all of the data that I'm talking about will be freely available on our website by the 13th of June. But we decided not to score some of those thematic areas. So as we go, we're not going to talk about the rankings today. I'm very sorry. Please tune in on the 13th of June for the rankings. But we have to be very careful to ensure that the data that we include in the rankings is precise and accurate. So we've collected that data, and in the 2nd edition, we're going to refine that much more carefully. So we've still got data protection and privacy, gender equality and AI, children's rights, cultural and linguistic diversity, labor protections and the right to work, bias and unfair discrimination, public participation and awareness. And then the 3rd dimension is on responsible AI capacities. So as we are particularly interested in what countries outside the West are doing, we have to be thinking about how are countries around the world building their capacity to be ready for the responsible deployment, use of AI, etc. Again, we'd had a number more thematic areas under this dimension and decided not to score them in the end because they were not conclusive enough. So for example, we had oversight institutions here. And the evidence that we got for oversight institutions, there were lots of great things being done. There was the FTC and various other institutions that we can be really proud of. Sabrina will talk to us about one we can be very proud of. But there were others that were definitely not independent, and it was really not conclusive. We couldn't conclusively compare and include all of them. So the thematic areas that we have kept for responsible AI capacities is international cooperation, public sector skills development, and competition commissions. These thematic areas, I should say, the conceptual framework and building that was quite a process. So when we began in 2021, the UNESCO recommendation had not yet been endorsed and published and signed. It was by the time we finalized our conceptual framework. So it was a really, the UNESCO recommendation was a very, very important, probably the most important framework that we used to develop our conceptual framework, partly because it went through this very extensive, globally consultative process to develop it. There were also the OECD principles, but a lot of the kind of ideas around what does responsible AI mean and what does it look like and what should be the components of responsible AI were coming out of discourses and discussions that were largely Western. So we spent a long time engaging with policymakers across the global south, across the majority world, different stakeholder groups that were working on human rights-based issues and AI in these countries and in these places to ask, what does responsible AI mean to you? What does it need to include? What should it look like? So this is where we arrived to some of the things like cultural and linguistic diversity. With the advent of generative AI, this became incredibly more important. And also labor protections and the right to work. That was a really significant one that was not emphasized enough. And then some of the other ones were around like the kind of broadening of this idea of responsible AI was an emphasis on the AI life cycle. We had originally in the survey a set of questions around how far are the kind of evidence we're asking you to collect pertain to the whole AI life cycle, but this questionnaire was thousands of questions long and no human can sit and fill it out. So, and we had to have, I think part of what's so interesting about this study is it had to be completed by humans because AI only knows what already exists digitally in the world. And a lot of what we were collecting was information that didn't already exist in the world. But we did manage to assess the entire, well, a large part of the responsible AI ecosystem. Must I turn? Is my mic not good?
Yeah, can we just?
Oh, that's fine. Should I turn this off?
Yes, that would be great. Thanks.
Okay. Yeah, so we measured, we were really interested in not just what a government's doing in any given country, like have they got a framework? Are they doing some kind of legal regulatory thing? But are they implementing it? And so that's government action. So the first kind of indicator against each thematic area was frameworks. Is there a law or a policy, some kind of regulatory instrument? To what degree is it binding or not? And then the second one was government action. So what are governments doing to advance implementation of this particular framework or to advance work in this area? So if it's gender and AI, are they kind of advancing national level programs or kind of supporting conferences or publishing reports? So are there other government-led actions that show that governments care about and are aware of these issues? And then the third indicator is around the role of non-state actors. So what are universities, civil societies, and private actors doing to support the responsible AI ecosystem within any given country? So it allowed us to develop what was really a multi-dimensional study on responsible AI in these different places. So this is the sneak peek of the findings. I'm not going to go into too much detail. about these findings. And in some respects, having them up there and you reading them, you'll be like, yeah, we knew that. We did, but we didn't until this point have the empirical data that stands behind some of these statements. So we know this with clarity. We know this with granularity around what countries are doing what, where are the capacity gaps, where do we need to do more work. So one of the first things we found were that governance frameworks do not mean responsible AI. Just because you're governing something does not mean you're governing it equitably and inclusively. And that global progress on responsible AI is really, really far behind AI development and adoption. We kind of knew this, now we know how far behind it is. And the statistics are quite shocking. So the kind of global country average is around the world is really, really low. And then mechanisms on the protection of human rights in AI are limited. So kind of not just the protection of human rights, but what are the mechanisms in place to ensure these rights are protected and promoted, like impact assessments or public procurement processes that ensure sustainability and inclusivity in the use of AI to help deliver public services that might be human rights, social protections or health or these kinds of government services. They are very, very limited, and there are really, really significant gaps. Issues of inclusion and equity, I'm going to go into this a little bit more, are not being prioritized. So governments are ticking off kind of certain ethical AI principles, transparency and explainability, accountability and responsibility, proportionality and do no harm, but not really kind of looking at, well, what extra protections might be needed for vulnerable and marginalized groups in our society. So children's rights, cultural and linguistic diversity, bias and unfair discrimination, gender equality. These are some of the lowest performing thematic areas globally. On the more positive side, international cooperation is a really important cornerstone, and almost every single country in the world had some evidence of cooperating globally on responsible AI or making commitments to do so. And the most important mechanism in terms of global reach was the UNESCO, was the work of UNESCO on AI ethics. Gender equality was a very poorly performing thematic area. I think a lot of governments have kind of thought gender falls into bias and unfair discrimination, but we were very deliberate in having a separate thematic area on gender equality. Governments need to be aware of the particular gendered impacts of artificial intelligence, and very few are. AI workers that are subject to, I think we heard of the algorithmic boss this morning. But there are very few countries that have frameworks in place to ensure labor protections. So not just kind of job displacement issues, but labor protections for people who are subject to AI in the workplace. There was quite a lot on skills development, but we were less interested in how governments are trying to upskill their workforces and more interested in what protections they have considered or have in place for workers who might be in the gig or platform economy or just subject to AI in the workplace. I think I mentioned this before, but issues of inclusion and equality in the kind of what responsible AI looks like at the moment is not being prioritized. So responsible AI at the moment globally looks like we're going to talk about transparency and explainability, responsibility and accountability in our national AI strategies, but we're not going to ensure that marginalized populations are not harmed. That's what it kind of broadly looks like. Cultural and linguistic diversity. I mean, I think one of the interesting things we found is how many countries have got like really interesting efforts to promote the use of AI to preserve cultural heritage or to promote the development of large language models or smaller language models in local languages, and just finding out some of what these efforts look like and what countries are like taking this very seriously was super, super interesting. And then the last one that I've got here, there were more global findings, but I can't give you everything. I mean, you need to wait for the 13th of June and hopefully log in. The last one was the role of universities and civil society so if each thematic area measured government actions, government frameworks, and then the role of non-state actors in some of the kind of areas that are very human rights inclusion orientated, like gender or bias or cultural and linguistic diversity or labor rights, you can see that actually the most a country has is in relation to the work that universities and civil society organizations are doing. So they're really, really filling gaps, but they are not enough in and of themselves. So I'm going to do a couple of deep dives that aren't that deep, but go into a little bit more detail about some of these issue areas. And you can see some of the kind of findings that we have here. So yeah, I've explained this a little bit, the kind of lack of priority for inclusion and equity related issues, but this graph shows the number of pieces of evidence we found globally in 138 countries around some of these different areas. So for example, there are 33 companies globally, countries. I really would like the second edition of the Global Index to measure companies. So if anyone's interested in that, then please talk to me. But the first edition measures countries. So there are 33 countries around the world with frameworks that address labor protections and the right to work. But you can see that there are 64 that have civil society or non-state actors that are working positively in this area. So that's where you can kind of see this gradient of the ecosystem. Children's rights, you can see, is quite a low performing area. Only the top countries that ranking globally had kind of properly considered children's rights. So if you want your country to do better on the global index, make sure they're addressing children's rights, gender equality. These are some of the things that will bring up their score. And you can also see that gender equality is the poorest performing thematic area here. This is not all of them, but these are some key human rights related ones. The poorest performing one in terms of government frameworks. So just having this kind of evidence that shows, okay, only 24 countries around the world have considered gender equality to be an issue that they include in their policies or their frameworks or some kind of governance response is actually pretty shocking. Okay, so we're going to dig a bit deeper into this one. So this just shows a further breakdown of what we saw in the previous slide. So there were 37 countries that were doing something that kind of recognized that this was an issue at a government level, including 6 in Africa. And we're going to talk a little bit about what Senegal is doing, as they are one African country that has included issues relating to gender in a small way in their national AI strategy. But maybe Togo will be next. And then you can see just how far the role of civil society and non-state actors is pulling up the evidence and pulling up that balance between this is number of countries with evidence and without evidence, and it's really hard to see because we've not had our beautiful web developers make this look nicer. But when you log in on the 13th of June, this will look really cool and it'll be easier to see. But you can see the kind of number of countries, 114 countries that have just not got anything in relation to gender and AI, 141 that have not taken any action. But there's less countries that have no civil society or universities or private actors working in this space. This generative AI was a kind of core theme for today, so I thought I'd pull this out. This was another non-scoring thematic area. And the reason this was non-scoring was that when we collected data up until November 2023, this was still a very new and emerging area. So we may include this as a scoring thematic area with a more focused conceptual framing of this measurement area in the second edition. But it's really interesting to see, for example, this is just the number of countries in the global south. That's what I'm particularly interested in. There are many other countries that are doing things, but these are countries in the global south where their governments have said, okay, this is something we need to take note of, and we're thinking about this. So quite a number. And then Dominican Republic, Malaysia, Mexico, and Peru have already made commitments in government frameworks in relation to generative AI. So I'm going to just go a little bit, 5 minutes, that's fine, That's fine. I'm getting towards the end. I'm going to go a little bit into the findings for Africa. This map is demonstrating the number of evidence in each African country. So it kind of shows how active are these different African countries with respect to responsible AI across the whole ecosystem. This is not the rankings, don't get excited, but for clever mathematicians, you may be able to work some things out. But you can see South Africa, Senegal, Morocco, Tunisia. I'm going to read some of this because it's impossible to see. Benin, Egypt, Kenya, Nigeria, Ethiopia, Rwanda, Libya. So those are the kind of top, what is that, 10, but that's not the scoring. I actually know that's not the scoring. So, but those are the top 10 countries in terms of the amount of evidence, the amount of kind of different kinds of activity. The reason that doesn't equate to the scoring is that there's a different weighting. Government frameworks weighed more than government actions, and then non-state actors didn't weigh as much. They had a lower weighting than government frameworks or actions. And then just to go into a little bit more detail on Africa, kind of some of the high level findings was very little emphasis on kind of human rights related issues, risks and harms of AI. And I can attest to that with the work I've been doing with the Continental AU AI, African AI strategy. I think, yes, that's what it's called. Where, you know, the kind of overarching emphasis is on the benefits that AI can bring, and there really are important benefits, but the risks are arguably greater. And so that's really worrying. The risks are greater because there's not representative data, there's emerging democracies with kind of new and not as well established institutions to protect and ensure human rights. And there's lower levels of AI literacy. So these are all factors that make the use of AI in countries across the African continent more risky. But the hype is really, really there and really strong. We have, at the point of data collection, I think there's been more since this time, since November 23, but there's 5 countries with AI strategies, and they all include references to public procurement. So yay, we think that's really, really important. Impact assessments, accountability and transparency. Egypt, Kenya, Mauritius and Rwanda are all investing resources and skills to enhance local AI governance capacities. There's important kind of contributions from the AI ecosystems in South Africa, Kenya, Libya, Nigeria, Niger, Cameroon and Burkina Faso. And then the continental AI strategy is really set to be an important framework for the continent overall. I won't go too much into some of these bright spots because I know we're running short on time, but part of what we wanted to do was highlight what is happening, what does responsible AI look like in different places. So Senegal's national AI strategy includes a number of things, including ensuring the promotion of skills development for women in particular. So we thought that was quite interesting. And then they've got other kind of principles articulated there, like proportionality and do no harm. There's quite a lot of emphasis on responsible AI research and development, and they've got this digital technologies park that's part of seeing some of that work through. Gender and AI, I've pulled out 2 examples that we found from non-state. I think this is a non-state actor, the National Council for Human Rights in Morocco, but I would have to check because if it is a state entity, it would have come under government actions. But in Kenya, we've got SIPIT and a report they produced, and then in Morocco, it's the National Council for Human Rights has also done a report that recognises the particular gendered impacts of AI, including violence against women in the digital space. So some of the lessons that we learnt was that this kind of a lot of the evidence we found and a lot of the thematic areas that we were asking to be addressed were ticked off through national AI strategies, but we found that the governments that scored better were those that had deliberate, human-centered, rights-focused frameworks unpacking, for example, children's rights. So we would like to see more of that. And then beyond frameworks taking into account the role of the national AI ecosystem and just seeing how far universities and civil societies were bringing up the scores for countries showed us that this was a really, really important thing to measure, and we want to be doing that more in the next iteration. That international cooperation is such an important lever for addressing what is discernibly an AI divide globally. So those countries that score and rank well, that are doing a lot of very important and leading things, need to use their influence to help everyone everywhere. And then there are really significant variations in, like, when you look at the overall scores of these 138 countries, there's this like small cluster at the top of high performing countries that performed well across all these different evidences, what we call pillars. And then at the bottom, there's like a huge cluster of countries that are performing really badly. But in the middle, there's this huge kind of variance. So you'll have countries like Japan, who don't have many frameworks, relatively speaking, but they've got loads of government actions. And then you'll have countries like Slovenia, I think it was, that had quite a lot of frameworks, but less government action. So what this actually demonstrates is that there are many different paths to achieving responsible AI. And that's what we're interested in. We're really interested in what are the different pathways for responsible AI, so that this huge cluster of countries at the bottom can see there's different ways of achieving and going forward with this work. This is the last slide, Philip. But this is about what we have coming up. We launch on the 13th of June at the Global Digital Development Forum with USAID in Washington next month. Then we will publish all the data online. It will be free to use and access and play with on our website, global-index.ai, or you can go through our new Global Center on AI Governance, which is globalcenter.ai. We will be publishing various kind of thematic and regional reports. We've worked with 15 regional partners, largely from across the Global South, leading research institutions working on AI and digital issues. So they will be supporting us in publishing more close analysis on the data from different perspectives. And then we start work on the second edition and the data collection for that. We're going through a really big kind of review process of what worked and what didn't, and how we can define more clearly and measure more clearly and do better on the second edition. So yeah, I will pause there. Thank you so much.
Thank you. Thank you so much, Rachel. This was incredibly insightful, and I'm already looking forward to the launch. I can't remember what date it was. Can you say it again? I think you only mentioned 10 times. So
the 13th of June.
Oh, the 13th of June. Yeah, I almost forgot. Yeah. No, it's all great. I mean, wonderful. And I'm really looking forward with bated breath to see how different countries are scoring and what kind of actions are actually backing up their rhetoric or not. So now we'll switch perspective and gears just a little bit, tuning back into the European ecosystem, where we do have a framework in place and less actions so far for making it happen and enforcing it. But gladly speaking, as I mentioned before, the European Commission has announced the installment of the AI office just yesterday. And miraculously so, we have the first representative of the AI office here with us, Sabrina Cuthbert. Wonderful to have you. And online, maybe we can put this up also, we have Kai Zenner. So I'm just going to introduce both of them real quick. While Swarth is kindly bringing up the slides. So Sabrina is originally a researcher, did some degrees at Oxford in AI and economics, and then went to the Commission and also worked on the AI Act file on the side of the Commission, and has now transitioned as one of the first employees, I guess employee number, I don't know, 5 or 3 or 1 of the AI office. So it's great to have somebody here from such a newly founded office, which will be absolutely pivotal, not only for Europe, but for the entire world, at least for anybody who is seeking to offer models or use the model output within the European Union. And then we have on board as well from on the internet, online, Kai Zenner. Maybe we can even put him up so that we can see his image as well. Maybe the IT could do that. He unfortunately can't be with us today due to personal circumstances, but it's so great that he made the time to, in his incredibly busy schedule, I should say, to tell us more about how the AI came about and where it's heading and what's the good and the bad about it. Kai is probably a person I don't have to introduce here. He's probably one of the foremost experts on AI policy in the EU and worldwide. He has partially written the AI Act, but only the good parts, of course. And so we are terribly glad to have him and Sabrina kind of subbing in and out. And as I understand, they'll be giving this talk together about something related to an EU perspective on international regulation. Many thanks for coming all the way, and the floor is yours.
Thanks so much, everyone. And thank you, Philip and Sarah, who's somewhere, I'm sure, for having us. I hope we can see Kai in a bit. He unfortunately couldn't make it, but we wanted to give you today some EU perspective on international regulation. So as I am part of the European Commission, I'll outline to you a little bit what our current approach is to generative AI in the AI Act, but also in the current work of the European AI Office. And Kai will react as a political figure in that space as he's at the European Parliament. And we can, I think I can move the slides. Let's see if that works. Yes, perfect. So as many of you might have heard over the last months, if you check your AI governance newsfeed, the AI Act happened. In December, we reached a political agreement between the European Commission, the European Parliament, and the member states for this first ever comprehensive legal framework on AI. In the AI Act, we take a risk-based approach, which means that the European Union thinks that many AI use cases bring a lot of value to society, but then in a few instances, there might be risks occurring and a couple of just outcomes that we might want to positively influence. And for this, we outlined harmonized rules across 27 member states across the EU. And this law will actually enter into force towards the end of June, at the beginning of July, based on like the last steps that need to be taken. And this AI Act is focused on ensuring safe and trustworthy AI. That's the heading under which the European Union is operating here. And we are building a strong European AI governance system, which means that at an EU level, we will have the European AI Office within the European Commission as the EU level enforcement structure. And then we will collaborate with the 27 member states who will also set up their structure. So it's going to be a huge European team working on making this happen. And as this is today a lot about the international approach, we as the European AI Office, we also want to contribute to a global approach to AI. So this is about that the European approach can be seen as a global reference point, but of course we're also engaging in multilateral fora and bilateral engagements. As today is about the generative AI and regulation intersection, I'm going to talk about how the AI Act wants to create trust along the entire Gen AI value chain. When you look at the large AI models that have influenced the narrative over the last year, then we understand this to be that these models are being that have like many, that can perform many tasks, right? And they can then be implemented in many different use cases. So for example, you take a model of Mistral AI or OpenAI or many of the other providers, and then they would be adapted, for example, in as a chatbot to support in questions around health issues, or they would be applied at some point in finance. And so that's the value chain that we're looking at, from these general purpose AI models to AI systems. And the AI Act started out looking at the AI systems first. So that's like where this AI came from historically. And here we established this nice pyramid where you can see that actually a lot of AI systems will be minimal or no risk. So they will be permitted without any restrictions. But then there are a few that have to follow certain rules if they're being provided in the European Union. And if we go up to the yellow level, then you see that some have certain transparency risks, for example, looking at chatbots or deepfakes, I'll go into detail later there, which are permitted, but they have to establish certain transparency to the user so that every one of us knows that what they're interacting with and that they're interacting with an AI. Then another set of systems, they're considered high risk. So for example, if you see an AI system that's being used in recruitment and that might scan at some point through CVs and score them, right? That could actually be a high risk case in recruitment. And we want to be sure, as part of the AI Act, that these systems then follow certain rules. And so there are certain requirements and a conformity assessment to be done. And then there are also some unacceptable risks that are simply prohibited, such as social scoring, but that's a very tiny fraction. And then in the AI Act, we said, okay, but look at the recent developments. And these were actually general purpose AI models that are suddenly becoming parts of all the other AI systems, or some of them. And here we established transparency rules, which means that there just should be better documentation, for example, so that anyone who wants to use these models, they can actually build on it in a better way and also in a safer and more trustworthy way. And then we single out a few models that might pose systemic risks to the union, and we impose certain oversight in light of these risks. But I'm going to go more in detail into that in a bit. And so this should just establish trust along the entire value chain so that from the models to the systems, we can trust AI. So a short deep dive on the rules for general purpose model providers. That's actually the area of research I'm coming from before I was working with the European Commission. And here we have these two levers. So lever number one, for all general purpose AI models, there are certain light touch transparency rules. So they have to write down certain types of model cards. So we will establish just like a way of how to write them, and they need to facilitate enforcement for copyright rules. Here, for example, open source models are partially exempted because we already consider them to be pretty transparent. And then we say a few models in the world might pose systemic risks. We set a threshold for the nerds here in the room. It's at 10 to the power of 25 flops. And above this threshold, these models would be presumed to carry systemic risks. And here we establish additional rules and oversight, and providers of such models, they now have to manage the risks. They have to evaluate their models, they have to establish cybersecurity protection, and they have to tell us when there were serious incidents. And so now on the legal basis of this, the AI office can actually engage with the providers. And just the last one, because it impacts us already every day when it comes to chatbots and deepfakes. In addition to all the other rules on AI systems, we also said that we as users, we should be made aware that we're interacting with a chatbot. And for deepfakes, an activity is that AI-generated content should be identifiable. And this should not hamper the enjoyment of the work, but it's still very important so that we can trust AI. And now I'm handing over to Kai, and I'm very much looking forward to your reactions to this.
Thanks, Sabrina. And yeah, I'm sorry from my side that I couldn't come in person. I think you see it. Maybe I got a nasty eye infection from the kindergarten of my son and unfortunately needed to cancel everything. But yes, as Sabrina was mentioning, I would introduce now some political remarks, but also link our presentation to the international level as our title for the presentation is indicating. Maybe firstly to the European AI Act. I was working, like Philip was nicely saying, now for 7 years on this law in the prep work and then in the discussions and so on and so on. And yeah, I have really mixed feelings if I'm now looking at the outcome, especially with regards to the Gen AI chapter. There is, first of all, on the pro side, really a huge improvement if we compare it with other digital laws. You can really call it a new type of EU digital lawmaking. There's strong international alignment. If you look, for example, at the executive order and the AI Act, the language on foundation models or general purpose AI models is not so different. And well, it will help us later on if we are trying to align again. We secured also, Sabrina was partially mentioning it, the idea of a fair burden sharing along the AI value chain, which I think has huge potential to really change a little bit the market economy, the digital markets, and also enable smaller market players to play a bigger role again. And lastly, the AI Act is principle-based and also much more future-proof because it's easily adjustable via harmonized standards, via secondary legislation, and so on. On the negative side, I think if you are reading the AI Act, and most of you will have done so in the last weeks, it really shows or creates a lot of legal uncertainty. We heard it in the morning sessions already that the horizontal new legislative framework approach, so this product safety law that the AI Act is built on, is probably not really a fit for something that is evolving. It's working for washing machines, for vacuumers, for toys, but an AI system, and in particular something like a foundation model, doesn't really seem fitting for it. There are also various overlaps and contradictions. It was also shown in the morning already with other existing laws, and we don't really know how those laws are connected to each other. There are a lot of extremely vague definitions. If you look in the annexes, for example, the documentation requirements for GPI, you have a lot of question marks in your head, I'm sure. And also there are extremely unclear procedures, for example, how to designate a systemic GPI model provider is not really clear. And I think more time should have been spent to make the AI Act or to improve the AI Act legally speaking. So right now, even though I tried it, a full assessment of the AI Act is not really possible because the secondary legislation, which is a pro, but at the same time a con, is not there yet. And therefore the AI Act is really, now that it's entering into force, a first episode of a long journey that we will continue to do. On the next slide, you will see now the link to the international level. Because of the internal assessment that the EU was doing in this prep work before the AI Act that I was mentioning, we identified the problem. Okay, we are lacking on a technology level behind other areas in the world are so far away in venture capital, in talent attraction, and so on, that maybe the only chance that Brussels has is similar to the GDPR to trigger another Brussels effect. So creating an AI law and by doing so, setting globally a regulatory standard on AI. Unfortunately, now that it took so long for us to agree on an AI Act, other regions caught up. They brought up their own ideas. And maybe some of those ideas that we see in the United States, in Canada, and so on, are maybe even better than the European AI approach. Therefore, I would argue that we don't only have now a global race when it comes to AI technologies, but also a global race when it comes to the regulatory front. And this is why you see in the heading, maybe instead of a Brussels effect, we will see in the end a Washington effect. On the next slide, you see now why this is maybe negative for the European Union, because it's kind of preventing us to achieve our ambition to lead worldwide in regulatory terms. While it's bad for Europe, I would argue that internationally, this diversity of policy and regulatory approaches on AI, and especially on Gen AI, is something very positive. Because if you look into the details, you will see that there is already strong international alignment when it comes to the core or baseline principles. On the right side on this slide, you see the OECD or G20 principles that are coming from 2019, and that you can now find in basically all the different regulatory or policy approaches around the world, in Singapore's code of conduct, in the Chinese automatic decision-making law, in Brazil, in the United States, and of course in the European Union. So a regulatory competition that is based on this kind of same principles could in the end maybe create a lot of best practices that will help other regions that are so far not having a regulatory approach on AI to kind of cherry pick from here's something from Europe, here's something from the US, and so on. And basically they can pick the things that are best suited to them. And this is why I think this high number of policy options, and also, as you see on the left side, the high involvement of international organizations is something, as I said already, very positive, and something that potentially will help, especially the Global South, because they have just much more to check and to actually also shape a little bit. Back to Sabrina.
Thanks a lot, Kai. So if I take Kai's words and interpret them as I did joining the AI office, then I would say there's a lot to shape. So we do have the AI Act very soon, very officially in place. But then the European AI office, together with the member states, they will be the ones also interacting at the international stage on these topics. And right now, let's say there are like three big pillars for the AI office. So it's not only enforcing the rules on like generative AI, it's also the entire AI Act and overseeing it. It's about strengthening the development and use of trustworthy AI. And then it's also very clearly fostering international cooperation in this space. So it's important for us to think about AI in a way that it should be trustworthy and safe. And we do want to engage with international like-minded partners on exactly this front, because we are aware that this is not an issue that's going to be solved in one jurisdiction. It's a global effort. And this is also why right now, Philip mentioned it earlier, I'm not the only one in the AI office. So the entire team that was writing the AI Act and negotiating it, as well as our colleagues that work on trustworthy AI innovation, they right now built the cornerstone. And then there will be 18 new hires, new people, new talent to be hired that can shape exactly this landscape. And then the office will grow to 140 or more colleagues that will, be able to shape this. On the international space, because we're often asked also what we bring to the table, of course, as the EU perspective. perspective is that we want to combine technical capacity and regulatory powers. So the ambition is to be the European Center for Expertise on AI at the EU level, to really stay on top of AI advancements, emerging risks, the benefits that AI can bring. And then we can combine this with the power that the AI Act provides us, so the regulatory powers. For example, when it comes to general purpose AI, we can compel access for model evaluations, for example. That's something where others rely a lot on voluntary commitments. And so we really want to leverage this voluntary power, and in that collaborate with a diverse range of institutions, experts, and stakeholders in Europe, but also globally. And for this, we are engaging in a lot of international cooperation. I won't go through all of them, but you can see that there are a lot of multilateral to the left, multilateral fora, and to the right, bilateral engagements. So for example, one of the efforts of the last year were the G7 Code of Conduct for Advanced AI Systems, where we engaged with our G7 partners to already lie down a code of conduct, where you can find some elements, especially when it comes to how to define systemic risks, also in the AI Act. And then, of course, Council of Europe, the AI Safety Summits, where colleagues of mine have been engaging at a technical level, as well at the OECD, United Nations, Global Partnership on AI, as well as bilateral engagements are very important to us. And Kai will wrap up now our perspectives.
Yes, exactly. So similar to my first block, I will again comment politically and also again make a link to the international sphere. So Sabrina now explained to you a little bit how the AI office is structured and is functioning. And as it was being said at the very beginning, yesterday there was a long presentation of the European Commission. So now we have already a little bit of a better idea. And it sounds in theory for the Parliament and for my boss Axel Voss, quite good, and we think that it was probably strategically very smart of the European Union to give the AI office such a broad flexibility and also power, especially when it comes to enforce against GPI providers. Everyone who likes to read laws can have a look in the AI Act there in Article 91 to 93. You see really a kind of carte blanche for the AI office when it's coming to Gen AI. Yeah, but this means basically, like always, huge powers. Well, they mean also huge responsibilities. And I'm not really so sure if the AI office right now can deliver on those responsibilities. And I see there especially two key problems. And the first one you see on this slide. I mentioned already that the horizontal approach of the AI Act is leading legally to a lot of overlaps and contradictions with other digital laws. But of course, those digital laws have also a governance structure or enforcement structure that is already existing and often already enforcing or governing AI. And now the big question mark is what happens? We have, for example, one field on financial services and AI, where the European Central Bank was calling us already during the negotiations quite often and was saying, okay, we and the BaFin in Germany, the EBA in Europe and so on, we are already doing that. So what is the AI office or the commission now doing? It's our turf, to use my title. And yeah, so for the next months, it will be probably a very tricky situation where the AI office need to stand its ground. And we as European Union need to figure out how all those entities, Bruegel, a Brussels-based think tank, and myself created this overview. And in November 2023, we have identified 65 different digital mechanisms, how those 65 different mechanisms are in the end all working together. This is problem number one. problem number 2 on the next slide. Problem number 2 is that we are in the AI Act and with the AI Office, but the same can be said for the member states, kind of addressing again a digital field that is very dynamic with the same old commission structure or administrational structure that showed already in the past that it's unable to really keep pace with such a dynamic sector, and in particular with powerful tech companies. We see already now, Philip was mentioning it, Sabrina was trying to show that there are already a few people working in the office, but it's still really not enough. The big hiring round in February that was started there will only lead to the first hires at the end of the year or maybe even next year. And of course, the real AI talent has already been hired either by companies or by the UK or US Safety Institute. There's in general a huge lack of funding and resources. So if we are giving such an entity so much power, we should also back them up significantly, in my opinion. But currently, just to give one example, there's only one person responsible for all standards and for sectorial implications and for risk assessment and so on and so on. And this is, of course, not possible at all. And there is often, at least this is what I hear, not really time for international alignment or cooperation. Sabrina was mentioning general points, but I'm regularly contacted by international partners that are trying to streamline, trying to cooperate with the office, but do not reach anyone there. And again, it's not going back to certain staffers that don't want to work. It's just a structural problem and let's say, lack of staffers that is leading to this. Going back maybe to our ambition in the European Union to trigger a Brussels effect, because for that, not only the law, but also the enforcement is important. In my opinion, a Brussels effect can only be in the end triggered if we have in the AI office strong leadership. So like in the United States with Kahn or with Vestager, Commissioner Vestager in the EU, someone who is extremely charismatic, is leading the AI office and is drawing back on a good combination of policy, but also technical people. And we also need to introduce a new set of work methods for the Commission, but also for the national competent authorities that are enforcing the AI Act. You see on this slide on the left side a little bit the problems. On the right side is a graphic that is going or is being based on a recent article from Philip, Sebastian Hallensleben from Sensenelec, and myself, where we are proposing basically our vision of a well-functioning AI office. If you are interested in it, look at my LinkedIn page or Philip's LinkedIn page, and then you will find the directive article where we are talking about it. Maybe to conclude, in the end, and despite the different institutions that Sabrina and I work for, we have exactly the same objective. We want to prepare and deliver a successful AI governance system for the EU. But there is at the moment, at least in my opinion, a huge question mark over the question if the EU approach is in the end quality-wise, but also fast enough delivered to really become this global blueprint of how to govern AI that the Commission and the whole European Union were envisioned before they were starting to draft the AI Act. I mentioned a lot of potential problems, which I think show that the European Union has a lot of homework and obstacles to overcome in order to achieve that. Internationally, in general, general, I think, as I said before, we are on a rather good path because compared to a lot of other areas where international cooperation is lacking or is not existing at all, on AI, I think the opposite can be said. It's really a prime example of how different countries, regions should work together. And I find it still amazing that G20 was able to agree on the same set of principles.
All right. Thanks so much, also Kai. Yeah, just to emphasize the note that you gave, you've heard very different perspectives, and you also see that we represent the different institutions, but ultimately there's like so much groundwork already done, and now it's about the next years to really kind of like deliver on this promise. And yeah, I'm looking forward to working on this together from the two institutions. Thanks so much. I'm looking forward to the Q&A now.
Thank you so much, everyone, particularly to Sabrina and Kai for teaming up for this joint effort, one presenting, the other criticizing the institution that is presenting the first part. So that's really ingenious and certainly quite inspiring and agile. I hope the whole process will continue in this way. Now, we are already heavily running over time. Nevertheless, we've had two such great talks that I would like to open the floor for a few questions. We'll just take we collect a few questions, all right, and then we'll give the floor to first Rachel and then Sabrina and Kai to answer them perhaps rather collectively. Okay, let's get started. We just go from back from the front to the back. Can you please or just identify yourself very briefly? I'm talking about re-identification in my classes a lot. And as we're getting the microphone, which is over here. So for our online speakers, and then briefly state your point. Thank you.
Hey everyone, my name is Anka Reul. I'm a PhD student at Stanford University in computer science. I'm also an incoming fellow in geopolitics and technology at Harvard University. And I work on AI governance and responsible AI more broadly. My question is not a real question, but I actually wanted to give Sabrina the chance to respond to the criticism that Kai just gave her. So yeah.
That's very kind of you. Okay, more questions. Yeah, thank you.
Hi, I'm Daniel from Nigeria, international lawyer. I've been working here in various institutions, WEF, UN, and most recently Microsoft. I guess my question, generally speaking, is there's so much in terms of law and frameworks and technical standards across different countries, across different international organizations. How will this all be harmonized in your view for companies that need just clarity and to operate across borders?
That's a very good question. Not sure we have a very good answer. Many other questions. Yeah, let's pass it along to the gentleman here, then the one in the middle, and then we have two more, then we're closing the set.
Good afternoon. My name is Manuel Cavalcante. I'm from the Portuguese telecommunications regulator, and I actually have a very, very practical question. I was discussing this earlier on, but because of the first intervention right now, practical question: what are you expecting from us at the national level? So exactly what are the ambitions of the AI office for the member states? And a practical question: how is the office organized, and who should I have in an office at the national level to implement the AI Act? Because I just heard the first question, the lady that made the first question. If I understood correctly, you come from technical programming, and you have and you are now working on policy. Yes, we don't have those in Portugal, so please help us.
I think this was a unconcealed job offer. That's great. We had more questions somewhere in the middle.
Hi, thanks. My name is Nicole. I'm working on AI governance. I also thought it was very bold of you to, represent the two institutions on stage in such a dynamic way. So thank you for the insights. I'm curious about the more technical work that has to be done by the AI office together with standards bodies, because you haven't addressed that at all. And I feel like that's also probably one of the biggest things in the next few years. So maybe you could give us some insights on these processes.
Hi, I'm Tarek, from PhD candidate from TU Dresden and working as a scientific officer at the German Aerospace Center. My question would be regarding the EU AI office. How will it cooperate with the national initiatives that the member states have? For example, in Germany, we have the Mission KI as one that's doing it on its own. How will there be a collaboration between these two entities?
Hi, my name is Ivan Madan. I used to work with AI related sort of things. Anyways, my question is, in the UK, one already sees the failure of leading AI labs to deliver the models for the test as was agreed on a voluntary basis. How a EU AI office is going to enforce the labs before deployment?
Well, that's a very good question too. We still have one person in the middle. While the microphone is being passed around, I take the liberty of asking a quick question myself. That would be to Rachel. Namely, we discussed this a little bit before, but I'd be still intrigued, and maybe also for the general audience, to what extent were you able to measure law in action rather than law in the books? So I think that's a pivotal point when it comes to a lot of countries making promises of, and even having, my father's from the GDR, German Democratic Republic. It was a very democratic regime on paper. Now he fled in 1980 for some reasons relating to the law in action part. So, I was wondering how you were able to address this, or whether that's something that's perhaps reserved for a later edition. Thank you. And then we have a final question by the gentleman in the middle. Yeah, thank you.
Thank you. I'm Vilmos Radi, a lawyer from Hungary, and I'm working for a Hungarian telecommunication company dealing with privacy, IT security, and AI. And my question is that I know that for the high-risk AI developer companies, there will be many requirements about the softwares, risk assessments, and there will be a compulsory registration for them. But I'm pretty sure that smaller developer companies will try to circumvent it, probably try to avoid the registration or qualify themselves a little bit differently, so they can say that this software is not high risk, it's just lower risk, and probably they will try to reach out for the clients directly and together avoid the registration, or together avoid stricter requirements. But do you think there will be any kind of countermeasures from the AI office, or do you plan to do something to detect these anomalies? Thank you.
All right, many thanks. So we're closing the speakers list now, and I would like to first give the floor to Rachel. I can say we have a paper coming up also on Gen AI and some related harms, and particularly some things you brought up, violence against women of color, and this is something that we discovered a lot in the, unfortunately, in the papers and in the studies out there, in often heavily Western influenced systems. So I was really curious to hear from your index and the analysis, which I think is absolutely crucial. So thank you for sharing it with us, and I'm looking forward to your discussion now.
Yeah, thank you, Philip. I'll just answer quickly. We measured government frameworks and then government action. So in some parts, we were looking to see how far are their implementation strategies and actions aligned to the frameworks. But this was slightly more complicated because it meant assessing the actual, just two pillars of evidence that weren't kind of put together at a country level on an individual basis. So we'll do it in a little bit more of a nuanced way in the second edition.
Thanks. Yeah. Do you want to start, Sabrina, and then we have Kai for a wrap up?
Yeah, perhaps. Kai, do you want to start just to break up the dynamics?
Yes, I can do, but I think most of the questions were going to you. So maybe I would pick up the international alignment question from the middle, basically. I actually do not see this as such a big problem because, as I underlined in my presentation, when it comes to the core principles, they are already aligned, at least on G20 level, but even in the UNESCO, there were very, very similar concepts in and so on and so on. And ISO, IEEE, but also the OECD, the United Nations, and so on and so on. They are also now starting on top of those core principles to look further into certain things. For example, as probably many have heard, there is a lot of engagement between the United States, OECD, European Union, and a lot of other players, how a risk assessment should look like. And in the end, the goal is basically to have globally one common approach how to do risk assessment. So companies who want to offer basically their AI technologies worldwide, as far as I see it, will not have that different rules to follow. They don't need to design for every region a completely new AI systems. And if you compare it, for example, with privacy, where we have much more fragmentation worldwide, I would argue that with AI, it's looking much better. From the EU side, and going back a little bit to my criticism, I think what we definitely need to do, we were very good in our international engagement before the AI Act negotiations started. Then, of course, especially the Commission needed to focus very much on the negotiations on the AI Act, and hopefully soon Sabrina will be joined by many more other staffers so that there is more capacities again to really engage internationally, to share first experiences, best practices, and so on. And especially, hopefully soon, we will overcome this silo approach, because again, AI is a horizontal topic. Many different entities in the European Union and nationally are working on it. They are already doing a lot of good work, but we are so far really bad in coordinating among all those players. So this is something very EU specific where I hope we can improve. But on the rest, I think internationally we are on a really good track.
Thanks a lot, Kai. To complement on that, and maybe to start out with a personal note. So while Kai was kind of like part of the negotiation team of the AI Act, and this was a democratic process, right, between the Parliament, the Commission, and the member states, the final the AI Act is the final outcome of this democratic process. And it's also only about to enter into force at the end of June, at the beginning of July, depending on the details here. So actually, from my personal point of view, we're right now ahead of the curve, in the sense that in January, we set up, or like it was communicated that the AI office will be set up. Yesterday, we announced a new structure with like 5 new units. It was mentioned that there are, what about the technical talents here? So there will be a new unit focused on AI safety, which will bring together especially the technical talent that will then, for example, conduct the evaluations on the models, but also work closely together with the policy and legal colleagues on implementing exactly this trust along the value chain that I've outlined earlier. And so for me personally, during the largest part of the ag negotiations, I was on the side of civil society, and only towards the end of the negotiations entered as a seconded policy expert on general purpose AI specifically. And I have to say, we addressed at the end the recent advancements, you know, ChatGPT that like brought this topic so much to our everyday lives just happened a year and a bit ago. And still this process across 27 member states was able to address it and put it into hard law. And now we have this, all the good hooks in the AI Act that all the colleagues that will be joining can use to then deliver on this governance framework. And when it comes, for example, to the technical talents, in February, we launched the hiring call. Just to correct a fact that Kai mentioned, the first colleagues might be joining in summer or shortly after the summer. And so we are building the team here, and we're all setting up the governance structures, working together with a scientific panel of international renowned experts that will then support the people in the AI office with their external expertise. So many systems will be put in place. As it comes to the questions on AI systems and how they will be overseen, this is actually more with the member states. So they will set up the national competent authorities, and they will engage in their country with the relevant providers. So there will be much more closer interaction. The AI office will focus on enforcing the rules on general purpose AI models and then support the member states in this. When it comes to the questions, how should the member states be organized? These are other colleagues than mine that focus on this. There are discussions being set up to exactly, also discuss with the EU level, but also amongst the different member states, like what are their learnings and how do they want to set it up. So to end on this note, thanks so much everyone for the questions, and I hope you've gained some insights into what we're trying to achieve and the basics that we have in place, luckily right now with binding rules, and the spicy conversations that are happening in the ecosystem. So thank you so much.
Thank you, everyone, for joining us for the next session of our workshop on international AI regulation and local implementation. I am Sarah Hammer, and I'm very excited about our discussion on transformative applications for generative AI. As we all know, it's important to understand the applications of the technology in order to develop relevant policies for it. And I want to introduce myself and talk a bit about the work that we are doing at the University of Pennsylvania and the work that I have been leading with Philip. At Wharton, I serve as executive director and work with our future finance strategic initiatives and our AI and finance initiative. I also have the great honor and pleasure of leading our corporate AI accelerator, Cypher Accelerator. And today with us, thank you very much for joining us, is Swarth Reddy, one of our student leaders on the accelerator, co-team leader, and excellent research assistant. So Swarth, thank you for joining us today and for leading the Cypher Accelerator at Wharton. In this process, we actually have many research assistants who work together as team managers to identify high potential AI-based companies and other emerging technology-based companies to review applications and identify those for an appropriate cohort that we will accelerate at the Wharton School. We put those companies through a series of curriculum in many different aspects of launching and leading a startup company in the emerging technology space. And then we host a Demo and Innovation Day, which this year was in New York. So at our Demo and Innovation Day this year, we hosted an artificial intelligence in finance roundtable where I and several others from around the world spoke about AI and finance. And joining us was the UN High-Level Advisory Body on AI, which I've been working with since my time here at the ITU. There are a number of other research and initiatives going on, which I am involved in at the university, including serving as academic director for the AI industry and the law program at Penn Law. So I'm going to talk just briefly about AI and finance because it's very applicable to really everything that we've discussed here today. And as someone who's interested in complex regulatory frameworks, I think that even if you are not in finance, there are lessons that we can learn. One thing I've been working on, including with Philip and our forthcoming handbook on generative AI, is the classification of different applications of AI in the financial sector. And as we think about transformative applications, there are certainly many in the financial sector that would in some ways at a policy level equate to what we might see in another complex regulatory space like healthcare. So for example, by institution, we might have asset managers using AI for customer-facing interfaces, chatbots, or for provision of financial advice. And again, one of the key issues there is the advice generated by Gen AI alone? What is the role of the human in that? Institutionally, we also have banks using AI for capital and liquidity provision, which is of key interest for the regulators who themselves are now using AI. And hedge funds, for example, using AI for trading models. And our team at Wharton has done some really important research around AI trading models and systemic risk. And then on the other side, applicable to every industry really, are issues around fraud. So bad actors using generative AI, which we haven't discussed here today, but unfortunately that is a very deeply concerning area of the application of generative AI technology, as well as cyber attacks, which we see in every industry, but for financial services in particular is of deep interest, it being a very data-intensive industry and actually being on the receiving end of the largest proportion of cyber attacks in the United States. So I look forward to our discussion today on transformative applications for generative AI and implications for policy. And I'm very pleased to introduce our first speaker, Dieter Chen. Dieter is Managing Director at EY Parthenon, a member of the Generative Task Force on Artificial Intelligence, and has led transactions using generative AI that are very transformative for industry and business. Dieter holds many high-level advanced degrees in computer science and mathematics and operations. And we're pleased to have Dieter here today and involved with us at the consortium as well.
Thank you, Sarah. Sarah just informed me that I have as much time as I can, so I'm apologize for that in advance, but you're lucky I'm not a man of many words. I do want to talk about innovating with integrity. EY, as you may know, has a deep heritage in risk, in audit. I'm in the consulting arm, so I advise clients on transactions. I do growth strategies. I currently have a client in the industrial space that I advise on a channel strategy. Later on, we'll do a transaction. And as a side hobby, I'll do a little bit of Gen AI for the firm, both on the more transformative side. So bringing customer disruptive solutions to industry and focusing less a little bit on the efficiency plays that other teams at EY focus on. I do also want to talk a little bit today about responsible ethical AI. As this has been a theme, obviously here in the morning and just after lunch, we heard a lot about ethics, trust, responsibility. I always learn a lot when I'm invited by Sarah and Philip. I didn't know horses had a lot to do with the law as well as charcoal. So thank you, Jeremiah, for bringing that to my attention. If we look now, what's going on in companies? So when we want to bring AI into practice, I think it's very similar to what Reggie is observing. A lot of my clients are grappling with, ChatGPT has left the barn. What do we do now? There's the democratization of AI. There is some confusion about
what to do in terms of adhering to regulatory requirements. You know, there's different stages of maturity over the world, as we just learned from Rachel and from other speakers. So, you know, for companies currently, they know they want to do something with AI. That is pretty clear. But I think for a lot of the companies, the question is, you know, how to get started, responsible, and in an ethical manner. If I use this, so here, this just illustrates, you know, I don't want to go into a lot of details. I want to go into some of the use cases that I want to illustrate that we're bringing to the clients. But obviously, with the explosion of Gen AIs, a lot of the C-suites are grappling with what to do. So on the one hand, Gen AI has left the barn, as I said before, but how do you start with a governance internally? How do you even know how, you know, we get questions about how do you define AI, right? So there's traditional AI, machine learning, there's Gen AI. Where does AI start? How do you look at statistical models with outputs? Is that AI? Is that not AI? So at EY, we have actually, and it's still in process, we are developing a definition of AI that is still currently being vetted. It is not an easy process. And, you know, if you look into, you know, the regulatory texts, it is not clear how to properly define AI. So that's one of the many challenges of just looking at the landscape of what do I need to govern? What are the assets that I have? Even when you define AI, it's not a straightforward exercise to then inventory where AI resides in the companies. So that's another big exercise you need to do. So there are a lot of concerns, and just, you know, I don't want to go into the details, but, you know, there's obviously the data that goes into the models. There is governance complications, there is risk, and risk not only from a regulatory perspective, right? But if you bring AI into businesses, as a business, yes, as Reggie mentioned, stay out of jail, right? So don't, you know, at least know what is required from a regulatory perspective, which is also not an easy task, right? But there are other things that you should and could do, which we'll talk about with respect to ethical AI. How do you then translate that into a responsible framework that you can follow, right? So if you talk about trust, for me, trust is doing the right thing, right? The intent, which is different for me, for you, it will be different for a company. But it's not just doing the right things, it's also doing things right, right? So on the one hand, you have to have the intentions that you communicate. But if you don't follow up, if you don't have the processes, the operations to make good on your intent, then you're going to lose trust, right? So you need to have a process in place that will allow for that. So then how do you balance if you're wanting to do the right thing with also innovating, right? So there is sometimes the perception of, well, we have regulatory requirements, I need to comply with those. Do I need to bring in, you know, the machinery and apparatus of process documentation, transparency? We talked about explainability. You know, do I need to have that apparatus in place before I can even start experimenting, right? So a lot of the questions that are being brought to us concern, how do I balance those two sides? And especially if you're a startup, I think the financial sector is a good example. Financial sector is very, very experienced in regulations, adhering to compliance. They have a whole system already in place. Now that system needs to be updated to account for Gen AI, but they have something in place. So as a startup, that question is going to be important. And in turn for venture capital, private equity companies that are now investing in startups, that's also becoming important. So when I talk about ethical AI, EY has a simplified framework. And, I have a colleague here, one of the signs that we take this quite seriously is, we have a person who is our global head of ethical and responsible and regulatory AI. He has left the building, but he will be back. So specifically for my talk, he said, Dietrich, I'll leave you on your own. But just very, very simply, on the regulatory side, these are the things that you must do, right? So stay out of jail, must do. Now, what you should do are things that, for example, transparency. If you have a chatbot, I think it's good practice to inform your customers that this is powered by a Gen AI solution. And then at the highest level, there are things that you could do, not necessarily benefiting your own business, but benefiting society overall. Okay, so I think for companies that want to put this into practice, they need to do some soul searching first. Who do we want to be? There's a regulatory level, which is kind of table stakes. At least make sure you know what they are and where they apply. But then the should and the could is really up to individual companies, right? So I think when we have our discussions with clients, we ask these questions so that they have a vision of, especially now with AI, who they want to be. Now, we also have then a responsibility framework. The responsibility framework then puts the values that you develop into practice. So we've developed this over time. It used to have 7 pillars. Now it has 9 pillars. We may go back to 7 pillars. The individual pillars are not that important, right? I think what's important is you have a framework in place that you can use to operate. So if you look at these pillars, reliability, sustainability, explainability, a lot of these themes you find, in the OECD principles, NIST. So we borrowed, we've adapted, etc. Right? So can change over time. It's just a starting point. We have a discussion with our clients to see whether they need to adapt that, whether they need to, redefine some of those pillars. But I think it's important to have a framework that you can use in order to align your processes, the governance, documentation, and monitoring. And I think, as Sarah already alluded to, the financial sector is pretty far ahead with respect to use cases for AI. Also, healthcare, as we've seen, has some really interesting use cases. Both are heavily regulated, which is not a bad thing, because as I explained before, you already have an apparatus in place for compliance, monitoring, documentation, etc. Now that apparatus needs to be adjusted because a lot of the apparatus that was in place before is not equally applicable to, let's say, a Gen AI system. Okay. On the other hand, consumer retail, even tech, where maybe the regulatory landscape is not as stringent, you can say, well, they can just freely innovate, right? But they need to then build up that apparatus potentially to follow their guidelines in terms of what type of responsible AI should we have and should we follow. For example, our responsible AI framework, we have most typically, we have clients in the financial sector that have adapted our framework because they want to be ahead of the curve. Similarly, healthcare has, we have a number of pharma clients that have done either an assessment of their practices of AI and then have gone ahead to update their practices to incorporate the elements that I showed before on the responsible framework. Tech, we are working currently with a really very well-known professional networking site that you probably all use. Not as video heavy maybe, but to update their governance process for responsible AI. So, as a consultant, you love the 2x2s, but different sectors are in different maturity stages and have different requirements. Just like consumers, Sarah is different than Philip. Therefore, you have different behaviors, different needs. Companies will have different needs and different use cases, right? So the general framework that we developed needs to be adjusted for the business. So I just want to talk about, there are dozens of use cases. I'll just talk about 3. The first one is marketing related. So the first one is really around, I mentioned, Sarah's different to Philip, Philip is different to Isa, and so on, right? So 10, 12 years ago, predictive marketing analytics was kind of the buzzword back then when, K-means clustering, segmentation, recommendation engines, that was developed back then. So now with Gen AI, you can augment that by doing hyper-personalization of the content of how you are receiving the offers, right? The bottleneck always used to be the content creation. So, because Sarah's different to Philip, she should get a different offer from, let's say, a marketing company than Philip, right? The bottleneck used to be the creative. Now with Gen AI, you can automate that. And what is even more interesting now is if you think about a pharma company, pharma companies spend millions of dollars on legal review of their advertising, right? So that can also now be automated. In my firm, I work very closely with my law team, and we're working on some use cases for that. We've also just signed a very sizable annual contract with a pharma provider who is trying to displace or outsource or leverage Gen AI now for content creation, which is millions of dollars in the advertising budget. So that's one use case. Now, marketing always goes hand in hand with sales, right? So sales, I'm working right now with a industrials special lubricants manufacturer. So it's a B2B business. You know, if you're looking over sales, you have account teams who are trying to look for new clients, right? So client, new logos, that is of importance for a B2B client. And a lot of the challenges they face is assigning the right prospect list to a geography to maximize the probability of a new sale, right? So there's another use case here where you can use AI and then Gen AI to not only look for prospects, you scrape the LinkedIn profiles to then identify the respective contacts, and then you use Gen AI also to develop supporting material, sales material, to cross-sell, upsell, etc., based on existing customer profiles as well as their purchase history. My client has thousands of SKUs, and so Gen AI can swiftly look for SKUs that are relevant, just like a recommendation engines, for a new prospect, and then develop the sales material on the fly. And then because we have so many lawyers here, legal compliance, legal functions are also a very good use case. So we are working right now with one of the largest Gen AI providers, actually, to restructure, reimagine their legal function. Sarah alluded to a project that I led for a Fortune 100 technology company. They were divesting one of their business and spinning it into a public company. That process took a little less than a year, but involved tens of thousands of contracts that needed to be separated. So we use traditional AI, machine learning, to review the contracts and accelerate the dispositioning process. Now, back then, that was about 2 or 3 years ago, we used human legal aids in the respective countries to do the contract drafting. Now, the contract drafting can be accelerated now with Gen AI. So again, my legal counterparts at my firm are prototyping this type of use case right now. I think we're holding the questions for later, I assume. Just a few more slides. I think this just illustrates that we have a framework in place. And then just for some amusement, you know, I was just chatting with Sarah about slide generation. So I tried to use Gen AI also to do these slides. It failed pretty miserably. It was, you know, you can blame it on my prompt engineering. But I also asked my team, I have a small team. I told them, your homework is to do some clever prompt engineering to do my presentation. I just give you the output of a few things. You know, lead generation, for example, you know, the images don't quite, I think when you look at customer relationship management, you know, customer intimacy, I did not want to put customer intimacy onto a slide after I saw this. So enhanced customer engagement, I came up with this proposal. So, you know, I think we're still a little bit away for certain use cases. It's also probably also a combination of the lack of my prompt engineering abilities, but this is just, you know, one illustration that you do have to do some quality control. Thank you, and looking forward to your questions later.
Thank you so much, Dietrich, for that interesting, informative, and amusing presentation on transformative applications. It's my great pleasure to introduce our next speaker, Isa C.A. From SAS. He's a member of SAS's data ethics practice and helps organizations innovate responsibly. For the past 15 years, Isa has also been an analytics advisor to the United Nations and the international development community and has implemented numerous award-winning projects. In addition, he leads a number of Data for Good initiatives at SAS. Isa holds an engineering degree from Cornell University and has implemented transformational technologies across a number of highly regulated industries, including healthcare, defense, and telecommunications. Isa, thank you so much for joining us today.
Okay, thank you, Sarah. Thank you, Dietrich. Good afternoon, everyone. Yeah, thank you. So what I thought I would do is just really tighten the scope now for the next 10 minutes or so. I've really enjoyed today and all the different perspectives that are so different than mine, right? So I thought best thing I could do for you is to offer for you the perspective from an generative AI practitioner perspective. So I've put together a list of what I guess I would call the greatest hits of transformative Gen AI projects and use cases in the private sector and industry. So I'm going to get to that in a second. What I thought I would do is just set the tone, right? Because we got to be real about where it's working and where it's not, right? So in a survey done of Fortune 1000 companies, right, 90% of these companies said they were increasing their Gen AI investment. All right, so it shows some excitement there. But here's the interesting thing as well. 2 out of every 3 of those executives said they were dissatisfied with their own progress on Gen AI or their company's progress on Gen AI. And when you delve in a little bit deeper, right, you realize that, you know what, of all of the AI projects and prototypes and pilots that are going on, generative AI, only 5% of them are making it to production at scale. Right. So how do we, so what are the best practices? What are the ones that are really netting some tangible benefits and capturing the imaginations and excitement? Oh, I'm so sorry. 5%. Okay. So here is my greatest hits album of 2023 for Gen AI in the private sector. So here are just some examples, and I'll take the next few minutes and just share some examples with you, right? So we know that Gen AI can write code and companies are using it for that. I want to draw your attention to first 2 of the most often overlooked siblings of large language models in the Gen AI world, right? The first is digital twins, and that it has its heritage from, it's a fancier way of just saying, here's some optimization, here's some simulation stuff that we've been doing for decades. And by the way, SAS, for those of you who don't know, we've been providing technology tools for AI and, for 4.5 decades now, right? Machine learning, deep learning, neural networks, all that stuff. So an example of digital twins might be, in healthcare, this is probably a pretty easy to understand example. I want them to run all the tests and simulations they want, not on me, right, from a healthcare standpoint, but on my digital twin. And then you choose to use on me the safest and the most, effective solution. Yeah. So that's one example of digital twin. But another one happens also actually here in the Netherlands, where they're creating digital twins of a fruit orchard. Right? Thousands of trees in this orchard, but you have different topographies and you have different ecosystems and so forth on the land. And so, hey, as you're going by, whether you're controlling a drone or just telling a worker, you know what, you don't need to spray any fertilizer here, but maybe here, put this much amount of fertilizer and water and so forth. Okay, but let me give you some more examples of, here's one from on complaints management. So using large language models beyond just a chatbot. Okay, so we work with one of the international banks that we were working with, right? The CIO said, hey, we have 450 use cases of generative AI. People are really excited about this technology and what it could do for us. And so the interesting thing is, like Reggie was saying earlier, you can, I read some nervous laughter in this quote, right? Because, if one of those uses is in your email, like Reggie was talking about earlier, all of a sudden now you have to train people how to use email again, right? But this time with some of the large language model capabilities. So, but in this case, here's something new that we hadn't seen. They invited us they used large language models for complaint management. And it works like this. So with all, a large international bank, tons of customer service complaints coming in. So they use a large language model to just summarize those complaints really fast, right? And then they connect that to the quantitative reasoning system, which in this case was SAS, right? And then they run it through all the basic, good old fashioned churn analysis and analytics and saying, oh, this is Sarah and she's a really good customer, so we better, make the following offer just to keep her happy. And then when they're done with running through the churn model, it then goes back into the large language model to draft up an appropriate suggested response, right? And by the way, each and every one of these suggestions is reviewed by a customer service rep, right? So, but the net was shortly after they flipped the switch on this, they increased by 20% their ability to handle complaints, right? Because if those customer service reps are anything like me, they can probably review a suggested email much faster than can write a thoughtful email, right? I usually have to do a couple of drafts before I hit send, so hopefully this is where I start to understand, how like when you read reports sometimes and people say, wow, AI and generative AI is going to add another 13 trillion to the global economy. Those are huge numbers, right? And I have to try to wrap my brain around that and say, well, what does that mean? But an example like this says, you know what, if shortly after we flip the switch, we can increase the number of customer complaints we handle by 20%, without hiring just another single person. If we look at some of the examples that Dietrich just shared about, okay, you can do more targeted marketing, increase sales by 20, 30%. You can push out product, or in the pharmaceutical, space, especially where product development is so expensive, increase product, R&D, time to market by 20, 30%. All those numbers start to add up. And for me, the light bulb goes off and I say, wow, okay, I can start to do the math, some simple math, and say, I can see the 13 trillion. Right? So my first takeaway for you is that, yes, generative AI, large language model, ChatGPT kind of go hand in hand, right? ChatGPT and large language models still take up most of the oxygen in the room when you're talking about generative AI, but it's more than just large language models, as we talked about with digital twins and synthetic data generation. But here's something else. Here's another innovative thing that we have seen people do, which is to take good old-fashioned text analytics, right? So here's the challenge right now. In industry, you saw 90% of companies are saying, hey, we're increasing our spend on generative AI because we want to be seen as innovative. And so what you have right now are a lot of companies, yay, they're willing to invest money, but they're walking around with this big generative AI sledgehammer and trying to whack every single problem with a generative AI sledgehammer. And generative AI, I kind of liken to a really, really, really good college intern, right? Man, tireless in their efforts. They can be far more effective and productive than I can be, because I get tired a little faster these days, right? But they don't quite have all of the world experience for me to let them go out and represent me 100% of the time, right? And and this is where I see large language models and people bringing their, like a predecessor, good old fashioned text analytics, to help train and put up some guardrails for the large language model. So in this case, because you all know, if you ask ChatGPT the same question, maybe 3 slightly different ways, you're gonna get 3 different answers possibly, right? Quite often. And so, but use some good old fashioned text analytics, right, to be able to summarize and bucket appropriately, and that greatly reduces hallucinations. I put up there a QR code for a white paper that some of my colleagues wrote about 4 ways to use good old-fashioned text analytics to increase your accuracy of your large language models. Okay, So here's another example. I really like this example, especially with all the talk about regulation today, synthetic data generation. So what that is, it's increasing in popularity, right? When you have to work in a highly regulated environment and you have a lot of sensitive data, or when you're in a situation where you just don't have the data that you need in order to train your AI model, right? There are some best practices that have been formed around synthetic data generation that'll give you a data set that has all of the same statistical and mathematical properties of your real data that you're after, but yet still doesn't violate any of the regulations that, that you need to adhere to. So let me give you an example. Has anybody ever heard of Georgia Pacific? Right? They make paper products. So, they take trees, run it through their mills, and they make anything from toilet paper to copy paper and so on and so forth. Okay? What they did was really innovatively, they used synthetic data generation into their computer vision and then back into their synthetic data generation, right? Sounds kind of complex, but when I show you this picture it looks like something you'd get out of the vending machine down the hall, right? So here's what they did. They say that their most expensive problems are when, they put in a log and all of a sudden their systems, their computers, their operators, their machines see something that it is not used to. Right, that it has never seen before. So what did they do? They used synthetic data generation. They used generative AI to create images of logs. Now, we rarely see logs of this shape necessarily, right, in nature, right? But this is just one of millions of images that they fed through their computer vision aspect of their machines on the factory floor. And what that did was it trained their computer vision models in their machines to be able to handle variety of different types of logs. And this little move alone saved them $8 million, right? So huge return on their investment from a use of synthetic data. I won't talk about synthetic data in the analytics lifecycle right now, but here are just some other examples of synthetic data and uses across different sectors, okay? So, I had another example. I'll come back to it if I remember it. But, the second takeaway for you is that, one thing that the companies we work with are really appreciating right now is hearing that, large language models have their limits. And we all know that, right? Everybody in this room know that. But a lot of times in the boardrooms, they get this idea that, oh my goodness, generative AI is going to solve all of our problems, right? This is the unicorn we've been waiting for. But being realistic about, hey, here's what it does well, and here's where we have to stop, right? And then hand off to something else. One best practice that I don't know if you've noted in the examples I've shown so far, like in the complaints management, right? A large language model is only 20% of that process. But man, it was a really good 20% to be able to give them that 20% increase that they were looking at, right? But then the second takeaway is that the need for governance needs to come up, further, and earlier in the cycle. And just a quick note about governance, I travel the world and I talk to a lot of executives, and it's always interesting. I love reading the room when I say, hey, I'd love to talk to you about trustworthy AI. And you can see right away the folks who cross their arms and roll their eyes like, okay, trustworthy AI. That's just a really cute way of saying you're going to govern me and put a lot of rules on me and police me and slow me down, right? But then, so right off the bat, I have to address that if they're going to listen to anything else I'm going to say. And I say, you know what, trustworthy AI isn't about governing anybody. Trustworthy AI means that, you know what, if I hand you results as an executive, as a business decision maker, results that were partially generated by AI, how do you know you can trust that? Right? How do you develop the muscles that you need, to be able to flex, to be able to quickly discern whether you can trust that or not? And then when you create something with generative AI or any sort of AI, how do people know they can trust you and what you've put out, right? And so all of a sudden it's about credibility. And long before AI and generative AI were even a topic, right? Trust continues to be a key competitive differentiator for those of us in industry. So with that comes the need for just, better governance, like what Dieter was talking about in that high level. And then here are just, here's the checklist, and similar to that model, the governance model Dieter was showing, right? Here are the things that people need to consider. If you just read real quickly, there's a lot around fairness and bias assessments and your data governance and your large language model governance and so forth, and just making sure you ask the questions. You know, one very practical tip I like to give people is, and I've not really asked this question very much at all in all the projects I've implemented, but I need to start now. And that is, before you do something, before you use AI to solve a problem, to ask the question, okay, for whom does this not work for, right? And I've trained, we're using this to train all of our employees who volunteer on our Data for Good projects to start by asking those questions and to start flexing and developing some of those AI ethics muscles. All right, so the last point, AI intelligent assistance. And this is a pretty easy thing to grasp. So going back to the Georgia Pacific example, right? So let's say something weird comes down the production line, a weird shaped log comes in, and I just started yesterday, right? Oh no, what do I do? So if it goes past, it gets to a certain point and there's a problem. What they did was they also used that. They turn on the ability for a generative AI to be an intelligent AI assistant. So it looks something like this. Okay, here's a problem. Here's something I've not seen before. Hey, new guy on the line, turn that button 3 clicks to the right. Turn this button 2 clicks to the left, right? And so there's me, and I may have just started last week, but this AI system, right, was trained from somebody who's been there for 20 years and has all that knowledge that now gets passed to me. So again, like has been said several times today, the ability to democratize knowledge. There's one of my favorite tweets on Twitter was somebody looking at large language models and saying, wow, this is awesome. The hottest new programming language is now English, right? When you can, or Portuguese or whatever your spoken language is, however you're choosing to communicate with that large language model, right? Because when you can take down, you greatly reduce the barriers of entry into anything when you reduce it to the spoken language. Right. And so who of us wouldn't want to be able to say to a trusted generative AI solution and say, you know what, can you run 200 million simulations on that and come back to me with the one that fits my needs the best? Thanks. Right. Before I pull the trigger on this very important question or solution. Sorry, I move around a little bit when I talk. So I think, and then this is just another example, similar to what I was talking about, but this is a different consumer packaged goods company, right? They make products that go into every single household. And so you can imagine how hard it is for them as products come out of the warehouse for them or come off the production line to figure out, okay, how much of this product do I need to put here versus here versus here to make sure that we never run out, that we're always in stock, and so on and so forth. And so in that situation, they use Gen AI to be an intelligent assistant so that when a truck driver comes in every day, that truck driver does not need to know anything about optimization algorithms or need to talk to an optimization expert, right? He just talks to his intelligent AI assistant that says, hey, take so many of these over here, so many of these over there by such and such time. Okay, and I think that is all that I have. Thank you so much for your attention.
Thank you so much, Isa. We will take a few questions from the room now all at once, and then I'll turn to our speakers to take turns responding. Questions over here.
Hi, thank you both for the talks. That was great. I work in AI strategy and investment bank, and one of the big things we're doing is deploying LLM use cases. So Dietrich, how would you recommend a client goes about prioritizing different use cases and quantifying the benefits that come from Gen AI or otherwise? Thank you.
Yeah. Can you hear me? Up. I need to push. Yes, technology. Yes, so thank you. So we do actually quite a bit of work, as I mentioned before, in the financial sector, including investment banks, and we do have what we call an AI accelerator, which is basically, from a consulting perspective, a combination of a assessment where you are on the maturity curve, and then run this through assets that you may want to deploy. We do have a prioritization framework that we obviously adjust for the purposes that you have. So there's, typically time to value, ease of implementation, regulatory requirements, etc. We run this through, and then we also have the ecosystem with the eco partners available to do prototyping, deployment, and then build at scale. Hopefully that helps, and
Yeah, thank
happy
you.
to chat.
Was there another question on this side of the room?
Yes, thank you so much for both of the presentations. They're really, really insightful. For the second speaker, my apologies. I'm not quite sure how to pronounce your first name. Isa?
Isa.
Isa, pardon me. Thank you, Isa.
All right.
You gave a number of really interesting examples about where generative AI is being used in particular contexts, which is really wonderful to put meat on the bones of where it's being used in practice and its effectiveness. And then you gave the example about trust being crucial to trustworthy AI in terms of decision makers. I was wondering what your views would be on when the user in certain sectors can't be connected with the failure of a decision-making outcome. So you mentioned law enforcement as one of the areas where generative AI is being used. And if, for instance, one of those AI-based systems doesn't produce an outcome that's fair or lawful, often the decision maker, the particular police officer in question, it will not connect back to them. So there's an immediate detachment in terms of that incentivization of trust, because it's a failure then in the institution and not the particular decision maker.
That's a great example. Repeat the question part though, again, for me, please.
So the question is, how do you make the case for improving cultural compliance in a sector where you have that challenge? So law enforcement is one example, but there are many other sectors, health and education and so on, where individuals will make decisions affecting natural persons, but it won't necessarily be connected back to them. So that incentivization is disconnected.
Yeah, and maybe this bears it probably warrants a longer discussion, but for me, the short answer really, it comes down to, again, in your process that you use to deploy trustworthy AI, right? It sounds like the testing in that situation. I mean, it's never going to be perfect, but like sometimes some projects suffer because it's rushed and they don't train it properly, or starting off, they don't bring enough diversity into the into the training aspect. But then there's also, there's different points of failure in a situation like that. What about having a human in the loop, right? Being able to, like in the case with the complaints management, there was a human monitoring every single suggestion before they hit send, and so, right, so it's yeah, it's complicated, right? But there are definitely some different checks and balances that we can put in place along the way.
I think we have a comment from Reggie Townsend.
Also, I want to augment Isa's response. So the way I understand the question is, let's say police officer takes action at the urging of AI system, and so impact is had, or received by an individual citizen, but the trust is lost in the institution of policing, right, as opposed to the police officer. That's the premise. And so one of the things we're looking at in the US from a law enforcement perspective is putting the, so let me put it this way, the officer in this case has to be subject to training and an understanding of policies as to how to act to prevent harms, and therefore should not ever be in a position of exacting some harm without some knowledge of accountability, right? How you deal with the individual citizen, yeah, the institution has to step in. So this is not so much a bilateral as much as it is a tri-plus lateral sort of issue that you bring up, right? Because well ahead of some police citizen interaction, there should be some understanding of what the law is on both sides, right? And so it's tough to talk hypotheticals here, by the way, because the reality is AI should never urge harm to a citizen by an enforcement officer, right? So that's part of the reality. But in those cases where there is the use of the technology, we do have to have policies and regulations in place sufficient to potentially identify and mitigate any potential harms before they would occur at the citizen level. I hope that helps to clarify. Yeah. So, but that comes well after technologists like Issa create stuff, right? That's at some point liability drifts back, but it's really much more indirect than the hypothetical might offer.
Also, if I may want to, and I had this discussion, a similar discussion with Philip on the healthcare side. So healthcare is another challenging sector where I think what you're describing could be a challenge. So my wife is a physician scientist. She's giving a talk at ASCO this week, American Society of Clinical Oncology. One of the talks there is about ethical and legal challenges in clinical care. So when an AI system diagnoses or recommends a treatment, for example, there are legal challenges because the standard of care is applied to physicians. And there is questions, the question now is, for an AI system, what do you apply? So not that there's a solution to it, but I think, different sectors have different challenges that need to be recognized by the practitioners as well as the law.
Thank you. I think we'll take the remaining questions now.
I have a question, but yeah. So my question is for Iza. I'm from Ata Technology Platforms, a software company from Turkey. And I just wanted to ask, maybe I missed, how do you relate the term digital twin to generative AI? Could you please repeat that part?
Yeah, so from our lens and perspective, we look at digital twins, synthetic data generation, large language models as all a part of the generative AI family, right? And that's our definition in my organization on, and just how we chose to categorize it.
So yesterday I participated in the telecommunication workshop, and there was the term AI native systems. So when we talk about the digital twins, I think it becomes crucial to bring generative AI and maybe different deep learning applications into each aspect, each part of the system. So do you have comments for that?
Yeah, maybe let's talk afterwards a little bit. I
Yeah.
want to give you a thoughtful response right now. That's a good question, though.
Okay, thanks.
Yeah, thank you.
Thank you. Our last question here.
All right, so thanks for both for the great talk. So just a lot of times when people are talking about things that can go wrong, are thinking LLMs and what's wrong from an ethical safety perspective, et cetera. Beyond that, so going down to the layer of applications, agents, et cetera, data sets, whatnot, and all the, everything you guys have covered. Have you seen in practice in industry already applications around governance and audit? And what type of examples can you offer in terms of how is this practically happening right ahead of EU AI Act, being actually put into practice?
Yeah, so the governance of a lot of what we talked about, I've seen it mostly applied in the financial sector, to some extent in the healthcare sector, the tech and the consumer and retail sectors. Because the regulatory requirements are not as stringent, they often start to innovate first, and then, once the proliferation of, let's say, new algorithms becomes more robust and scalable, typically legal steps in and wants to make sure that, things are being done accordingly, especially if it's a global company. Now with the, EU AI Act is in the press everywhere. So, adherence to making sure they stay out of jail is going to become important. And then, so there are different stages of entry points where companies start from. I think the highly regulated companies may start from governments first and then look at use cases that they can deploy. Other sectors may start somewhere else. Smaller companies, private equity companies that want to deploy Gen AI in their portfolio companies may want to put some more burden on the providers to make sure that they have responsible frameworks in place and so on. So hopefully that helps. It's not a one size fits all.
So I'm just going to comment on your last point, Dietrich, because I agree the financial sector is another good example for us to learn from when we think about governance and differences between companies. It's a highly regulated space. But in addition to what we're talking about here today, AI governance, for all listed public companies, including financial sector companies, they will have certain governance requirements as listed companies and certain requirements around what constitutes governance, having a risk committee, for example, an audit committee, and the types of expertise required. For example, finance expertise is required of listed public companies, or an explanation as to why they might not have that expertise. So one question on the corporate governance side would be, should companies be required to have AI expertise? And if not, provide an explanation as to why. And then separate from that, but hopefully integrated at some point, is the whole question of AI governance, which poses novel and interesting questions for us as policymakers. So thank you for the question. We're going to go to break, and we're taking a 10-minute break, so we'll return at 4:52.
I'm happy to announce our next speaker, Alexandre Zavalha Coelho. He's a professor at the University of Lisbon, teaching an AI post-graduation course. And besides being a RECSAI expert and coordinator of the research group of AI governance and ethics, he's a pioneer in Brazil developing AI projects in the legal fields, as well as a member of the National Council of Justice Task Force to propose the regulation of AI in the judiciary. And last but not least, he's partner and director of legal and tech.design.
Hello. Hi, everyone. Thanks for having me. It's a great pleasure to be here with Sarah and Philip. It's a pleasure to be member of RECSAI and try to bring an example of how we are building AI tools, how you're using it in legal fields. And of course, every time looking about governance, ethics, and how we're gonna implement it, because everybody's talking about transparency and explainability and auditability, but what it is, how to do it. So we are trying to develop some strategies and tools, and I'm gonna show you a pathway about our judiciary. I've been collaborating with our judiciary for a long time, being part of task force, and the last one established by the president of our Supreme Court to propose the regulation of the use of AI in our judiciary, because you're going to see we have more than 150 projects ongoing there. So we have a very nice example, Isaiah, because it's very close about what we are saying, using different technologies in NLP and predicting models, machine learning with LLMs. So the thing is, law is one of the, has immense potential to develop AI, because we have vast numbers, millions of acts, millions of activities, interactions, and of course, documents. and legislation, contracts, evidence, sectorial standards, and of course, when we have challenges and problems, they are often opportunities. So we have to manage all these problems. So at the private sector, we built a lot of nice tools. We have more than 300 startups and tech companies dealing with litigation support, contract analysis, decision support, compliance, and also document generation. I'm working with document generation for the last 5 years. Before the LLMs, we were building 40,000 documents monthly basis, achieving 98% of accuracy. I showed it last year here in AI for Good. So the thing is, we have to understand, of course, everybody knows it here, as technology, not an end itself, but how the technology can help us to understand the law as a phenomenon and how to scale and how to systematize the legal reasoning and how to help us to solve legal problems and to increase the access of justice. So in Brazil, we have this scenario. I don't know if it's good or not, but we have 80 million lawsuits in stock right now. So you can think 50 pages or documents or 100 pages of documents or documents per lawsuits. We're talking about billions of documents and a lot of activities and interactions and new documents every day. So we have 30 million new cases every year and 29 million cases judged and closed. So you're seeing 60 million increasing this stock every year. So this is a huge problem, how to deal with it. And that's why in other countries, advisory strategic areas are mostly more important, but in Brazil, litigation support is very important because we have this massive volumes of work into the judiciary, into in-house legal departments, and also law firms. So when we are talking, so we heard about the policy view, the policymaker views, the consultants' views, but I'm trying to bring to you the implementation view because I've been working as a lawyer, working as a bridge between the two worlds. I'm working with artificial intelligence since 2016. Nobody talks about it yet. Nobody believes that that's going to happen. But I really work with the tech teams trying to build these tools, to use an NLP, to trying to classify all those databases that we have. So we have three main pillars. Of course, engineering, hard works, cloud, etc. But I'm going to talk to you about automation and data science, data science. So I forgot just the time. So the first thing when we're talking about quality and good outcomes, we have to understand that we have to build our digital environment, all right? Which is going to be our main system, how it's going to work, and in case of judiciary, we have to follow the procedures code that will be reflected on the every part of the system, and then we can go to data science to transform data information. But we have to follow this path, you know? So the first thing in Brazil, we started to build this electronic judicial process systems in 2004. That's why I have 20 years history in 20 minutes. I don't know if it's possible, but we started in 2004. But in 2013, it's an important moment because we have this National Council of Justice, which is the most important body to control and oversight and build this internal policies from our judiciary. So in 2013, this PJE was established as a public policy into our judiciary. Since then, every process, lawsuits now are digitals. It became the information processing systems, and they established the guidelines, how to operate. But there's a problem. At that moment, it was good, but now we are suffering the consequences because they allow the decentralization and autonomy for the 90 different courts to build it. So every court do in their way. We have a lack of interoperability, lack of standardization. So in 2019, the new version 2.1 started a new way, a new moment with distributed and cloud computing, platform architecture, and higher speed, because of course you're seeing 20 years, all the lawyers, oh, I don't like this digital system. I have a lot of problems. I can access. It doesn't have the proper UX experience and so on. So when we're talking about innovation, of course, we are always rebuilding, redesigning, and understanding the problem, and of course, making it better in each version. So in parallel of this, to build our digital environment, the judiciary did expansion. They carry out the digitization of all those records. So now, since 2022, we have 99% of the new cases in a digital, in this digital platform. So you see, first of all, which is our system and how to build it with automation, reflecting the procedure codes, and then the digitization of all those data. But at that time, we did that in an analog way of thinking, because we just upload images. But the image of the petition, of the decisions, they were not readable for the regular computer systems. So it was a big challenge to really bring different technologies to deal with this challenge. That's why we started at the first time to build a national database called DataJudge. But DataJudge, we were talking just about metadata, the registration about the parties, the class of the actions, and the claims, and so on. So, of course, in this database, we have 365 million lawsuits, just the metadata, not the documents. And we tried to unify the procedural taxonomy, because it was very important, because we were not dealing with AI at the first time. So DataJudge helped a lot. So you can access the system and this BI from internet. You can put DataJudge CNG, and you're gonna see this. So we have this 36.5 million lawsuits there, and we can have a lot of dashboards and KPIs with the companies with the higher numbers of cases, which is the statistical numbers about healthcare discussion, about financial discussions, so justice in numbers. So DataJudge helped a lot to understand the principal overview, the KPIs about what's going on in judiciary. But it was not enough, because they only have the metadata. We cannot see at that time what's inside the documents, you know? So we have this lack of standardization, included lawsuits without subjects, incorrect identification of parties, failure in identify types of objects, and so on. So this challenge is because these things was negatively impacted the surveys, the reports. So it was very good and helped it a lot. But we needed at that time to achieve another goals, to classify that that database, to go deeper, to really understand the problem, to understand and to build this interoperability of the systems. So that in that moment, we started to work with AI. And there's two important things here, because we have open data in Brazil, differently in most countries, because we have this constitutional principle. Every judicial act are public. Yeah. So, and what we learned, the most important information was and are into the documents, not in the metadata, of course. So we are trying and begin to use NLP and machine learning to build this legal Portuguese library to use AI, you know. So we are building it for the last 5 years. So now we have a major and very successful work before LLMs, you know. So we have all this data now classifying. We build this library, and then of course was starting these projects, and the National Council of Justice started to worry about governance, ethics. So then they launched this first resolution in 2020 to bring guidelines to it. But the biggest moment was in 2021 during the pandemics. So the judiciary launched the program called Justice 4.0, and it established the new digital platform of our judiciary, because we have this model of isolate database, isolate system. So now it becomes a model to platformization as a public policy. And the new database called Codex, now with all the documents and a lot of microservice. But and then Codex, we have now at this new database 25 million lawsuits with all the documents. And this is gonna be the proper way and the proper environment to build this model, to use LLM, to avoid hallucination, to understand, to have quality, to really have the better results and all the transparency and explainability and auditability that we're talking about here. So this is the step. So we are building it for the last 2 years. And then synapses, you know, just before the regulation, we already have a platform, and every AI projects are there. The projects, the purpose, which kind of technology each court are using. So this is public. We have all these projects there, and this is the last research launched yesterday. So we have now 140 AI projects in our judiciary. So and just for you to know, I'm sorry it's in Portuguese, but 80% of our courts are developing or using AI at this moment. We have more than 90 different courts. And concerning about LLMs to judicial activity, just 39%, it's starting right now. And to implement administrative or managing activities, just 21, but using machine learning, especially NLP, 80% of our course. And of course, the highlighted projects, I don't have time to show all of them, but I'm just gonna show the generative AI project. So, but mostly of them is the reading documents, enriching the database, doing jurymetrics, decision support, understanding the KPIs, the correlations, which is the best moment to do a settlement, which is the best value how the provision of a conviction, for example, and so on. So we have all this well classified, especially for the private sector. In this point, our judiciary did their work establishing and making happen all this point, and now they are in that moment starting to classify the codex. But as is open data, they fomented a lot of startups because we have data to train our models, you know, and legal data. So so we have now starting these Gen AI projects in Paraná, Rio Grande do Sul, mostly of them using to find millions of judgment to consultation, to provide support to simple decisions, because of course it's not working very well yet, because we are doing this 40,000 documents monthly basis with another techniques with 98%, 97% of accuracy, but when we are using LLM, it's not happening this way yet. But the most important case of this year is about our Supreme Court. Our Supreme Court has 3 projects. Oh. It's not going. One is called Victor, classification of appeals in general repercussion teams, because we have a hybrid system. We are civil law, but the repetitive and objective case, we also have precedents, and we choose one leading case, and then they decide this leading case. So Victor achieved 92% of accuracy. Of course, this work is not done by the AI system. That they have the oversight of the judges and all this his team to really use this data, but it's 92% of accuracy. Looking at a lot of data. Victoria grouping appeals and complaints with similarity. We are using similarity techniques at all time to understand, to cluster the claims that are really similar or the same. And HAFA, which is how to integrate all this job with the SDGs and the 2030 agenda. All of our judiciary, everything we're doing, we are understanding how it's impacting or how it's addressing each SCD. So in our Supreme Court, they automated this job. So it's HAFA. And the most important project of the year is, not good. Yeah. And I am almost done. So our STF issues this public call for Gen AI project to summarize law claims and to start to build the draft or some kind of decisions. So it's public in our Supreme Court. And this is the final report. So I think attend this public call 24 companies, all of the big techs, directly or through their partners, and startups too. So they just send 3 data sets with a lot of questions. and say, oh, you have to answer that, and we're going to measure the results. And this is the result. This is public. This is the final report. So we see, for example, look, all the big techs are here. All the big companies in Brazil, consultancies are there. So, for example, what are relevant arguments for the appeal? Just 7 solutions achieve the proper result. So you know, you can see, of course, we have a very exciting things going happen, but right now we have to understand that we have to put together, as ISS, the very well-structured database, use NLP models to build our to really understand what have into the documents and classifying all these documents, all the themes, all the kinds of appeal, to use LLM in a proper way. So I have a last case, but before that, so in the last December, our Supreme Court just launched this new task force to propose the regulation of the use of AI in Brazilian judiciary, because we have this 150 projects, all of those concerns about risks and bias, discrimination and governance. So I'm one of the members of this task force. And just to show you how it really happens now in a private sector. So we have Azaya, that's the one I was talking to you. We have this database with 50 million lawsuits classified with NLP. So we can ask everything what we want to this database, but the lawyers are not using it very well, because you have to say, oh, I have to use this kind of, I want to see this company against another company, which kind of claim in this city. So nobody's really do this. Everybody's using just 5% of the potential of this solution. I am at the back office, so I can see it, you know. So that's why we are using LLMs in first project as an interface with this database, with our predictive models, with our prescriptive models, you know. So they're just asking, because LLMs is not good for predictions, isn't it? So we are using these different kinds of systems and techniques. So now we have this chatbot. So the lawyers can, oh, I want to do this question. So they don't have to click anymore. They just have to ask, you know. So I think it's the state of the art of what is really doing. And why it's happened, because we have this digital environment, we build our data lakes, we classify the data using all of these techniques, and now we are using LLMs to ask questions, and the second project is to build documents. So the last slide, we are building documents using this pathway and using a new technique called RAG. I think you already heard about it. So RAG is a technique, is a retrieval augmented generation. So when we have this prompt, this RAG with this well-classified database helps to find in the exactly the best kind of data or document or argument. And so we can bring this traceability and where did it come from, which kind of data we are using, and this is Philip, the the image that I built for our Oxford handbook. This is pretty new because we are building this using HAG. So now we can see at the new text using HAG and this pathway. So this part comes exactly from that document. That part comes exactly for that document. So we're talking about transparency and auditability and explainability. And what I try to bring to you is that with the policymakers, with all those guidelines, we have to work with the tech guys, with the, we have to have this technical view, because we're not, we cannot solve this without doing all, respecting all these steps to understands the limits of the technology and which kind of technology will help us to know what kind of data we are using, what kind of technology to do the impact assessment, to understand the weight of each variable, to understand the outcomes, and then to do our job, our human job, which is making the decisions if we're going to use it or not and how we're going to use it. But without the collaboration with these multidisciplinary teams, we cannot achieve everything we believe in working with. Thank you.
Now it's my honor to introduce our next speaker. Before we are collecting some questions, our next speaker is Carrie Coglianese. Carrie is the Edward B. Shields Professor of Law and Professor of Political Science at the UPenn Law School and globally leading expert on technology regulation. He's the founding director of the Penn Program on Regulation, as well as a senior fellow of the Administrative Conference of the United States.
Thank you very much for allowing me to be here and connecting with you remotely. If you could just give me maybe a thumbs up to see if you can hear me okay. All right, great. And I will share my screen now as well. I know this is a session on governance of AI at the international level and at the level of local implementation. And what I have to talk about today matters, I think, for both levels. I'm interested in the form that AI governance takes at whatever level it takes place. That is, I'm asking, what is the type of rule design or regulatory strategy that we should be pursuing with AI in general and with generative AI in particular? And in the end, I will conclude that a central approach, a key approach to regulating and governing AI is a management-based approach, which makes people or guardians, if you will, absolutely vital. And in that regard, my overall remarks respond to a common way of referring to AI governance today as one of providing guardrails around the risks that AI can present, whether it's safety risks, risk of bias and discrimination, or a myriad other forms of mischief that AI can create. Guardrails is how the president of the European Commission has described one of the contributions of the EU's AI Act. It's also the way the White House in the US has described its own memorandum adopted in March of this year, following Executive Order 14110 from last October, that outlines measures that federal agencies need to take when they use AI tools. What I want to do is just divide my remarks into three parts. I mean, first, I just want to spend a little bit of time on why guardrails is an unrealistic metaphor for AI governance. Then I want to share with you some basic research findings and conclusions about rule design that come from other types of risky technologies. And lastly, I'll draw out what I think this means for regulating AI. And up front, I'll tell you that it means that AI governance needs to be agile, flexible, and vigilant, which means really ultimately that the guardrails that we might all seek are really going to come in the form of people guardians rather than in any fixed technology. But at the outset, let me just consider literal guardrails, those on the sides of roads, and just say that, you know, first of all, it should be obvious they don't prevent all accidents or injuries from automobiles running into each other. They're only there for situations where vehicles would be leaving the roads, not necessarily all interactions on roadways. They don't protect, for example, the thousands of pedestrians who die each year in the US in auto-related accidents. And, you know, I suppose we should be serious too. Do we really think it's enough to provide auto safety just by putting in place guardrails? No, we have licensing requirements, age requirements, testing. We have laws related to drunk driving, driving while distracted, and we do a lot to regulate the vehicles themselves, functioning brakes, headlights, seatbelts, and so forth. And we even require people to use those seatbelts. The second observation about guardrails in particular is that they are not effective even in those circumstances involving vehicles leading the roadway. They're not foolproof even when they're needed. They can give way if vehicles are very heavy or large or traveling at high speeds. And a third observation about guardrails literally is that they themselves cause harm. In fact, that's pretty much basically how they work. They're inherently designed to cause a certain kind of harm by creating a barrier for a moving vehicle to encounter. It's just hope that they cause less harm than would otherwise occur. You know, we do know that guardrails can sometimes cause vehicles to flip over and create more harm than would be otherwise, but highway engineers caution that we should only use guardrails and place them where they can be shown that the harm from encountering those guardrails is expected to be less than what would be encountered in the absence of the guardrails, such as with steep cliffs or wooded forests or something like that. So what are we to make of this? I mean, I think taking at face value, I mean, these three key observations imply that guardrails, while they can be important, are still just one circumscribed tool for protecting against the risks of automobile accidents. It's better, obviously, to hit the guardrail than to go over the cliff, but we should not think of a guardrail as adequate governance. So when it comes to AI, you know, I grant that the word guardrail is used in this context as just a metaphor or figurative speech, but that choice of language and its imagery of some kind of strong barrier does reflect, I think, an abiding desire for physical safety, for some solid protection, even though we're talking about a digital world driven not by physical vehicles, but ultimately by electrons. I think the choice of metaphors we use about AI governance is important because it can lead us to think about the solutions we seek when regulating AI, about whether we need rules that operate as rigid, fixed barriers or something else, maybe something else that's more flexible. And whether ultimately we need, as I want to suggest, guardians, perhaps more than guardrails. Another problem, by the way, with thinking about governing AI by guardrails is that when it comes to AI, there's no clear fixed roadway at the edge of which we can install guardrails. The technology is shifting and changing at an exceptionally rapid pace, as the prior presentations on this panel have made very clear. The number of different uses to which AI can be applied, which may be perhaps infinite if we are thinking about generative AI. All of this makes the technology far, far, far from just a simple roadway with defined edges along which a barrier can be built. And Furthermore, I think as a society, we may actually want to encourage, at least metaphorically, some off-road travel, the search for using AI to reach new important destinations in better ways. So blocking innovation and limiting it to circumscribed paths can actually be undesirable. So for these reasons, I think we need a different metaphor for governing AI that doesn't imply that all we need to do or all we can do is find clear parameters, mark them, and block the technology from succeeding those parameters. That metaphor, again, in my view, is of a guardian rather than a guardrail. It lies in how people manage and oversee the development, deployment, and ongoing oversight of AI tools. And that leads to the second part of my remarks that I want to highlight, which is to draw upon research from other domains where we have learned a lot about regulating risky technologies. And a few years ago, I had the privilege to serve on a U.S. National Academies of Sciences, Engineering, and Medicine committee that was charged with making some recommendations for the design of safety rules to protect workers and the public from the dangers of high hazard industries. These are pipelines, petroleum refineries, chemical production facilities, things that can literally go boom. And we were asked to perform a study for the US federal government about what were some of the advantages and disadvantages of different ways to design safety rules in these kind of high hazard settings. Some rules could be more rigid, operating more metaphorically like guardrails, while others could be more flexible. And in particular, we were tasked with assembling all that we could find out and all that we knew about a type of way of designing rules called management-based regulation. And I mention this because what we found bears on what it means to regulate AI. Just as with AI, large chemical facilities and other high hazard facilities can be incredibly complex with myriad ways things can go wrong, many of which cannot be fully anticipated by a regulator or maybe even by operators at the outset. So I think what we know about regulations in these settings can be instructive for what we should be thinking about when it comes to regulating AI. In all of these other contexts, regulators around the world are deploying a management-based approach to regulation. And to see what that approach is, I think it helps to distinguish it from other types of regulation. And in this National Academy of Sciences report, we distinguished different rule designs from each other by looking across two different dimensions. One dimension focuses on whether a rule specifies a means, some action that needs to be taken, or whether the rule specifies some kind of end state to be either achieved or avoided. And then we said there's actually another dimension, and that is between whether these rules are focused on the ultimate outcome that the regulator's trying to achieve, avoiding a big chemical facility from blowing up, for example. That's an ultimate outcome. Those are macro rules. They're really targeted at and focused on those outcomes, versus a micro rule, which is applied to some specific causal pathway on the way to that ultimate outcome. So a very specific rule governing either what actions need to be taken or what other ends need to be taken with respect to, say, operating some kind of particular valve on a larger facility would be micro level, because that valve, if it fails, could trigger a chain of causal events that could lead to an ultimate explosion. of the facility. Once you distinguish between rules along these two dimensions, we can take and see that governance, really governance across the board, can be captured in a 2x2 framework here, one that is adapted actually from some research that I did some years before this National Academy of Sciences study. We used some new labels here of micro means, micro ends, macro means, and macro ends to distinguish these approaches, but there are other common words that are used by regulators around the world to describe these approaches. I won't go into all of them, but just wanting to highlight the one in the lower left, which is the macro means approach or a management-based approach. And this is one that, again, is used in all of these settings where we have high risks, where regulators instruct regulated entities and their managers to focus on that ultimate problem, and then to develop their own internal processes and procedures designed to understand and then to respond to the risks of that ultimate event that the regulator is trying to avoid. So there are different examples that one can find in the world of chemical facilities that require them to engage in their own risk analysis or develop safety management programs or safety management plans or systems. This is even something that we see being applied in the financial sector today, in the area of terrorism and security provision, anti-terrorism protection and security provision, and in the food safety, just to name a few. These approaches can have the advantages of being able to be flexible and allowing opportunities for industry to innovate, because as much as they are telling firms exactly what to do with respect to managing their operations, they don't say exactly how those operations and facilities and technologies need to be designed, structured, and used. So it's just saying, put in place this, what is often a Deming cycle or Deming circle approach of a plan, do, check, act, systematic structure to find risks and to address them. And it can be very useful for regulators when it's hard to measure outputs or outcomes themselves. And ultimately, it's hoped that maybe these approaches can help infuse a sense of responsibility, accountability, or safety culture within organizations that are presenting high risk. This approach is, as with anything, always something that has advantages that we have to think about as comparative, compared to what? And if we compare it to situations where the outputs are very easy to measure, well, there's probably a better way of going about that, as the rules should specify the attainment or avoidance of those outputs. That's what we would call performance-based regulation, or in the National Academy lingo, micro-ends regulation, the upper left on this chart. Where all the situations that a regulator is concerned about are pretty much the same, and there's not much dynamism or change. One size can truly fit all, and a means-based or micro-means-based approach would be appropriate. But what do you do in those situations where the outputs are hard to measure, and the regulated entities or processes are always quite different? That's the area for management-based regulation. And management-based regulation can work. It's been shown in the area of environmental regulation to be associated with a 30% decrease in toxic emissions. When it's been used in the food safety area in the US, it's led to an annual reduction of about 500, at least fruit juice, foodborne, this is the area where it was tested, foodborne illnesses a year. But there can be limitations, and it requires a new way for regulators and the firms to operate sometimes. The regulator also needs to be able to continuously monitor and maintain a motivation for improvement. And this is an important limitation to note. Sometimes these plans and systems can be used by regulated entities just simply to go through the motions, or what sometimes in the old style technology was called pencil whipping, where we just create the plans, but we don't really take them seriously. And we do see, at least in the study that Benir did in the pollution prevention context, that over time, the effects of this may wear off. And that's important. So what does all this mean for AI? Well, I think when it comes to AI, we're definitely down in the lower left area here. Outputs are very hard to discern, part because of the distributed nature of this technology. Foundation models and generative AI are being deployed, you know, by anyone, and it's hard to for any regulator, central regulator, map that. Plus, this is an area of great heterogeneity. I had to include a Swiss Army knife for you all because you're in Switzerland, but it's just, you know, obvious that there's different kinds of algorithms and models that are being deployed, and they're being updated over time. Sometimes they're being deployed on new data sources. You all have been talking about the heterogeneous uses proliferating. The Brazil case was talking about the hundreds of cases that that are being used there in its judiciary. In the US, I have another study, the federal government, that has now documented over 1,000. I think we're up to about 1,300 documented uses of AI at the federal level. That's not even counting, obviously, all the private sector uses. And the problems are also heterogeneous. And when it comes to generative AI, I think it's you know, instructive that a study last fall from some researchers from Princeton, Virginia Tech, and Stanford was titled "Fine-Tuning Aligned Language Models Compromises Safety Even When Users Do Not Intend to." These things can have a dynamic nature to them. So how do we think about regulating AI? I think the key is for regulators to be agile, got to build up their own capacity to keep pace with industry. They do need to be flexible because one size won't fit all. Management-based regulation is appropriate. There may be instances where mandatory disclosure can also be used, but that too is flexible. And ultimately, we got to be vigilant. The regulators have to be staying engaged with the industry and attentive to new risks and new technologies. In the US, over the last several years, we've seen the executive branch starting to respond. I know the general view is that the US hasn't really done much of anything. It's been the EU that's been ahead of the curve. But in fact, in another study that I'm working on, I show that following adoption of legislation in 2020 in the US, the executive branch has had almost 60 different measures. And that's all before the adoption of Executive Order 14110 last fall, which addresses the safe, secure, trustworthy development and use of AI. It directs agencies to take about 150 actions itself. These are a whole of governance approach. And most of these actions tend to be flexible, guidance, planning, auditing, and they follow the National Institute of Standards and Technology, NIST's risk management framework for AI. Ultimately, I think this is important to recognize that if management-based approaches, risk management, which by the way, is used, a word used more than 50 times in the EU's AI Act, if that's going to be the direction we're going, and it does seem to be the way we're going, it's going to depend on developing sophisticated human decision-making and capacities. That means ultimately building human capital. And there's a whole section in the US executive order on trying to help ease the path for getting high-tech capable individuals into federal government to help harness and govern the use of AI. And it's noteworthy, of course, that the European Commission has established its AI office under the EU AI Act. In the end, ultimately, AI governance, can't be just a rigid fixed guardrail. Sometimes guardrails or prescriptive rules might well be useful or needed, but they're not going to be a complete approach. The extreme heterogeneity and dynamism of AI means that we have to manage and oversee on a continuous basis. We need patrols or guardians as much as we need guardrails. And those need to be guardians of the people and the public in a world that is increasingly being affected by digital machines. So thank you very much.
Is there anyone who has questions? Either here or in Zoom, on Zoom?
Philip has a question.
Philip has a question, please.
Thanks. Two very inspiring presentations here. So to carry maybe real quick, I saw on your 2x2 box that the lower right corner, if I was not mistaken, probably was macro ends, that's liability, basically, right? And so it bears note, perhaps, that the EU and other countries as well, of course, have not only some kind of procedural frameworks, such as the AI Act, but also very robust product liability framework. The US, of course, is one of the forerunners in this domain. The EU has just updated, is actually updating jointly with the AI Act, its liability system. I'm currently writing a report for the European Parliament to see if we need something more than that, but already the product liability directive now includes software and AI. So I'm wondering if similar to the theories about public and private enforcement, where you have lots of theories about the pros and cons of each of them, oftentimes it's a mixed approach that perhaps works best. If you would say that for AI, that could also be ultimately a winning strategy, combining management-based regulation with liability. In fact, a number of colleagues that I've talked to in the past, and also practitioners, tend to favor the liability regime, of course, because it's less intrusive, gives more space and liberty to companies to experiment and just avoid harm in the end. So what's your take on these mixed strategies, as it were?
Excellent question. And you've said it, actually, the case for the mixed strategy very well. And in fact, we see that even in other areas of risky technologies, that there really isn't just a single approach taken. There are, often backstop ex post liability regimes in place. And there's also, by the way, for some particular types of best practices, some micro means that are thrown in, and where there are possible outcomes that can be measured, some micro ends as well. So I don't want to imply that there will be, even in the AI space, an exclusively management-based approach. In fact, where management-based regulation tends to work is combined with a liability approach. If a chemical facility explodes, there is liability to the for the harm that inflicts to neighbors or workers or the like. But the problem is with liability is it's incomplete. It's, first of all, it's ex post, and we know that from behavioral economics that humans are often harder at sort of internalizing effects that might be into the future. And so how a future incident might in some future litigation come back and affect a business is going to have a little bit of muting of its behavioral effects for that reason. Other factors can mute the behavioral effects too, whether it's insurance coverage or bankruptcy protection too. So liability by itself can't be probably the answer for AI governance. In the same way, it's probably not the answer in any regulatory realm. And by the way, it only kicks in when the boom has happened, right? What we'd like to do is govern prospectively to try to prevent problems from happening in the first place. And so that's why I focused here on the management-based approach, which is a common element in high-hazard industries, but it's not, as you say, an exclusive approach, and it is mixed to begin with. Absolutely.
Thanks. Thank you so much, Carrie. I couldn't agree more. Maybe before we adjourn, I'd just like to, with a request for a very brief answer, maybe one question for Alex. You have such an impressive data set on Brazil, so many millions of cases, Have you thought about bringing your system and expertise to other countries with open judiciary systems where court cases can be easily, downloaded? And I know that there is lots of problems with respect to not only language-wise, but in many countries we don't have these open judgment policies.
So, Philip, I'm seeing, for example, in the healthcare sectors that Europe is training on US data, for example. So I think, of course, we have this regionality and different systems of law, but I think we build a way to construct the system. So we have a lot of pressure to collaborate, not just to bring the technology, of course. I'm here with friends from UK. We are trying to bring their tools to Brazil. They are working with LLMs to address this internal and sectorial standards into companies, and we're collaborating with a lot of tech companies and also with the public sector. So, I am a professor too. I'm working with it, and we are here trying to help and to bring our knowledge and what we learn. And of course, we are very pleased to collaborate with tech companies here in Europe and also the public sector, bringing this history, this gains, and this knowledge that we achieve. But just to finish, I have a quickly question for you too, because I'm always looking at how to build tools to address the regulation. So we are now looking all those frameworks. We have ICO, we have NIST, we have thousands of frameworks. So, but we can see a common points. Look at which kind of data, which kind of technology, the ways of variables, the outcomes, and so on. So how can we address, because the private sector is trying to understand, okay, I want to have transparency and explainability and auditability, but what is it? What do I have to do? You know, so how can you see the AI office or other regulation bodies solving this problem for the market?
Yeah, thanks. We had Sabrina from the AI office before. She actually had to go back to work because they're very busy drafting precisely these guidelines, I'd say, well, hopefully. And that's one thing. We're also waiting for the technical standardization, of course, from standard setting organizations. Last time I spoke with Sebastian Hallensleben, who chairs the JTC 2021 committee at Sensenelec, who are actually precisely drafting those standards. He said spring 2026, they will be available. So it leaves companies with about half a year or less to implement them until the AI fully kicks in. In fact, GPAI providers need to comply even before, but there we have codes of conduct that, again, the AI office is drafting, and they have started working on this right now, which is really the reason that Sabrina cannot be with us right now. She's going to rejoin us for dinner, I hope. So yeah, but there is this time lag. It's undeniable, and I think you probably have a similar problem in the US, Carrie.
Absolutely. There's, you know, the NIST framework is stated in a pretty generalized language, but people have to internalize and make it their own. I think this is, again, one of the reasons why I come back to it's not going to be, the future is not going to, of AI governance is not going to be specified with some fixed, rigid rules. But we really have to make sure that people are managing these systems, their design, their deployment, and their use in responsible ways. So it's guardians at the end of the day more than guardrails.
Thank you. Great.
All right, so we will have a 5-minute break now, and yeah, see you back at 6:06.
Hello, everyone. Thank you all for sticking around for the last bit of our workshop today. Well, we've had the honor of having him chair for the whole day. I'm very fortunate to be able to formally introduce Professor Philip Hacker, our very own co-chair of RECSAI. Philip holds the research chair for law and ethics of the Digital Society at the European New School of Digital Studies at the European University Viadrina, Frankfurt. His research focuses on the intersection of law and technology. In particular, he analyzes the impact of tracking technologies, AI, and the Internet of Things on consumer, privacy, and anti-discrimination law. He often cooperates with computer scientists and mathematicians, especially on questions of explainable AI and algorithmic fairness. With that, I'll leave it to him for his presentation.
Oh, thanks so much, Swarth, for the kind introduction, and thanks for chairing. That's wonderful. I'm going to try to be quick and talk as fast as possible, as I usually do. So jumping through a couple of hoops here when talking about something that I think is of increasing relevance, but still a little bit underappreciated in the AI policy context, and that is sustainable AI and its relation to international regulation. So I'm going to try, or I was thinking before we were running 1 hour late, to structure this in 3 different steps. First, talking a little bit about international AI regulation more generally, how can this be usefully implemented? Then taking a look at sustainable AI, where are we at and what are the challenges? And then finally trying to wrap up and get these 2 different strands together by focusing on international sustainable AI regulation. What I think I'm going to do is I'm probably going to jump through these first couple of slides in international AI regulation rather quickly, because I assume that some of this might be known to many folks around here, and also if you want to, you're welcome to ask some questions later on, and then I'm going to focus a little bit more on sustainable AI and sustainable AI regulation. All right, international AI regulation, nonetheless, is of course something we should at least once explore in just a little bit of detail while being at the UN. So
I was wondering, before actually the UN high-level advisory body on AI published its interim report, what use might be made of an international agency, if you had any kind of regulatory agency or any kind of agency in the international space, and its contribution to the AI sphere. And I've recently been at a deep dive with a couple of members from the AI advisory body. And I must say that the interim report matches some of these thoughts rather well and others less so. So I think that generally it's not a bad idea to have to structure this into what I would call probably information, collaboration, and legislation. So the first one is publishing and gathering information. And why this? We have, of course, the IPCC and the reports for climate, and the International Panel for Climate Change. And I think what we're witnessing at the moment in AI is an extreme acceleration of science and papers. There's just a flood of papers out there on arXiv, that most of which are non-peer-reviewed as for now. And I think particularly when we look at AI safety and some of the challenges that we're seeing in, post-training mechanisms, things that Marshall kindly mentioned in the beginning of this workshop, there is a dearth, I think, of really trustworthy information that can inform policy leaders and industry about where we are at, which risks are really valuable and have also materialized to a certain extent already, and which ones are rather hypothetical, but nonetheless non-negligible. There is, for example, a new report that came out just for the AI safety, not called Safety of the AI Summit, now it's called, in Seoul just last week, that was lead authored by a fellow German scholar, Daniel Privitera, and those are the kinds of things that I think really can help drive public discourse, and having some kind of framework for reviewing this and for publishing trustworthy information on it might actually be worthwhile. Now, certainly we don't only need more and better structured information about the AI benefits and risks, but also we now have an abundance of regulatory bodies, both at the EU level and internationally. And we've seen this in the talk very vividly, of course, by Kaitsena and Sabrina from the AI office, that it's not only at the European level, but at member states level. We have interactions between all of these different regulators, both the specifically dedicated AI agencies and then the sectoral regulators. So it's a dazzling array, really, of different bodies that are coming together to look at this AI phenomenon worldwide. And here, what I think about is something akin to basically the new EU AI board. That will be a body where representatives of individual member states will send people to coordinate on enforcement strategies, priorities, and problems. And we could have something like this at the international level, so that, in fact, regulators can agree on some best practices, see where the common problems are, pain points, also engage in some kind of, a division of labor, since Italy, for example, has been for various reasons very prominent in enforcing the GDPR vis-a-vis OpenAI. Then other people can do different tasks, and also trying to avoid, of course, conflicting judgments and enforcement priorities. And finally, there is this question of whether there can actually ever be kind of a global AI compact. The UN has now unveiled the first draft of the Global Digital Compact, and it has in it a few chapters on very vague principles actually concerning AI regulation. But what I find interesting here is a parallel that has been mentioned before also in this context, that is the ICAO, the International Civil Aviation Organization, which basically says, if you want to land your plane in the EU, you need to have some minimum standards at home. It's not enough for you to comply with our laws. You need to have some minimum standards in your place as well. So that's the reason why, barring sanctions and so on, Russian planes can land in the EU and vice versa. I think it would be interesting to think about such a regime in the AI space, whereby now we have extraterritorial applicability. So that means that if US companies actually want to, and other international companies want to offer their products in the EU, they have to comply with the AI Act. But it does not mean that there needs to be minimum, standards in the US itself. And it's unclear whether such a mutual conditional recognition mechanism would ever work, but at least for some sectors of, AI safety, which are agreed upon by a wide array of scientists, and where President Biden, for example, has issued the executive order, there might be some room for covering at least some of the core risks in a minimum regulatory framework globally. So those could be some of the contents of such an AI pact. I'm not going to go through this in detail. It's very clear that the AI Act itself will not be sold across the globe. Many countries are very hesitant, and rightly so, in just copy-pasting the AI Act. But I think one feature deserves greater scrutiny, and that is something that is actually probably beyond the AI Act, and that is precisely sustainable AI. And that's, I think, where international regulation can really kick in and make a difference. Why this? I think that the question of climate impacts of ICT, so information and communication technology more broadly, and AI more specifically, is really one of the next frontiers, both in computer science, where we have a growing community dealing with it, and in regulation. Of course, many great things can be done with AI, but the question that is still a little bit unanswered, where we have growing evidence, is the contribution of these technologies to climate change. Why this? There is a significant effect that ICT more generally, and AI specifically, have on greenhouse gas emissions. And if you look at the statistics, it's actually quite troubling. So you can find, for example, estimates, and those are probably on the lower bounds, of 1.8% up to 3.9% of ICT technology contributing to greenhouse gas emissions globally. And you might say, oh, that's not so much, it's even less than 4%, come on. And I agree. I mean, there's others like transport and housing that are much, much greater obstacles. But if you look at air travel is 2.5%. And, that's in the middle of the policy debate. We all wonder if we should fly here or there, or zoom in, and so on and so forth. And actually, ICT is most likely has already surpassed this. And if you look at the curve, it's just going extremely straight upwards. In fact, there are estimates that show that if we have a median adoption of AI in the search space, which is something that Google is now introducing with these AI overviews, for example, if we have a median adoption there, then by 2027, we'll have GHG emissions to the in the extent of countries like Argentina or the Netherlands, just for AI. And that is not only, as Sasha Lucioni and her people at Hugging Face have recently shown, not only in training, but actually inference is increasingly taking over. So this is one thing that I tell my kids, because we sometimes play around with, various Gen AI tools, and they always want the pictures, right? And now let's generate a picture for the story, and I'm telling them, well, yes, we can do that, but you have to remember, if you generate one picture with a high resolution image generator, it takes as much energy as a full charge of a smartphone. And so with the amount of images that are generated just for fun, like me with my kids, that's just a lot of energy that goes basically into nowhere. And that is, I think, a regulatory problem. Now, of course, AI can be used to mitigate climate change as well. There's loads of studies about that. But the problem is that much of the energy consumption comes from large models, large language models, and there's quite little research and few use cases that would show that actually LLMs are used in this space. So you can use a lot of computer vision to look at deforestation and so on, but that's mostly traditional AI, at least the use cases that I know of, and not so much LLMs. So this is something that increasingly now gets picked up by the media. There was a report in the New York Times that shows that in the US, actually, you can see here the curve, there was a rising energy electricity demand in the last couple of, actually since 1980s, up until 2007 about, then it went flat. And now it's sharply rising again. And why? Well, at least to a great extent because of the data centers that are being built and where you need just quite substantial energy consumption and water consumption, in fact. So there's another article from The Atlantic where Karen Heo looked at data centers in Arizona in the desert. You might know that Las Vegas, of course, is already running out of water. So now they're competing with the data centers. And by all means and purposes, they're losing out because actually Microsoft and other companies, they just throwing more resources at it in terms of, they can just buy their rights into the waterway. So I'm not saying that we should stop AI development for this, but this is just a factor that we need to factor into the equation and look at more than just, performance metrics and fairness metrics. But I think sustainability has to become part and parcel of any ethical AI framework. The problem is that if you look at regulation, it's really quite a blind spot. Okay, so at the moment, we have very few things that tackle this problem, which if you look at other areas, in high energy industry, you have very clear regulations and standards on energy and water consumption. And this is not the case for AI. In fact, we've seen that there is this energy problem, there's a water problem, there's also a toxic materials problem. And in the EU, for example, we have the emissions trading system, and we have the WFD. Everybody knows what that is, right? The WFD, you all know that that's the Water Framework Directive, exactly, an exciting piece of legislation from the EU legislator. And you could argue that the EU Water Framework Directive does cover water consumed by data centers, at least to some extent, because you have water quality frameworks and water quantity as part of water quality in some areas. But in the emissions trading system, very clearly, it covers traditional high emission sectors, such as, transport, airplanes, steel, but the modern ones, nope, hasn't been updated. So there's really quite a gap. I'm not saying that we should immediately jump to the conclusion that all of this needs to be, regulated like all over the place with, emissions trading, but we can start thinking about it, as I'll suggest toward the end. And now you might say, okay, so this is a new problem, but it has been known for a few years, and now comes the EU AI Act. Maybe the AI Act says something about it, right? Because they surely must have been aware of this problem. Now, I tried to raise awareness for this, but actually not to so much avail. Or, as we shall see, maybe there is something in disguise in there. So the AI Act has two main requirements concerning sustainability. First one is energy consumption needs to be disclosed. And that's, of course, important because that allows market participants to factor this into the equation, and you can start building better models if you know which models consume what. It's a little difficult to do sometimes. I'm actually starting a project with people from the Hasso-Plattner Institute, from computer science faculty near Berlin, to look at this from a more technical standpoint. But then we have the risk management framework that we've heard about a number of times already, and that is basically part of this management-based approach that Carrie was just talking about. And basically, you now know that both providers of high-risk models and those who are providing high-powered, let's say, general-purpose AI models, such as GPT-4, are required to assess and mitigate risks to fundamental rights. And you might say, okay, what do fundamental rights have to do with environmental protection? Because as I once learned from Nora, we talked about Laura before. And, okay, as I learned from Nora the other day, environmental protection is mentioned in the charter, but it's not a fundamental right. It is only a principle. However, this is something that the drafters of the AI Act were oblivious of. So they actually, in the recital, say that the AI Act is supposed to protect fundamental rights, such as environmental protection and so on and so forth. So basically, in a doctrinally absolutely outrageously wrong way. They're equating fundamental rights and environmental protection, but that means that you have this Trojan horse basically in the AI Act, because at some moment there was an environmental impact assessment that was written into the AI Act whereby the risk assessment would specifically have to include environmental parameters. That was taken out in the negotiations because of political concerns. But it turns out that actually they managed to bring it back in because they wrongly declared environmental protection to be a fundamental right. And so I think that there is only one conclusion, means that we now do have this basically environmental impact assessment or sustainability impact assessment in disguise as part of a fundamental rights impact assessment. So that's kind of interesting because there's many industry initiatives underway. Of course, industry has quite a strong interest in bringing down energy costs too, because it's just very expensive. But at the end of the day, there's many other rivaling priorities, such as performance, such as sometimes fairness, accuracy, and so on. And this is one lever now to say, you know, particularly in those high-risk areas and for general purpose models, foundation models, this is actually something that is mandated by the law, and where the regulator, the AI office, can come in, do some standardization and actually look whether this is done correctly. So what does this have to do with international AI regulation then? And those are my final remarks. There's two things I think we can be aware of. So the first one is, what about emissions limits? Of course, companies have an interest in reducing GHG emissions, particularly through electricity, because it's just very costly. There's a huge energy bill. In fact, the professor that I'm teaming up at Hasso-Plattner Institute, his research focuses on sustainable AI, and he used to be one of the heads of machine learning at Amazon. And when he was at Amazon, actually, he looked at the bills, the energy bills that came in. He had to sign off on them. And he said he was basically thrown off his chair. And that's when he started, you know, harboring an interest or nurturing an interest in sustainability questions here. And so since ICT emissions now are comparable to aviation, for example, is part of the emissions trading regime, the question is, why is AI not, or at least data centers, you know? And this is, I think, a legitimate question to ask. We still have to find ways to make sure that this, you know, would be rolled out in a way that doesn't harm unduly SMEs, research, and so on. But I think it's a legitimate question to ask to what extent the overall GHG targets can be met, because at the moment, there is a race on the one hand to smaller models, but on the other hand, still to upscaling ever larger models, GPT-5, potentially 6. And this performance-driven quest is somehow offsetting some of the incentives to actually reduce GHG emissions. And the advantage with an emissions trading regime is that you have an overall cap. So to make sure that you're not going beyond a certain limit. And we could, for example, say that cap is smaller for something, for an AI model for, say, entertainment that's, you know, good at solving computer games and where people can play whatever, some funny war games in a smarter way, whilst medical AI gets a much, much larger share because, you know, the societal benefit is just much greater. So that's one point of reflection. And the other one is, I think this is one area where actually international regulation can make a difference. How? Well, first of all, it's an international endeavor to get more research funded internationally to actually measure this, because it's very hard, people from machine learning tell me, to actually measure the exact consumption of the model vis-a-vis the system. So of course you have a whole system, you can model, you know, what goes into the system, what comes out of the system in terms of energy, water, and so on. But the specific amount that is driven by the model itself and by different model varieties is apparently quite hard to measure. So this is something that where standardization hasn't really come forward so much. And this was also one of the reasons actually why it was thrashed during the AI Act negotiations, as I heard, because there's just no hard metrics at the moment to measure it. So this is something we have to come up with, and perhaps I'm wrong, and perhaps other people have other suggestions, but I'd love to hear about it. And then I think once we are working on these standards and can look at some ways to measure this, and there's approximations, of course, through just the amount of compute that goes into a model and that goes into inference, then we can have these standards, and a global AI compact, or the Global Digital Compact, the AI chapter of the Global Digital Compact, could refer to those standards. And the idea would then be, or could be, similar to the Paris Climate Agreement, that individual countries could adopt this framework or opt into it, and by this make these standards mandatory to a certain extent, to the extent that they'd like. And you could basically have an opt-in regime where internationally we have these standards that try to operationalize the otherwise very vague principles that we have in international regulation. So basically a similar regime as the one to the AI Act, but with, of course, on the global level, voluntary adhesion as we have it in international law. That could be a model, I think, where international law actually goes beyond what we have currently in the AI Act and in other frameworks across the globe. I could say a little bit more later on about why this could potentially be something that countries could sign on to, but there's certainly a distinct measure of hope and optimism in this that might not be borne out by international negotiations. So to conclude, I just want to say the future is certainly going to be exciting, both technically and on the regulation front. Thank you so much for listening in, and very much looking forward to your questions after, of course, Laura's brilliant talk.
Every other question, just press the big button. So just while we're waiting for slides to be loaded up, I have the very unenviable position of being the last speaker of a really fantastic workshop and panel today, and also to be the one person standing between you, the end of the day, and dinner. So it's a healthy amount of pressure. And I've decided then that what we need to do is talk about something completely different, the EU AI Act. But don't worry, we are actually focusing on a different aspect of the Act that we haven't focused on yet today, which is the context of AI-based biometric systems being used by the government, law enforcement, also in certain contexts, national security. So that is the focus. There's been quite a bit of criticism of the AI Act today. Kicked off very nicely by Jeremiah in the morning and consistently followed on. We're going to do things a little bit differently now by talking about some of the achievements in the EU AI Act within the very specific context of remote AI-based mass biometrics surveillance that can be used by competent authorities in member states. Now, when this was first introduced, when the AI Act was proposed in 2021, it was falling under the category of one of the high-risk AI systems categories. Now that we've finished up in 2024 with the official text of the Act to be published any day now, it is still in the high-risk category of AI systems. However, there was a significant push by the European Parliament and also by the European Data Protection Board and the European Data Protection Supervisor, the data protection watchdogs of the EU, that it should also be put in the prohibited list of categories. Now, because political tension between these various EU institutions, the Council and member states, what we now have are actually quite a significant set of safeguards and oversight in the EU AI Act for these powers that we wouldn't have had for these AI-based systems before. So much of this has already been said in terms of the context of the AI Act, that there's this expectation that the AI Act could take the role also of the GDPR in terms of the Brussels effect. And I take the point also recently made by Philip, is it? Yeah, Philip, that we may not have a Brussels effect on our hands now because other countries outside of the EU could be quite wary of copying and pasting the legislation. Having said that, the Brussels effect, as Anu Bradford has interpreted it, as the fantastic paper that she's done, is that it's not just that we have a copy and paste of EU standards and laws for the GDPR, it's that it's influenced the policy debates around data protection and around data privacy and around the use of AI-based systems in jurisdictions around the world. So if there isn't an adoption of some of the safeguards and the elements, there's certainly then a reaction to what is not going to be adopted. And this is very significant. So where do we stand now? Well, as I just mentioned, we are expecting the official text of the Act to be published any moment now, which is very exciting because then many of us can finish a number of papers that we've been working on for the past few years now that we have the exact text and not just lots of very exciting but leaked copies. So as everyone has already mentioned, the EU AI Act, it's very lengthy, it's very complex. I'm sure all of you are familiar with it now. This talk, we focus much more specifically on the prohibited AI practices and on the high-risk AI systems. I make some of the references here to additions that have happened between 2021 and 2024. We're all very aware of the additions of generative AI and the general purpose AI models that were not in the original proposal. But back in 2021, there were very serious criticisms of the proposal and the fact that it also had a blind spot in terms of its human rights safeguards or the lack thereof. And this was a case that was made quite vehemently by the EU data protection watchdogs, that basically the EU legislature, by putting forward this proposal, just wasn't striking the right balance in terms of having a framework, as was raised earlier on this morning by Jeremias and others, of EU product safety regulation, consumer protection law, and then an afterthought of fundamental rights protection, and an afterthought by saying, well, this legal framework will also complement existing relevant frameworks such as the GDPR, the lesser known law enforcement directive, the sector-specific part of EU data protection law and law enforcement. But how exactly those are going to complement and interact with each other is an area that we're going to have to see play out over the next few years. But what we do have are improvements over the legislative scrutiny of the AI Act from a human rights, from a fundamental rights perspective. So in the material scope of the AI Act, you have a focus now that we didn't before on the fact that there should be a human-centric and trustworthy approach. There should be the protection of health, safety, and fundamental rights as enshrined in the Charter. And there is definitely some very interesting broad interpretation for scope there for environmental protection. Philip is absolutely right. So watch this space. And also a reference to harmful effects being prevented by the EU AI Act. So we've got a much broader set of safeguards and protection than we originally started off with. But what about these red lines that were drawn? I mean, this is also very significant. This is going beyond the proportionality test that we usually have and well established in European human rights law, where there are outright prohibitions on certain AI practices. It's very difficult to find an image that conveys brainwashing. So I recommend you all watch The Manchurian Candidate, both actually the 1960s version with Frank Sinatra, but then also this more recent version. But essentially, these are AI-based systems, which would also include generative AI systems, particularly when we think about going beyond the systems we currently have, AI digital assistants, these digital twins, and thinking about the AI-based immersive systems we're soon going to be surrounded by. Think about augmented reality, think about virtual worlds, for instance. These are the sorts of spaces in law enforcement and national security that are going to be used more frequently in terms of gathering evidence and also possibly investigative techniques. So we have an outright prohibition here about subliminal techniques beyond a person's consciousness that would cause them to take a decision they otherwise wouldn't have taken, to cause harm to them or others. Very significant to note, as I'll emphasize at the end, that the material scope of the EU AI Act excludes any use of its application to any entity that uses a system for the purposes of national security. this is a very, very sweeping carve out. So when you look at prohibitions like this, you should remember that the EU AI Act does not apply this to the national security purposes within member states. Another prohibition of certain AI practices, although technically it's a qualified ban if it's going to be used for law enforcement, is biometric categorization of individuals based on their biometric data. But it doesn't apply to labeling or filtering when we have lawfully acquired biometric data sets, so not unlawfully scraped, for instance, in a law enforcement context. So this applies also to historical facial recognition that happens more commonly online right now than real time does. But of course, this is just a matter of time before they both converge. We have a prohibition of other certain AI practices, as I mentioned, untargeted scraping in terms of facial images. We have emotion recognition in the workplace and educational institutions, but there's a qualified ban for this if we have medical or safety reasons that are the purpose. And we have additional qualifications. We have an exception for if it's going to be used for policing or border control or immigration, or for any matters of national security, for instance. So emotion recognition in particular is quite problematic from the human rights perspective because, and this goes back again to a lack of evidence-based or evidence-informed policymaking that Philip referenced, in that we don't have robust evidence supporting the accuracy of emotion recognition monitoring systems, and yet they'll still be permitted under the EU AI Act. And again, here we have a prohibition on what is effectively AI-based profiling, but this is a qualified ban again if it's going to be used within the context of law enforcement. And this goes back to the point raised earlier on as well by Kai Zenner, that while it's very useful that we have some red lines, these red lines are more like pink lines in terms of how blurred they are for qualifications when it comes to national security and law enforcement. What is very striking, though, in terms of looking at the achievements for human rights, fundamental rights protection, is that because of the tension that you had between what category emotion recognition and live facial recognition in terms of mass biometric systems would fall under, you do have a number of safeguards now that are in the EU AI Act that we otherwise didn't have originally. We also have more technically specific definitions of biometric systems. So under the GDPR, we have a definition that focuses just on biometrics, but under the EU AI Act, we have a distinction between biometric verification and then biometric recognition. Biometric recognition is much more intrusive in terms of the fact that it's collating sensitive data in different places, whereas verification is less intrusive. So it's interesting and welcome to see an evolution of the law, which is aligning more with technical uses of biometric systems. Having said that, another drawback in the legislation is that we've had such a huge focus on one particular type of AI-based biometric recognition systems, which is those in real time, used en masse in public spaces. We've had less of a focus on the safeguards about historical facial recognition, which is used very frequently and which can be used much more powerfully in future in terms of collating group profiles and also tracking people's internet usage and, of course, their groups and networks. What is also welcome, however, about biometric systems under the EU AI Act is that it doesn't just focus on facial recognition, for instance, or verification. It encompasses voice analysis, gait analysis, iris analysis, and other emerging technologies. So it's good to see some future proofing here in terms of the biometric systems. There's also a reference as well in the recitals to the different types of devices that we'll be dealing with in future. These are Ray-Ban smart glasses, but there are Google smart glasses and others I'm sure are available. But again, like I said, it's very good to see this thought around future proofing, particularly in terms of the virtual environments that I mentioned earlier on and the ease and collection of biometric data in future. So in terms of the qualified ban for law enforcement, this comes under Article 5, and it's actually a lot more narrow than we see in the legal frameworks of other states. in EU member states, in that we don't have explicit bans on this type of biometric system. I know. It is better than a fire alarm. Okay, we're almost there, everybody. Sounding more and more appealing. So very quickly, so now we have a targeted search for particular purposes that we didn't have previously under the 2021 proposal in terms of specific, substantial, imminent threats to life, physical safety of natural persons, genuine, present, and genuine foreseeable threats in terms of terrorist attacks. Why is this significant? Well, we also have itemized criminal offenses. This is much more detailed and much more prescriptive than what we had in 2021 under one of the annexes. And here's the next page of the limited criminal offenses. But why this is significant is that we actually have limits on those more serious criminal offenses previously under the 2021 proposal in Article 5. These sorts of AI-based en masse indiscriminate biometric systems could have been used for the scope of targeted search for specific potential victims of crime, including missing children. So can anyone tell me who is a specific potential victim of crime? Yes, absolutely. Well, we're all, aren't we, specific potential victims of crime? So we've gone from a very questionable, disproportionate, all-encompassing scope to something that is much more narrow and much more in line with the necessity and proportionality principles under EU law and under the European Convention of Human Rights. So that's very welcome. We've also seen added safeguards in terms of ex post pre-authorization and oversight. We've seen the addition of the fundamental rights impact assessment, which we previously didn't have. We also have additional transparency requirements under the publicly accessible EU database of all of the provisions under the AI Act. I'm quite excited about this particular one. Of course, because we're talking about systems that are going to be used for law enforcement, there will be some qualifications as to who can access data on those particular systems, but they will be there, and they will be there for regulators as well, and they'll be there too for the evaluation and review of the EU AI Act, which is something we don't do enough of in terms of actually assessing the impact of laws dealing with any data-driven systems. For the fundamental rights impact assessments, these are going to have to be undertaken by deployers. This is also something that's quite welcome in terms of law enforcement authorities having to provide summaries of these systems. So we know they exist and they're in use. These sorts of registers are going to be very useful in terms of mapping the use of these types of different very powerful AI systems. The information on the database must also be kept up to date. And obviously, like I said before, there are some restrictions in terms of the nature of law enforcement, how we can't have absolute access to how all the systems operate, but they will still be there in terms of accessibility for oversight and for the annual report of the European Commission, which will be very interesting to see in terms of their overall use and for measuring proportionality in future. There's also additional safeguards in terms of a reason to request that needs to be submitted before their use in terms of remote, en masse, discriminate AI-based systems. And there are stricter safeguards in terms of the fact that, well, if it is a genuine emergency, then the data protection authorities or whoever is appointed will have to be notified 24 hours afterwards. So these are all quite significant safeguards that have been added that we did not have before under the 2021 proposal. Okay, so these were some of the achievements. I'm going to be a bit more critical now when we talk about the fact that we still have emotion recognition falling under the high-risk AI category. This is particularly problematic in terms of its proportionality because of the lack of any robust accuracy and evidence that shows regarding the utility of these systems. And I mean, very much boils down to the fact that this is a highly subjective metric for public authorities to be assessing in order to be extracting any significant decision-making processes from. And just remember, it's not just individuals that we're assessing these decisions, it's also going to be various different AI systems that are assisting in helping to make these decisions. And even the AI Act itself in its recitals refers to serious concerns about the scientific basis of these AI systems. So it's rather worrying that they still continue to exist as a high-risk system, and it'll be interesting to see how the Court of Justice approaches them in future. Also outstanding concerns, as I previously mentioned, we have significant carve-outs for national security. Any public authority that cites national security as the lawful basis for which it can use any of these prohibited AI systems will be permitted. And there's something categorically, fundamentally wrong about the fact that we have increasingly more powerful AI-based systems in terms of generative AI and biometric indiscriminate general monitoring systems that can be used within the realm of national security, but won't be subject to any of these safeguards. And there have been some concerns raised that these will enable the development of these systems, and we're relying an awful lot on member states to be implementing the sufficient safeguards to be placing those restrictions in place, but we'll have to wait and see how that turns out. Another very significant concern in terms of oversight, which several commentators, including myself, raised concerns about back in 2021, is that the oversight authorities, when they're reviewing authorization as to whether or not these remote biometric monitoring systems can be used, is that they have to take into account the scale of the harm and probability caused in the absence of the system not being used. So this is a rather striking coercive element, which very much undermines the operational and functional independence of oversight bodies, which is very much a fundamental safeguard enshrined by both the EU legal order and the ECHR. So it's very troubling that that still persists in the legislation, even 3 years afterwards. It's very welcome to see these safeguards on paper, but what we're going to have to very closely monitor is how this law gets implemented in practice. Will it get implemented in a way where we'll have perpetual use of these indiscriminate and general biometric systems consistently at public protests? Is that how it's going to be interpreted? If it is, we're going to have to take on board the fact that the burden will fall to other stakeholders then to push back more against the use of these systems, such as civil societies, Rachel Adams raised earlier on. We also have the question about an ongoing blind spot for the fact that we have far weaker safeguards in the EU AI Act for historical facial recognition and monitoring than we do real time, when actually in practice, what happens is law enforcement authorities will use both. They'll combine both in investigations. So it makes no sense why one moment of you being captured at a park or a concert will give you far more greater safeguards and protection than 6 months of your internet usage and CCTV surveillance over, well, not even 6 months, it could be longer than that. So in terms of the privacy intrusion, it lacks a lot of consistency. So just to summarize, we do now have stricter rules for police use of these systems. We have the requirement of prior authorization. We have more specifically defined types of serious crime, unlike, for instance, the metric of a person of interest, which is what we have in the UK. So just to bring up that Brexit issue one more time. We also do now have, under the EU AI Act, the requirement of fundamental rights impact assessments. We have the EU database. So we have both national and also E-level measures of transparency and accountability in this space that we didn't have previously. Thank you very much, everybody.
We'll take any questions at this moment.
Please keep interventions to 5 minutes minimum per person.
Okay, so I have two questions. The first one is for Philip. So sometimes the law requires us to do things in relation to models that worsen their environmental footprint, right? So think, for instance, of the right to be forgotten. You can't really implement this other than retraining the model, which of course is bad for the environment. You know, arguably fairness requires you to use more data and train more. So again, bad for the environment, right? Yet, for instance, in data protection law, I think there's currently no scope to sort of weigh these two concerns, right? The exercise of individual right and the societal interest in not sort of increasing the environmental footprint of a model. So I'd be curious what your take is on whether the law should accommodate for a weighing of those two different goals, and if yes, then how could this be implemented in the legal frameworks that we currently have? And then my second question, I guess, goes to both of you. So, Philip, drew attention to the fact that Article 1, Paragraph 1 of the AI Act refers to, you know, the protection of rights, including environmental protection. And I find this super perplexing from a constitutional and hierarchy of norms perspective, right? Because I think arguably you can't read a right into a principle because there was no intent on behalf of the drafters of the treaties or of the charter to create a right, right? So I wonder then, where does this leave us, right? I mean, is this misinterpretation of the charter, I guess, is what it is. Is that potentially a ground for annulment? What are there any, you know, are there any sort of like constitutional or political consequences that could derive from this? I guess practically speaking, not, but from a theoretical perspective or purely legal perspective, I'm just wondering what your takes on this are. Thanks.
I've got 6 points and 5 questions, so that should nicely get us to 8 p.m. Well, actually, Michelle's already made my constitutional question for Philip, right? Which is that in terms of the hierarchy of norms, I think it just doesn't work to have primary level treaty instruments like the Charter saying it's not a right, and then a secondary instrument suddenly elevating to a right. That just doesn't work under the hierarchy of norms. I think that's pretty straightforward. Exactly right, and then it goes back to the question of so it's a huge mess for the Court of Justice to sort out when the Court of Justice probably doesn't. Well, I don't know. Kuhn Dennis is probably keen on making everything right these days, but who knows? But so I think that's the first constitutional point, right? Can we actually use secondary legislation to turn the treaties on their heads? The second question is a version of the question I was asked earlier today, which is about what's specific about regulating energy use in the AI context or the generative model context, as opposed to the energy creation in the first place, right? Because you could say, well, actually, I'm a French startup and I use nice, clean nuclear energy that's essentially unlimited in France. And so therefore, why should I be regulated by this when, you know, this German startup is using dirty, you know, brown coal energy to do their work, right? So this sort of upstream, downstream question. And Nora, the question for you is more one of the sort of institutional dynamics we've been seeing during these negotiations, right? Where it's very obvious that in council, the people who sit in council are the people who are the executives and who want to have as much of these powers as possible. Whereas we're seeing the parliament sort of more doing its job of actually representing the citizens, saying, well, easy there, we don't want to have those kind of rights. So I think just maybe if you could tell us a bit more about those institutional dynamics, I think that would be really interesting as well.
Yes, sorry. It's a very small question and a comment. First, a comment regarding the possibility of having an international regulation on AI. The example of air transport, it's easier to understand because the market is defined as a point-to-point market. So whatever goes from one place to the other is the same. So it is easy to have different countries accepting that. More interesting might be the rules on finance and rules for banks. And those are slightly different. And at the end of the day, people accept them because they have that huge monster, which is the systemic risk. As an economist, I don't understand it, but anyway. But anyway, people are afraid of it and they accept Basel principles. But as you know, we have been discussing the possibility of having an international regulator on banking and finance for 30 years, 40 years, and nobody ever managed to have an answer to that. The question is related to what was said. The thing is, difference for me, as someone that regulates, the difference between AI and everything else is that we are used to regulating linear linear markets. So something goes as a chain of progress, and it's easy to understand. AI and digital worlds mess with many perspectives. So you have a platform and everything is happening, and you need an infrastructure, you need software, and you can use it for many things. For instance, in Portugal, we have sandboxes for the application of AI to things like robots and drones. And it is interesting to see that in those sandboxes, you have different regulators. So you might have the regulator for energy and telecommunications and defense. You might have the regulator for energy, telecommunications, and I don't know, financial and insurance. So you might have different regulators depending on what is being looked at. This is to say that maybe I do understand the problem with energy. We do have practical examples, the price of energy in Ireland, the problem in Madrid with data centers. So we have practical examples that energy is an issue, but it's not only energy. So what I would say is that when we look at sandboxes and AI, probably we have to look at them not only as a space for technological experimentation, but also regulatory experimentation, and having many regulators working together to understand if they have to govern, regulate, and what they have to do. I'm sorry, it's more a comment than a question, sorry.
You want to go first?
I mean, sure, yeah, I'll go first. Drafting of the EU AI Act. And I'm sure I'm not the first to say that this perhaps isn't the most tightly drafted piece of EU legislation that you're ever going to come across. It was a very politically charged pre-legislative scrutiny phase, and there are references throughout the Act that contradict each other. And having said that, I would make the case that there are many pieces of legislation at the national, EU, and international level that will often have conflicting provisions, and particularly in the recitals when it comes to EU directives and regulations. They are the wish list of various different EU institutions and bodies. They don't always make sense. But I'd make 2 points on that front in terms of seeing the objectives, the policy objectives and priorities of EU institutions and bodies that don't make it to the legally binding articles of, say, the EU AI Act or even the annexes. You'd be a fool to dismiss everything that's in the recitals, because they can be used as a vehicle for enabling safeguards and rights and protections by the Court of Justice in preliminary references and any opinions that the European Parliament will refer to the court. So that would be my first point, that the recitals have become much more significant when we have an environment where we have a very judicially active court. I would also hasten to say that this too shall pass. We have a president of a Court of Justice right now who is very much an advocate of generous interpretations of the EU Charter, as Jeremiah's referenced earlier on, to put it mildly. But people should not always expect that every president of the court will be the same. I would remind everybody that the decade previously was known as the decade of surveillance of the court between 2000 and 2010, because it omitted engaging with fundamental rights issues and analysis before the court. And this is just something to bear in mind, that this is a temporal space that we're in. With regard to Article 1 and the reference to the conflict between secondary EU legislation and primary law, well, primary law takes precedent. It's hugely problematic that we have incorrect references to the EU Charter in the material scope of the AI Act. Having said that, because I'm very much an advocate of environmental rights, I would make the case that the protection of the environment is covered under Article 1 because of the protection of fundamental rights. And this is because of recent case law by the Strasbourg Court, which was based on Article 8, the right to respect for private life, family and home, which EU law under the Charter, under Article 52.3, has to guarantee as a minimum floor of rights. So there's your vehicle in. You don't have to rely on an explicit provision of the Charter when the Strasbourg Court has already started broadly interpreting Article 8 of the ECHR, which is Article 7 under the EU Charter, to encompass environmental considerations on a person's quality of life and their private life. So if I was an advocate making arguments in that direction in terms of international protection, that would be the route I would take.
I'm sorry, I have to say one thing. I'm an economist. I went to courts. I've been working with people from legal drafting for a long time. I'm part of a research group of legal drafting, and I'm amazed that you're amazed with this. This is so normal for me, and I'm an economist. This is so normal for me.
Do you mean bad drafting?
Sorry.
Do you mean bad drafting?
No.
No.
All the confusion that is created between the different parts of the test, if you
Right.
not well draft, primary law, secondary law. I've been listening about this for so long. I'm just amazed that you're amazed. So, yeah.
I mean,
it's so new for me, and I'm an economist. So, okay. So, this is normal.
I'm just to clarify, I'm not amazed that there was poor drafting of the EU AI Act, lest there be any confusion.
Sorry for
That's fine.
I would have been quite amazed if everything, was watertight in it. Now, I think that's a very interesting route that you're taking, Nora. And
Thanks, Philip.
Sure. 2 P's at the end, please. So the point being that this is also reflected in quite a bit of member state constitutional law jurisprudence, which is also, in some weird way, I guess, influencing constitutional law at the EU level. We had in Germany, for example, cases, and in other countries too, if I'm correctly informed, about fundamental rights such as the right to life or to, live whatever, to do whatever you want to and stuff, to being charged with or being infused by an understanding of climate change to the extent that climate change would prevent, so for example, younger people from leading a fulfilling life later on in their life. So that is one route you can take, just saying, we're just using other fundamental rights and infuse that with an environmental meaning. I have about zero knowledge of constitutional law, but I would just bring to bear one kind of instrument from the toolbox or trick box of the private lawyer, and that is falsa demonstratio non nocet. So basically what it's saying is you label it wrongly. They might have as well have said, it's not a fundamental right, it's, a piece of ice cream. It doesn't matter as long as the intent is just to say, look at this. This is part of what the risk assessment is supposed to be about. And I think at the end of the day, of course, secondary law cannot change primary law, no doubt about that. But I think looking at the secondary law, it would be a more correct construction of the telos of the norm to say that the legislator obviously wanted environmental protection to be somehow relevant in this risk assessment via the fundamental rights metric, and just chose the wrong words. It said it's fundamental right, it is not, but what matters is that there was an agreement about that being in. And so equally, if you order, a shark steak and the waiter brings you a shark steak, but it so turns out that this was actually not shark meat, but something else, but you thought that this was actually shark and it was a whale or something, and both agree that this is the right thing, they just labeled it wrongly as a shark piece of meat, then that doesn't matter in the end, the contract is still valid. And so similarly, I think we can say that if the legislators agreed that this is supposed to be in, it doesn't matter if they wrongly labeled it as fundamental rights. To be discussed later, perhaps over a glass of wine, but I think that there are multiple routes in making this relevant, the environmental protection framing of the AI Act. I'll say something more just very briefly about the GDPR, but you wanted to make a comment also on the financial framework.
Just a comment on the statement that was made about international banking and how we don't have an international regulator. I would just mention that we do have international standard setting bodies. So for example, the Financial Stability Board, which is utilized by the G20, for example, and also the Bretton Woods institutions, the International Monetary Fund and the World Bank, for example. And both of those items that I mentioned do have examples of incorporation of considerations around climate and artificial intelligence. And I think we are expecting continued extensive work streams on both of those topics. The other thing I would mention is I think we also have examples of success in international cooperation on the financial regulatory side in the area of anti-money laundering. So for example, we have the FATFA, which is the Financial Action Task Force, which both protects against anti-money laundering and enforces against it. And while our systems are not perfect, I think there are examples of countries working together to establish global standards and then cooperating for enforcement thereof.
Great. I'm just going to be very quick because I think we're by and large the last workshop running and everybody wants to see Her Royal Highness or whoever's talking now and grabbing the drinks. So as per the announcement that we just had via this funny Hal voice or whatever. Trade-offs. That's a great question. I try to answer some of this in my Sustainable AI regulation paper, and the gist of it, I think, is again boils down, but this way in the inverse direction, the difference between primary and secondary law. So the GDPR does not explicitly allow for a trade-off in the sense of, oh, this machine unlearning technique, right to be forgotten, is just so incredibly painful for the environment that we can't do it. But there are certain exceptions to the right to be forgotten in Article 17, I believe it's 3. And I think you can take from that a general principle that, you know, other fundamental rights need to be, or principles, need to be adjusted and accounted for. And in fact, that's what the court did in Google Spain, right? And I think that's the right way of balancing it, to look at it more broadly. And the GDPR cannot, I guess, hyper-focus on just a very limited set of exceptions to the right to be forgotten when actually it's a more general balancing test that needs to be undertaken. And last point about the energy question that Jeremiah has asked. Yeah, that's a great question. In the end, I think that one pragmatic approach that we're going to see is quota for data centers. This is something that renewable quotas, for example, this is something that is already being discussed at the European level. Actually, many of the, and this has upsides and downsides. The upside is, of course, this is an easy metric and many data centers are already switching to green energy. Downside is it's a problem for small operators because Google is already running all of its data centers, at least they say, on renewables, and other big data centers are too. But there is, for the moment, a finite amount of renewable energy, even though, and if you count, of course, nuclear energy amongst it, then it grows by quite a share. But it has its own sorts of problems, as we've seen. And so I think this might be a pragmatic approach in the end, but we may still want to limit the consumption overall so that some of the renewable energy is actually there for other players outside the AI space. In fact, Google is now trying to become carbon zero, zero carbon by 2030, and they're buying up all kinds of renewable energies. That's great that they're doing it, but makes it very much difficult for other companies really in the energy sector to actually just get renewable energy if they want to transition to carbon net neutrality as well. So I think we have to move beyond just the renewables quota, and some other measures might be needed, impact assessments, eventually perhaps some kind of light touch emissions trading system. But this will, I guess, be a motto or a topic for another workshop that we might convene within our RECSAI framework. For now, thank you so much for listening and for bearing with us for such a long time. It's great to be back in Geneva. We'll certainly not have been here for the last time. And you want to maybe wrap up in just 1 or 2 sentences,
I'd
Sarah?
like to thank my co-chair, Professor Philip Hacker, and all of our incredible speakers and all of the fantastic participants here today, and all of those watching online. And thank you also to the International Telecommunications Union and AI for Good, and to the Dieter Schwarz Foundation. Thank you also to Swarth and Johan for helping us make this day a great success. And we look forward to engaging in continued conversation on all these topics.